ಮಾಡಿದ್ದೀನಿ.
$2,000. It will become a routine course of Bharat. 2019, no priority. 2019, no priority. 2017 will be priority. Whatever it may be. Put in routine course of Bharat. 2019 routine course. Routine course of Bharat, sir. Other priority illa. Priority 2017.
Page number 2, syllabus 3 to 5. Page number 3, syllabus 5. Page number 4, syllabus 11 to 16. Page 5, 17 to 19. Page 6, syllabus 20 to 25.
Why, madam? Have you intimated the other side? You will better. Band ಆಮ್ಯಾಗ ಅವ್ರು ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡ್ತಾರ. ಅವ್ರಿಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಿ ಬಂದ್ರೆ ಇಲ್ಲ ರೂಟೀನ್ ಕೋರ್ಸ್ ಕಾಲ್ ಔಟ್ ಆದ ಡೇಟ್ ಕೊಡ್ರಿ ಅಕಾಮಡೇಟ್ ಮಾಡ್ತೀನಿ ನಾನು. 20 ಮುಂದೆ ಏನ್ ಮಾಡ್ಬೇಕು? ಯು ಆರ್ ಅಪಿಯರ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್. ಎಸ್ ಐ ಡು ಅಗ್ರಿ. ನೆಕ್ಸ್ಟ್ ಅದರ್ ಸೈಡ್ ಇಂಟಿಮೇಟ್ ಮಾಡಿದೀರಾ? ಮಾಡಿ. ಇಂಟಿಮೇಷನ್ ಮಾಡಲ್ದ ಇಲ್ಲ ಅಂದ್ರೆ ಬಂದು ಅವ್ರು ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡ್ತಾರೆ. ನೆಕ್ಸ್ಟ್
Page 8, 32 to 38.
38, my dad. Only next year, my dad. Other side also implemented.
ಇಂಟಿಮೇಟ್ ಮಾಡಿದಿರಿ?
Anything.
As per request of the learner council for respondent, is the matter on 19. Intimation ಕೊಟ್ಟಿದ್ದೀರಾ? The learner council for appellant. As per request of the learner council for appellant list on 21st. Have you intimated the other side? Without intimation, I will not adjourn during preliminary hearing, because other side will raise objection because without our intimation they have collected the dates until objection ಮಾಡ್ತಾರೆ. ಅವ್ರಿಗೆ intimation ಮಾಡಿದ್ರೆ ಹೇಳ್ರಿ, I'll trust you, I'll accept. Otherwise accommodation ಮಾಡ್ತೀನಿ, call out period ದಾಗ submit ಮಾಡಿ. When it reaches, I'll accommodate you. There is no issue.
Which type? Syllabus 47.
ಯಾವುದು? As per the request of 47 list on 27th. ಕೇಶವ ಪ್ರಶಾಂತ್ ಅವರೇ.
I appear for the appellant. ಇದರಲ್ಲಿ R5 unclaimed ಅಂತ ಬಂದಿದೆ. So maybe held sufficient ಇಲ್ಲ.
ಏನಿದೆ ನೋಡ್ರಿ ಅದು intimation delivered or not ನೋಡಿ. If it is intimation delivered, then only it will be held as sufficient service. Otherwise not.
Otherwise, my lord, I will file a memo for dispensation. This is only with regard to my lord quantum.
Even
Intimation.
the notice to R5 returned as unclaimed. The postal endorsement disclosed that intimation is delivered twice. Hence, it is deemed service. List the matter for admission.
But TCR is required, my lord, in this case.
All for TCRs.
Much on this.
ಪ್ರಶಾಂತ್ ಅವ್ರ ನಿಮ್ದು 3 ದಿನ ಒಂದು ಮ್ಯಾಟ್ರ್ ಇಡ್ತಾ ಇದ್ದೀನಿ. You are when that matter comes, you are not representing.
ಇಲ್ಲ ಕ್ಲಾಶ್ ಆಗ್ತಾ ಇದೆ ಸುಮ್ಮನೆ ಸ್ವಲ್ಪ. I will
ಹೇಳಿದೀನಿ. Today I will have to dictate the order by recording your absence. ಮೊದಲೇ ನಿಮ್ಗೆ ಗಮನಕ್ಕೆ ತಂದಿದ್ದೀನಿ.
ಇರ್ತೀನಿ ಸ್ವಾಮಿ. I will be there.
Yes, Mahesh ಅವರೇ. Serial number 2, unmute ಮಾಡಿ.
Lord, pray for 2 weeks time, my lord.
As per request.
R2, my lord, has returned with no such person.
My lord, court audience is muted, my lord. We are not able to hear. Court audience is.
ಅಲ್ಲ ಏನೋ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಗ್ತಿಲ್ಲ.
ಅಲ್ಲ ಅವ್ರೇನೋ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾ ಇರೋ ಅಡ್ವೊಕೇಟ್.
ಇಲ್ಲ ಏನೋ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಲಿಲ್ಲ ಅವರು. ನಟರಾಜ್ ಬಲ್ಲಾಳ್ ಏನಿದೆ ಏನಿದೆ ಅಲ್ಲ ನಿಮ್ ಅಲ್ಲ ದಟ್ ಈಸ್ ದಿ ಅದರ್ ಸೈಡ್. ಏನ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನಿದೆ? ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಇದ್ದೀರಿ, ಅಪೆಲೆಂಟ್ಸ್ ಅಂತ ಹೇಳಿ ವಕಾಲತ್ ಹಾಕ್ತೀರಾ ರೆಸ್ಪಾಂಡೆಂಟ್ ಪರವಾಗಿ ಅಪೇರ್ ಆಗಿ. ಕಾಸ್ಟ್ ಇದು ವಕಾಲತ್ ಒಳಗೆ ಹೆಸರು ಹಾಕಲ್ಲ, ಸಿಗ್ನೇಚರ್ ಮಾಡಿದ ಪಾರ್ಟಿದು. The learned counsel for the respondent number 226 undertakes to rectify the office objections. ನೀವು ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕೋರಿಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? Execution ಹಾಕುವವರೆಗೆ immediately you should have initiated ಅಲ್ಲ. 21st. ಎರಡು 21st.
I am for appellant in both the cases. There is
For the
some,
respondent, my lord.
retirement ಇದಿದೆ ವಿಜಯ್ ಕುಮಾರ್.
ಅದರಲ್ಲಿ ಮಿಸ್ಟರ್ ಶಿವಪ್ರಸಾದ್ ಶಾಂತನಗೌಡರ್ advocate has retired and I am appearing for APSRTC.
You have filed power ಅಲ್ಲ.
Yes, my lord.
Shivaprasad Shantanagowda filed the retirement memo. Sri B. Vijay Kumar filed power for a respondent. The Shivaprasad Shantanagowda is permitted to retire. The office is directed to delete his name from the cause title. Yes.
May I submit, my lord? My lord, it is only regarding quantum negligence and liability involvement not in dispute. It is only regarding the quantum. If other side ready, if court ready, my lord, I am ready for final.
Please, my lord. Please, my lord.
ಬರೀ ಇಲ್ಲಿ ಏನಾಗ್ತಾ ಇದೆ ಗೊತ್ತದೇನ್ರಿ? Now we'll have to start taking final hearing first.
ಹೌದು ಸರ್. ಅಲ್ಲ ತಾನೆ ನಂದೇನು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ. If court
We
time.
should start reverse.
ಅಡ್ಡಿಲ್ಲ
Anyway,
ಸರ್.
it is a 2017 matter. It is a 2017 matter. I leave it to your lordship.
ಸರಿ ಹೇಳಿ.
ಅಲ್ಲ ತೊಂದ್ರೆ ಆಗದೆ ಇದ್ರೆ ಮಾತ್ರ ಹೇಳ್ತೇನೆ ಸ್ವಾಮಿ. ಅಲ್ಲದೆ ಇದ್ರೆ ನಮ್ಮಿಂದ
17 ಮ್ಯಾಟರ್ ಅದೇನ್ ತೊಂದ್ರೆ ಆಗೋಲ್ಲ ಹೇಳಿ. 19 ಇದ್ರೆ ವಿಚಾರ ಮಾಡ್ತಿದ್ದೆ ನಾನು.
ಹೌದು, ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದೆ.
The case of first say ಮೊದ್ಲು ಯಾವ್ದು ತಗೊಳ್ತೀರಿ ಅಂತ 9,000 ಅಥವಾ
ನೀವು ಯಾವ್ದು ಹೇಳ್ತೀರಿ ಅದನ್ನ ತಗೊಳ್ತೀನಿ.
ಫಸ್ಟ್
I have no priorities.
ಇದು ಕಾಗ್ನಿಸ್ಟ್ ಅಂತ ತಕೊಂಬೋಣ 9,000/2017. ಯಾಕಂದ್ರೆ ಇದರಲ್ಲಿ ಏನು ಇದಿಲ್ಲ. ಡೇಟ್ ಆಫ್ ಎಕ್ಸೆಂಟ್ is 7/11/2015. The appellant was aged 21 years, a BE student plus ಟ್ಯೂಷನ್ ಮಾಡ್ತೇನೆ ಅಂತ ಹೇಳಿದ್ದೇನೆ, 10,000 ದುಡಿತೇನೆ ಅಂತ ಹೇಳಿದ್ದೇನೆ. ಅದ್ರ ಬಗ್ಗೆ ಯಾವ್ದು ಪ್ರೂಫ್ ಕೊಟ್ಟಿಲ್ಲ. ಬಿ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದ್ದೇವೆ. He sustained, may I submit? He sustained compound fracture of left femur with some facial injuries. He was treated in Bowring Hospital, Nimans, Sanjay Gandhi Hospital and DG Hospital and last Vishwa Bharati Hospital for the last 10 days total. He was inpatient, underwent surgery for fixation of steel rods and still it is in situ, required and another surgery, the cost of which is about 25,000 to 30,000. PW3 is the doctor. According to Dr. Mala, 13% whole body disability. Page number 13, para number 11 onwards is relevant. The pain and suffering 40,000 ಕೊಟ್ಟಿದ್ದಾರೆ. Loss of immunities ಕೊಟ್ಟಿಲ್ಲ. Medical expenses as per bills produced, that is 1,68,696. That has been allowed. Incidental 25,000.
ಓ ಮಹೇಶ್ ಅವರೇ ನಿಮ್ನ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
As far as future loss of earning and earning capacity is concerned, 8,000 is considered notionally, the 9,000 ಆಗಬೇಕು. Since the extent is of the year 2015. 9% disability ತಗೊಂಡಿದ್ದಾರೆ. 26% limb disability ಹೇಳೋದಕ್ಕ 9% ತಗೊಂಡಿದ್ದಾರೆ. ಆದ್ರೆ ಡಾಕ್ಟರ್ specifically stated that there is a 13% whole body disability. My respectful submission is as far as disability is concerned, since there is a specific evidence available on record that is a 13% whole body ಅಂತ ಹೇಳಿದ್ದಕ್ಕಾಗಿ 1/3 principle not applicable. That is my submission. Adrinda disability 13% ತಗೊಳ್ಬೇಕು ಅಂತ ನನ್ನ submission.
Humor 13% to whole body is exorbitant ಆಗ್ಲಿಲ್ಲ.
ಇಲ್ಲ ಸ್ವಾಮಿ, that depends madam. That depends.
That depends. What is the special circumstances? Femur is 13%.
ಅಲ್ಲ ಫೇಸ್ ಅದು ಕಂಪೌಂಡ್ ಕಮ್ಯುನಿಟೆಡ್ ಫ್ರಾಕ್ಚರ್ ಅಲ್ಲ, ಸಿಂಪಲ್ ಫ್ರಾಕ್ಚರ್ ಇಸ್ ಎಂಟೈರ್ಲಿ ಕಂಪೌಂಡ್ ಅಂದ್ರೆ ಚೂರ್ ಆಗಿರ್ತದೆ. ಅದೇ ದಟ್ ಇಸ್ ದ ಮೇನ್ ಇಶ್ಯೂ. Consideration is required to be considered. The simple fracture is entirely different from compound fracture. Compound means is the complicated. That too, weight bearing bone, that is the femur, but it is left to the court, my lord. I have no say. 9% ತಗೊಂಡಿದ್ದು ಕಡಿಮೆ ಅಂತ my respect to submit. 13% ಈಗ 1/3 ಡಿಡಕ್ಷನ್ 1/3 ತಗೊಳ್ಬೇಕು ಹೇಳುವಂತ ಜಜ್ಮೆಂಟ್ ಏನಿದೆ ಅಥವಾ ಪ್ರಿನ್ಸಿಪಲ್ ಏನಿದೆ, when there is no specific if the medical evidence or doctor not.
What is the evidence regarding disability to a particular limb?
26% ಹೇಳಿದ್ದಾರೆ.
26% to particular limb. 1/3 ಮಾಡಿದ್ರೆ 9% is on higher side.
ಅಲ್ಲ ಸ್ವಾಮಿ, ನಾ ಏನ್ ಹೇಳಿ
same analogy ಅಲ್ವಾ?
ಅಲ್ಲ ಇಲ್ಲ ಅದು ಅಪ್ಲಿಕೇಬಲ್ ಆಗೋದಿಲ್ಲ ಅಂತ ನಾನು ಹೇಳ್ತೇನೆ. ಈ 1/3 ಏನು ಕನ್ಸಿಡರೇಷನ್ ಇದೆ, when there is no medical evidence is available. ಈಗ ಡಾಕ್ಟರ್
But he has given 26% to the whole body.
ಅಲ್ಲ 26% ಲಿಂಬ್ ಹೇಳ್ಕೊಂಡು 13%.
Sorry, 26% to the limb ಕೊಟ್ಟಾಗ 13% whole body ಹೇಗೆ ಕೊಡ್ತಾರೆ? half
ಕೊಡಬಾರ್ದು.
He has given false evidence. His evidence cannot be believed and relied upon.
Yes,
them.
next.
ಮತ್ತೇನಿಲ್ಲ ಸರ್,
ಅಷ್ಟೇ.
ಎಮ್ಯುನಿಟೀಸ್ ಕೊಟ್ಟೇ ಇಲ್ಲ, ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಕಡಿಮೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಫ್ಯೂಚರ್ ಲಾಸ್ 9,000 ತಗೊಂಡು 13% ತಗೊಳ್ಬೇಕು. ಇದಿಷ್ಟೇ ಗ್ರೌಂಡ್. ಲಾಸ್ ಆಫ್ ಅರ್ನಿಂಗ್ ಆಫ್ ದ ಪೇರೆಂಟ್ಸ್, ದಟ್ ಈಸ್ ದ ಲಾಸ್ ಆಫ್ ಅರ್ನಿಂಗ್ ಫಾರ್ ದ ಲೇಡ್ ಅಪ್ ಪೀರಿಯಡ್ ನಾಟ್ ಅವಾರ್ಡೆಡ್.
Yes.
It is the only grounds.
Shall I submit, my lord?
ಅಲ್ಲ, ಸೆಕೆಂಡ್ ಸಬ್ಮಿಟ್ ಮಾಡಿಬಿಡ್ಲಿ ಅವರು.
ಆಯ್ತು. ಇದ್ರಲ್ಲಿ ಇನ್ನೂ ಶಾರ್ಟ್ ಸರ್, ಮತ್ತು ಶಾರ್ಟ್. ಇದು PWT ಡಾಕ್ಟರ್ ಡಿಸಬಿಲಿಟಿ ನಾಟ್ ಅಸೆಸ್ಡ್ ಮೇಲೆ. ಈಸ್ ಆಲ್ಸೋ ಬಿ 21 years ಬಿ ಸ್ಟೂಡೆಂಟ್ ಅಂಡ್ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ ಅಂತ ಹೇಳಿ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ರು. ಬಿ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಕಂಪೌಂಡ್ ಫ್ರಾಕ್ಚರ್ ಆಫ್ ಲೆಫ್ಟ್ ಫಿಬುಲಾ, 7 days inpatient in Vishwabharati Hospital, and medical bills produced 22,102. That has been allowed. Only 3 head is considered. Pain and suffering 25,000, medical expenses 22,102, and incidental 20,000. Remaining heads not awarded. It is left to the court. Pain and suffering.
What is the evidence of PW3 regarding disability?
Disability is not assessed, my lord. Is only deposed regarding line of treatment.
Then, when he has not stated disability, when there is no evidence of disability,
ಫ್ಯೂಚರ್ ಲಾಸ್ ಬಗ್ಗೆ ಡಿಸಬಿಲಿಟಿ ಹೆಡ್ ಮೇಲೆ ಬರ್ಲಿಕ್ಕಿಲ್ಲ. ಲಾಸ್ ಆಫ್ ಎಮ್ಯುನಿಟೀಸ್ ಕೊಡ್ಬಹುದು.
ಸರಿ.
ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಕಡಿಮೆ ಆದಂಗೆ ಕಾಣ್ತಾ ಇದೆ, 25,000. ನಮ್ದು ಯಾವ್ದ್ರಲ್ಲೂ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ ಸ್ವಾಮಿ ತಮ್ಮ ಜೊತೆ. ನೀವ್ ಹೆಂಗ್ ಹೇಳ್ತಿರೋ ಹಂಗೆ ನಮ್ದು, ನಾವ್ ಮುಗಿಸ್ಕೊಂಡು ಹೋಗ್ತಾ ಇರೋರು ಅಷ್ಟೇ.
Yes, Vijay Kumar ಅವರೇ.
My lord, as far as this second appeal is concerned, my lord, my lord, he is a student and he is a fracture of fibula and doctor is not examined and conservative line of treatment, and my lord, tribunal has considered the medical expenses as per the bills produced by the thing, and my lord, pain and suffering, my lord, conveyance, everything is awarded 20,000. My lord, in this case, my lord, my suggestion may be another 20,000 may be awarded.
Loss of amenities ಕೊಟ್ಟಿಲ್ಲ
ಅಷ್ಟೇ. 20,000 ಕೊಟ್ಟರೆ ಬೇರೆ ಯಾವುದು ಬರಲ್ಲ ಸರ್.
ಲೇಡ್ ಅಪ್ ಪೀರಿಯಡ್
ಬರಲ್ಲ. ಸ್ಟೂಡೆಂಟ್, ಅವನೆಂತ ಸ್ಟೂಡೆಂಟ್ ಗೆ ಲೇಡ್ ಅಪ್ ಪೀರಿಯಡ್ ಬರುತ್ತೆ. ಈ ಸ್ಟಡಿಂಗ್.
ಸರಿ.
Then in the next appeal, my lord, MFA 9,000 of 27, MEC 5242/2015, para 11 of the judgment. My lord, he is also a student and he sustained a fracture of femur. There is no document to show that he was a computer operator and even if he is a computer operator, the fracture of femur doesn't come in the way of his occupation income, but he is a student. Occupation, as per my learned friend only, income is not proved, occupation is not proved, and he is not entitled for any compensation towards loss of future income.
It is already granted by taking income.
Yes.
Then
I'll
you are
make
not
my-
challenged. Now
Yes,
you are
yes, my
arguing
lord.
in the appellate court, disputing the said aspect.
Yes, no, I am not submitting the court. I am not disputing. I am submitting to the court. Just to highlight the court, in spite of no future loss of income, tribunal has awarded. Of course, I agree that we have not filed that. But activities of the year 2015, just for a fracture of femur, that to a student, fracture is united well. Well, at 4,14,250, we should have filed the appeal. You have not filed the
You
appeal.
should have
The
filed it.
compensation-
Allah. Nobody has
Definitely.
prevented you.
Even now I can file. Even now
No,
I
you
can
file
file.
it and then
Early.
not familiar
Therefore-
way.
Therefore, my humble submission to Lordship is the compensation granted by the tribunal is already on the higher side. It does not require for any enhancement. That is my simple argument.
Okay.
If entitled for any compensation, I would have suggested under this head he is entitled. But everything is awarded on the higher side.
Amenities ಕೊಟ್ಟಿಲ್ಲ ವಿಜಯ್ ಕುಮಾರ್.
ಅದ್ರಲ್ಲಿ ಬೇರೆ ಹೆಡ್ಸ್ ಎಲ್ಲ ಜಾಸ್ತಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಎಲ್ಲ ಹೆಡ್ಸ್ ಅಲ್ಲೂ ಜಾಸ್ತಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಓವರ್ ಆಲ್ ಕಾಂಪನ್ಸೇಷನ್ ಈಸ್ ಮೋರ್ ದನ್ ವಾಟ್ he deserves. ಅವರೇ ಹೇಳಿದ್ರೆ ಈ ಕೇಸಲ್ಲಿ ಏನು ಇಲ್ಲ ಅಂತ ಹೇಳಿ.
ಇದ್ರಲ್ಲ ಮತ್ತೊಂದ್ರಲ್ಲಿ
ಅದಲ್ಲ ಎರಡನೇ ಫಸ್ಟ್ ಕೇಸಲ್ಲಿ ಅದೇನೆ.
ಅಲ್ಲ ಅದಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಏನು ಇಲ್ಲ ಅಂತ ಬಹಳ ಶಾರ್ಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಂತ ಹೇಳಿದ್ರು.
ಅಷ್ಟೇ ಇದೆ. ನಾನು ಶಾರ್ಟ್ ಆಗಿ ಹೇಳಿದ್ದೀನಿ.
is only to save the time of valuable time of the court.
Correct. I am also doing the same thing
Listed for
from the beginning.
orders by the consent of the parties. These matters are taken up for final disposal. These two appeals are filed. Challenging.
ಸಪರೇಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಆಗ್ಬಿಡಿ ಸ್ವಾಮಿ. ಸಪರೇಟ್ ಜಡ್ಜ್ಮೆಂಟ್
ಯಾಕ್ರಿ ನೀವು ಕ್ಲಬ್ ಎದಕ್ ಮಾಡಿಸ್ಕೊಂಡ್ರಿ ಮತ್ತೆ?
ಅದು ಆಗ್ ಬಂದಿದೆ ಅಷ್ಟೇ. ಇರ್ಲಿ ಸ್ವಾಮಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಯಾವ ರೀತಿ ಆದ್ರೂ ಸರಿ.
It makes no difference. Separate.
Yes, please.
ಅವ್ರಿಗೆ ಡಿಫರೆನ್ಸ್ ಆಗ್ತದೆ.
The MEC disposed of by common judgment itself.
ಪ್ಲೀಸ್ ಮೇಡಮ್,
ಅವ್ರಿಗೆ
ಯಾವ ರೀತಿ ಆದ್ರೂ ತೊಂದ್ರೆ ಇಲ್ಲ.
ಫೀಸಲ್ಲಿ ಡಿಫರೆನ್ಸ್ ಆಗುತ್ತೆ ಅವ್ರಿಗೆ. ಅದಕ್ಕೆ
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
These two appeals are filed challenging judgment and award passed by 21st ACMM and 23rd SCCJ and MACT bracket of SCCH 25. Challenging the judgment and award passed in relation number 5241 and 5242 of 2015 by judgment dated 27th February 2017. The claimants filed these enhancement. For the sake of convenience, party sharing, the brief factual matters leading to the case are that on 7/11/2015 at 0:30 AM, the petitioners Mithun and Manjunath were proceeding on motorcycle bearing KA 04HV1628 from Vidhan Sauda to Coffee Boat Circle on Ambedkar Road slowly and cautiously. At that time, the driver of APCRC bus bearing AP 03 Chad 0074 came from left side in a rash and negligent manner, endangering human life and dashed against the motorcycle of the petitioner, resulting in the accident. Both the petitioners suffered grievous injuries and immediately they were shifted to Boring and Lady Curzon Hospital, Bangalore. And after treatment, Petitioner Mithun was shifted to Vishwavarti Hospital, Hanumat Nagar, and was inpatient there. The petitioner Manjunath was admitted in Bowring Lady Curzon Hospital initially, and later on he was shifted to Nimans. And later on he was also admitted to Vishwavarti Hospital. Both the petitioners were studying engineering in UVCE College. Petitioner Mithun was studying engineering in UVCE College, while petitioner Manjunath was studying in computer science at GMS College. That Mithun was doing data entry work in part-time and earning rupees 10,000 per month, and also conducting tuitions and earning rupees 10,000 per month. Hence, they filed claim petitions seeking claim petition in section 166 seeking compensation from respondents. Mithun has filed MEC 5241, while Manjunath has filed MEC 5242 of 2015. The corporation has appealed through its counsel and contested the matter, disputing the liability fastened on the driver. The tribunal, after assessing the oral as well as documentary evidence, has awarded a total compensation of 4,14,250 with interest at the rate of 8% to petitioner Manjunath in MFA 9,000 of 2017, and a compensation of rupees 67,150 is awarded to petitioner Mithun, who is appellant in the other MFA, with interest at the rate of 8% per annum. Being aggrieved by these orders and these awards, the claimants are before this court. Third, the arguments advanced by the learned counsel for appellants and learned counsel for claimants, learned counsel for respondent corporation. There is the report. The learned counsel for claimants, it contend that claimants are engineering students and also doing data entry business as well as tuition and are taking tuition, and hence they were earning sufficiently, but because of the external injuries, they suffer permanent disability. It is also contended that no compensation was awarded under the head of loss of amenities, and as such, it is paid for enhancement of the compensation. Next. Per contra, the learned counsel for respondent corporation would support the judgment and award passed by the tribunal, contending that the compensation already awarded is on higher side and does not require any enhancement. Having heard the arguments and perusing the reports, it is evident that there is no serious dispute regarding the extent occurred on the intervening night of 6/11/2015 and 7/11/2015 at 0:30 hours. Further, both the petitioners, claimants Mithun as well as Manjunath suffered injuries Manjunath. Manjunath. The tribunal has held that the extent in question is because of actionable negligence on the part of the driver of the APSRTC bus, and this said finding is not at all challenged by the respondent. In respect of Manjunath, the tribunal has awarded compensation of pain and suffering, 40,000, medical expenses, 1,68,696, conveyance and food, 25,000, future loss of earnings, 1,55,520, and future medical expenses to the tune of rupees 25,000. It is argued that the income taken of the claimant Manjunath is on lower side, as the income was taken at 8,000, but it ought to have been taken on 9,000. It is further contended that the doctor has stated the whole body disability to the extent of 13%, but tribunal has taken it to 9%, and hence he would seek further. He would also contend that loss of the no compensation was awarded under the head of loss of amenities. At the outset, it is evident that the medical officer has assessed the disability to the particular limb to 26%, but as regards whole body, his evidence disclosed that he has given and treated it as 13%. However, tribunal has taken disability at 9%. The claimant has suffered fracture of compound fracture of the femur, left femur. Considering the nature and gravity of the injuries, the disability stated by medical officer is on higher side, and the tribunal has rightly taken the disability at 9%, which does not call for any interference. The tribunal has taken the income of the claimant at 8,000 per month. It is contended that the claimant is a BE student and was also earning 10,000 per month by data entry as well as by tuition. But to substantiate this contention, no piece of material evidence is placed on record. The claimant himself was examined as PW2 and the doctor is examined as PW3. The tribunal, in the absence of any material evidence, has taken the notional income of the claimant at 8,000, basing on the decision of Guwahati High Court reported in 2016 Part 4, Civil Law Journal, page 122. Admittedly, the extent has occurred in the year 2015, and this court is consistently taking the income at 9,000 per month. Hence, the tribunal has erred in taking the income on lower side. Further, the taking the notional income at 8,000 regarding the employment of the claimant is not challenged by the corporation. Under such circumstances, if the income is taken as 9,000, the loss of future earning would work out as 8,000, 9,000 into 12 into 18 into 9 by 100. One lakh 74,000. 96, 960. 960. As against 1,55,520 awarded by the tribunal. The tribunal has awarded 40,000 under the head of pain and suffering, which is reasonable and as such it does not call for any interference. Further, tribunal is awarded rupees 25,000 under the head of nourishment, attendance charges and conveyance, which is just and proper. Further, tribunal has also awarded 1,68,696 under the head of medical expenses on the basis of the records. Further, tribunal has also awarded rupees 25,000 under the head of future medical expenses, which is also on higher side. However, since the corporation has not challenged the said award, it cannot be interfered with.
ಅದಕ್ಕೆ ಡಾಕ್ಟರ್ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ 20,000 30,000.
ನಾನು ಬರ್ದಿದ್ದೀನಿ ಅಂತಿಲ್ರ, ನಾ ಏನ್ ಇಂಟರ್ಫೇರ್ ಮಾಡಿಲ್ಲ ಅದಕ್ಕೆ.
ಅಲ್ಲ ಅದು ಹೈಯರ್ ಸೈಡ್ ಹೇಳಿದ್ದಕ್ಕೆ
Not awarded any compensation under the head of loss of amenities. Considering the grant of compensation on higher side in other heads, I propose to award rupees 20,000 under the head of loss of amenities. Hence, claim title for
39,440 enhance ಆಯ್ತು.
under various heads as under pain and suffering 14, loss of amenities 20,000, medical 1,68,696, conveyance food nourishment 25, future loss of income 1,74,960, future medical expenses 25,000. Huh? 4 lakhs? 6. Hence, as a claimant, Manjunath, in MFA 9, a claimant appellant Manjunath in MFA 9,000 of 2017 is entitled for total compensation of rupees 4,53,652 as against 4,14,250 awarded by the tribunal. Next. As regards claimant Mithun, he has suffered fracture of left fibula.
ಅಲ್ಲ compound fracture of left.
Suffered compound fracture of left.
There is a lot of difference. That is why I am insisting.
Right. Left fibula. There is absolutely no evidence to show his disability, and medical officer is not examined in this regard.
ಅಲ್ಲ medical PW3 is examined, my lord, but he is
He has not be examined regarding disability.
ಅಲ್ಲ ಹೌದು ಡಿಸಬಿಲಿಟಿ ಬಗ್ಗೆ ಏನು ಹೇಳಿಲ್ಲ ಅಷ್ಟೇ.
That is relevant for us. PW3 did not disclose any disability pertaining to claimant appellant Mithun. The tribunal has awarded rupees 25,000 under head of pain and suffering, 22,102 under the head of medical expenses, 20,000 under the head of conveyance, nourishment, and incidental charges. Since there is no evidence regarding disability, question of awarding any compensation regarding loss of future earning does not arise at all. Since he is a student, question of awarding any compensation under the head of laid up period does not arise at all. However, the tribunal has awarded rupees 20,000 under the head of pain and suffering. Okay. There is a compound fracture of left fibula. In considering the nature of injury, the compensation awarded under this head appears to be on lower side, and hence I propose to award rupees 35,000 under this head. Under the head of medical expenses, tribunal has awarded rupees 22,102 based on medical records, and it does not call for any interference. Under the head of conveyance, nourishment, food, incidental charges, 20,000 is awarded, which also does not call for any interference. However, it is evident that the tribunal has not awarded any compensation under the head of loss of amenities. Considering the nature of injuries, I propose to award rupees 25,000 under the head of loss of amenities. Hence, claimant, appellant Mithun in MFA 7079 of 2017 is entitled for a total compensation under various heads as under pain and suffering 35, loss of amenities 25, medical expenses 22,102, conveyance, nourishment, etc. 20,000. Hence, she would be entitled for 1,02,102 as against 67,150 awarded by the tribunal. As such, both these sections need to be allowed. The enhanced compensation shall carry interest at the rate of 6%. And the same shall be enhanced compensation of sums shall be deposited within 6 weeks from the date of the release. Entire amount.
Raise for 2 weeks time not to take steps.
ನೀವ್ ಹೇಳ್ಬೇಕು ಅವ್ರು ಹೇಳ್ಬೇಕು ಏನ್ ನೀವು ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ತೀರಾ ಮತ್ತೆ ಈಸ್ ಎ ಕಾಂಟೆಸ್ಟಿಂಗ್ ಪಾರ್ಟಿ ಇಟ್ ಈಸ್ ಫಾರ್ ಹಿಮ್ ಟು ಟೇಕ್ ಸ್ಟೆಪ್ಸ್ ಅಲ್ಲ The learned counsel for appellant praise time. Finally, 1 week time is granted for taking steps. ನೋಡೋಣ ವಕೀಲ ಬರ್ಲಿ ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ ಅಂತ ಡೆತ್ ಕೇಸ್ ಅದ
I appear for the appellant.
1 week ಕೊಟ್ಟಿದ್ದೀನಿ ವಕೀಲ ಫೈನಲಿ
ಇಲ್ಲ ಅದು ಡೋರ್ ನಂಬರ್ ಇಲ್ಲ ಇದು ಇಲ್ಲ ಸ್ಟ್ರೀಟ್
ಅದು ಇಟ್ ಈಸ್ ಯುವರ್ ಲುಕ್ಔಟ್ ಸರ್
ಪಾರ್ಡನ್
ಇಟ್ ಈಸ್ ಯುವರ್ ಲುಕ್ಔಟ್ ಡೋರ್ ನಂಬರ್ ಸೆಕೆಂಡ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೆ 2 times ರಿಟರ್ನ್ ಆಗಿದೆ ನೋಡಿ ಅದಕ್ಕೆ ನಿಮಗೆ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ
2 weeks may kindly Miller because I have to write to the company and
ನೋಡಿ ಅದನ್ನ ಸರ್ಟೇನ್ ಮಾಡ್ಕೊಳ್ಳಿ ನೆಕ್ಸ್ಟ್
For second respondent.
The learned counsel for appellant absent. First time and ನನ್ ಮುಂದ್ ಬಂದಿದ್ದೆ ಫಸ್ಟ್ ಟೈಮ್ ಸ್ಟೆಪ್ಸ್ ಅಂತ ಹೇಳಿ ಬಂದಿದೆ ಅದಕ್ಕೆ ನಾನು ಟೈಮ್ ಕೊಡ್ತಾ ಇದ್ದೀನಿ ಇನ್ ಈಸ್ ಅಬ್ಸೆನ್ಸ್ ಆಲ್ಸೋ ಫಸ್ಟ್ ಟೈಮ್ ಸ್ಟೆಪ್ಸ್ ಇದೆ. ಪೋಸ್ಟೇ ಆಗ್ಲಿಲ್ಲಲ್ಲ, ಅದ ಅವ್ರ ತಪ್ಪ. ಪೋಸ್ಟ್ ಮಾಡ್ಲಿಲ್ಲ, ನಮ್ಮ ಆಫೀಸ್ ತಪ್ಪಲ್ವಾ? ನಮ್ಮ ಆಫೀಸ್ ಅವ್ರು ಮಾಡಿದ ತಪ್ಪಿಗೆ ಅವ್ರನ್ನ ಯಾಕೆ ವಿಕ್ಟಿಮೈಸ್ ಮಾಡ್ಬೇಕು ನಾವು? ತಪ್ಪಾಗತ್ತಲ್ವಾ? ಅವ್ರು ಮಾಡ್ಬೇಕಾಗಿತ್ತು, ಮಾಡಿಲ್ಲ. ಈಗ ನಾವು ಮಾಡೋಣಂತ, ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹೊಸಾನು ಮಾಡೋಣಂತ. There is no representation on behalf of appellant. List finally after 2 weeks for taking steps to R1. I don't want to view on whom liability is fixed. Steps ide ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳ್ಬೇಕು. As per request of the learned counsel for appellant, list up to 2 weeks. No representation on behalf of appellant, list after 2 weeks finally.
Serial number 9, I am for the appellant, my lord.
Yes.
My lord, I pray for a week's time, I will comply it, my lord.
Why I should not dismiss it? Second time it is coming up before the
My
court.
lord, I apologize, my lord. One opportunity, I will.
What can I do with your apology, madam?
I will comply it, my lord.
1 week finally.
Please, my lord.
The learned counsel for appellant filed a memo for dispensation of notice to R1. Memo is placed on record. Hence, at the risk of the appellant, notice to R1 stands dispensed with. List for admission after 2 weeks.
Memo may contain a memo regarding officer's duty. 3 objections the registry has raised. Then the first objection I have complained. Third one, my lord, the respondent is challenging the appeal, then statutory deposit will be made. It's a claimant appeal, my lord.
ಒಂದು ನಿಮಿಷ ನೋಡ್ತೀನಿ ತಡ್ರಿ. ಅವರು ಕಣ್ಣು ಮುಚ್ಚಿ ಏನೇನೋ ಮಾಡಿದ್ದಾರೆ.
Third one,
have you complied regarding valuation of the cross appeal?
that I have complained. Respondent is challenging the appeal, then statutory deposit to be made. It's a claimant appeal, he did not make statutory deposit. Cross objection is filed by the claimant. Again, I'm explanation.
Sir, date of service of notice on cross objector to be stated.
But last order sheet now my government. The explanations got to notice so survive the date on the date of the date of service and the consider more uಳ್ಕೊಂಡಿದೆ. Order statement.
ಸರ್ವಿಸ್ ನೋಟಿಸ್ ಆಗಿದೆ ಇದು ನೋಡ್ರಿ. ಅವ್ರ ಮೆಮೊ ಹಾಕ್ತಾರೆ, ನಮಗ್ ನೆನಪಿಲ್ಲ ಅಂತ ಹೇಳಿ. ನಾಟ್ ದಿ ಗ್ರೌಂಡ್. ಅವ್ರಿಗೆ ಡೇಟ್ ಆಫ್ ನೆನಪಿಲ್ಲ ಅಂತಂದ್ರೆ ವಿ ಕೆನಾಟ್ ಇಗ್ನೋರ್ ಇಟ್. ಕವರ್ ಡಿಲೇ ಕಂಡು ಬರುತ್ತೆ. ಅಲ್ಲ ಡಿಲೇ ಕಂಡೋನೇಷನ್ ಮಾಡೋಣ ಅಂತಿಲ್ರ. ದಟ್ ಇಸ್ ಎ ಡಿಫರೆಂಟ್ ಆಸ್ಪೆಕ್ಟ್. ಇಲ್ಲಿಟ್ರೇಟ್ ಅಂತೀರಿ, ಸಿಗ್ನೇಚರ್ ಮಾಡ್ತೀರಾ, ಡೇಟ್ ಆಫ್ ಸರ್ವಿಸ್ ನಮ್ಗೆ ನೆನಪಿಲ್ಲ ಅಂತ ಹೇಳ್ತೀರಾ, ಆಸ್ ವಿ ಆರ್ ಇಲ್ಲಿಟ್ರೇಟ್ ಅಂತ ಹೇಳ್ತೀರಾ, ಸಿಗ್ನೇಚರ್ ಮಾಡ್ತೀರಾ. ನೋಟಿಸ್ ಎಂದ ಇಶ್ಯೂ ಆಗಿತ್ತು ನೋಡ್ರಿ, ಇಶ್ಯೂ ಅಲ್ಲ. ವಾಟ್ ಈಸ್ ದಿ ವ್ಯಾಲ್ಯೂ ಆಫ್ ದಿ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್?
11,25,000. Para number 12, my. The partial application which I have rectified.
The Learned Council has complied all office objections.
Second objection was submitted.
ಯಾವ ಸೆಕೆಂಡ್ ಅಬ್ಜೆಕ್ಷನ್?
Second objection cross appeal ಹೇಗೆ ಹಾಕಬೇಕು ಅನ್ನೋದ್ರ ಮೇಲೆ ಅದರಲ್ಲಿ ಲಿಂಗ್ objection ಆಗಿದೆ. Second objection
ಏನ್ ಹೇಳಿ ನೀವು?
cross appeal is not in the proper form ಅಂತ ಹೇಳ್ತಾರೆ. By the heard may kindly produce the cross appeal. First to appeal the cross appeal ಆಗಿ, then I have filed the cross appeal last time. This is the proper forum. ನಾವು ಇದುವರೆಗೂ ಹಾಕೊಂಡ್ಬಂದಿಲ್ಲ. That is what has been held in Karnataka High Court rule. Chapter 6 of Karnataka High Court rules 1990.
The objection regarding cost detail overruled as the same is properly disclosed in the cross appeal. The other objection regarding port fee, statutory deposit does not apply to the case in hand since the cross appeal is filed by the seeking enhancement. Hence, office objections in this regard also stands overruled. The office is to verify the other office objections and submit a detailed report regarding compliance.
Serial number 12, my lord, delay may be condoned, and my lord, records may be called for, my lord, because claim petition is dismissed.
I-1 of 17 is filed for condonation of delay of 59 days in filing the appeal.
Records may be called, my lord, because
Comma, I-1 of 17 is allowed and delay of 59 days in filing the appeal stands condoned. Call for TCS. Delay. Hold on, I number 1 of 17, there is delay of 214 days in filing the appeal. Considering the grounds urged, I-1 of 17 is allowed and delay of 214 days is condoned subject to denial of interest for the said period. Call for TCRs, Baker. Call for post the matter for admission.
my lord, serial number 14, my lord.
Yes, Sukil,
14.
you take notice.
Yes, my lord, I will take notice.
5742 or 70. We post alarm
57.
5742 or 70.
ನೀವು ಓಮೇಶ್ವರ್ ಅಪೀಲ್ ಹಾಕಿದಾರಂತೆ.
Then my lord, let him take, my lord.
MFA 8877 ವಕೀಲ್ರೆ.
8877. ಅಲ್ಲ, Tata has been shown as
ಸೀರಿಯಲ್ ನಂಬರ್ 14 ಹೇಳ್ತಾ ಇರೋದಲ್ಲ.
Yes, my lord. Then my lord,
5742 17 ಹಾಕಿದಾರ.
In 14, my lord, my name is not shown, my lord.
ಅಲ್ಲ, ನೀವು ಇನ್ನ ವಕಾಲತ್ ಹಾಕಿಲ್ಲ. Served on your insurance company. But your colleague submit that you have filed, the insurance company has filed an appeal in MFA 5742 of 17.
Lord, I have filed, my lord, but in this case, my lord, I have been, copy has not been served and.
ಅಲ್ಲ, ಇನ್ನ ನೀವು ಸರ್ವಿಸ್ ಆರ್ಡರ್ ಆಗಿಲ್ಲ. ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿ ನೋಟಿಸ್ ಕೊಟ್ಟಿವಿ, ಅವರ ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಇಲ್ಲ. ಅವ್ರು ನಿಮ್ ಕಾಪಿ ಕೊಡ್ಬೇಕಾಯ್ತು, ಅವ್ರಿಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬಿಟ್ಟಿ ನಾವು.
ಇಲ್ಲ, ನೋಟಿಸ್ ಹೋಗಿ.
ನೋಟಿಸ್ ಹೋಗಿ ಬಂದಿದೆ, ಸರ್ವ್ಡ್ ಆಗಿದೆ. Insurance company is unrepresented.
I'll check up, my lord, with my client.
Serial number 14. CO Mahesh is directed to take notice for R2. The learned counsel for appellant is directed to furnish another set of copy to the learned counsel for respond number 2. Please the matter along with MFA 5742 of 2017.
Please.
Delay है मतलब. Owner मैंने see decrease passed against owner, liability is fastened on owner. ಅವೇನ್ ಕೇಳಿದ್ರು ಫಸ್ಟ್ ಡಿಲೇ ಕಂಡೋನ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ಡಿನೈಲ್ ಆಫ್ ಇಂಟ್ರೆಸ್ಟ್ ಮಾಡಬಹುದಲ್ಲ. Hold on, I number 1 of 21. There is delay of 323 days in filing the appeal. Considering the grounds urged, I1 of 21 is allowed and delay of 323 days is condoned subject to denial of interest for the said period. ಈಗ ಏನದು ಮೆರಿಟ್ಸ್, ಈಗ ಹೇಳಿ ಏನಾಗಿದೆ ಅದು ಇಶ್ಯೂ.
Was very behind permit limits. That ground, the liability
Call for TCS. But permit conditions violation ಆಗಿರೋ ನಾವು ಪೇಮೆಂಟ್ ರಿಕವರಿ ಬರುತ್ತಲ್ಲ. ಸರಿ, ಕಾಲ್ ಫಾರ್ TCS. ಬೆಂಗಳೂರಿಂದ ಬರೆದು ಅವ್ರು ಮಾಡ್ಬೇಕಾದ್ರೆ 2 ವಾರ ತಗೊಳ್ತಾರೆ. Third, on I number 1 of 18, there is delay of 86 days in filing the appeal, and I1 of 18 is filed for condonation of the delay. Considering the grounds, I1 of 18 is allowed and delay of 86 days in filing the appeal stands condoned. ನಿಮ್ಮ appeal ಯಾವ್ದದು?
I am for the appellant, my lord.
Yes.
My lord, we have disputed the involvement of the vehicle in the accident and also the liability. He was traveling in the tractor trailer. So they are liable to pay the compensation. We are not liable to pay. We have challenged the liability.
Yes,
And
challenge
also
the liability.
Yes, my lord. And also involvement of the vehicle.
Liability, I cannot release it. Argument ಮಾಡಬೇಡಿ. This will disclose. ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ತೀನಿ, ಪ್ರಿಪೇರ್ ಆಗಿಬಿಡ್ರಿ ವಕೀಲ್ರೆ. ವಿಲ್
ಅಲ್ಲ
ಡಿಸ್ಪೋಸ್
ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಬೇಕು. LCR ಬರ್ಲಿ ಸರ್ ಮಾಡೋಣ.
ತರಿಸ್ತೀನಿ, ಎಲ್ಶಿಯರ್ಸ್ ತರ್ಸೋಣಂತ.
ಪ್ಲೀಸ್.
Please the matter on 28th.
I appear for appellant, my lord. They have filed cross objection. The service is not yet completed. And appellant, my lord, in MFA 707 of 2019, challenging the, my lord, the liability and the nexus between injury and the death. LCR may kindly be called for.
ಬಡಿ ಪಾಪ ಅವ್ರಿಗೆ ಯಾಕೆ ಅವ್ರಿಗೆ ಕಷ್ಟ ಕೊಡ್ತಾರೆ. ಈ petition is filed 2:30. Valid again at 2:30. By that time get.
You take notice for R1 in crop.
No, if copy is served, my lord, I don't mind.
Hello,
taking.
whenever you have filed it, so you take notice.
Yes,
and,
my lord.
I will direct him to serve a copy on you.
Please, my lord.
Copy ಕೊಡಿ ಅವ್ರಿಗೆ.
And he has to take steps for other respondents.
Other respondents, it is for him.
Please.
Sri O Mahesh is directed to take notice in MFA crop 128 of 2019 for respondent number 1. The learned counsel for appellant is directed to serve the copies along with relevant documents to the learned counsel for respondent number 1. Delay ಇದೆ, notice ಹೋಗ್ಬೇಕು R1 ಗೆ.
ಹೌದು, notice ಹೋಗ್ಬೇಕು.
Issue notice in crop to respond number 1.
And LCR may kindly be called for.
For T-shirts. ಬಂದಿದೆ, LCRs ಬಂದಿದೆ, T-shirts. ಇದೆಲ್ಲ ನೋಟಿಸ್ ಬರಬೇಕು. ಡೇಟ್ ಹರಿಡ್ಲಿ ಮಾಡಿದಂದ್ರ ಡೇಟ್ ಟೈಮ್ ಇದೆ, ಪರ್ಟಿಕ್ಯುಲರ್ ಟೈಮ್ ಅದ ಅಂತ ಹೇಳಿ ಆನ್ಸರ್ಡ್ ಅಂತ ಹೇಳಿ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಬರುತ್ತೆ. ಅದಕ್ಕೆ
I appear for fourth respondent.
ಡಿಲೇ ಬಗ್ಗೆ ಏನ್ ಹೇಳ್ತಿರತ್ತಲ್ರ? You are for fourth respondent.
Yes, my lord, in MFA 1075 of 19, but in 4435 of 19, my lord, Tata AG is shown to be served.
They are not represented.
Yes.
Connected same matter ಅಂದ್ರೆ ಯಾವುದು? ಎರಡು ಮ್ಯಾಟರ್. 1075 you are for appellant. 1075 ಒಳಗೆ ಅದ್ರೊಳಗೆಲ್ಲ ಸರ್ವಿಸ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ. ಡಿಲೇ ಏನ್ ಹೇಳ್ತೀರಾ? ಡಿಲೇ ನಿಮ್ಮ ಅಪೀಲ್ ಒಳಗೆ ಏನ್ ಹೇಳ್ತೀರಾ? ಥರ್ಡ್ 18 ಒಳಗೆ
Appellant may be directed to serve a copy on me, my lord.
To be frankly, I am not supposed to say because it is already served on you. But ನೀವು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ಕೊಡ್ತೀನಿ, ಬಟ್ ನಿಮ್ಮ ಆಫೀಸರ್ ಜವಾಬ್ದಾರಿ ಇರ್ಬೇಕಲ್ವಾ?
ನಾವು ಏನು ಅದಕ್ಕೆ ಏನಾಗುತ್ತೆ?
The I1 is of 19 is filed for condonation of delay of 65 days. Considering the grounds urged, I1 of 19 is allowed and delay of 65 days is condoned. ಅವ್ರಿಗೆ ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡ್ರಿ. The learned counsel for appellant is directed to Sri O Mahesh is directed to take notice for R2 Tata AIG General Insurance Company, The learned counsel for appellant is directed to serve the copy on the learned counsel for appellant. T-shirts ಏನ್ರಿ ಬೇಕಾ? ಬೇಕಾ T-shirts ಹಾಕಿಲ್ರ? T-shirts ಬೇಕಾ?
ಬೇಕಾಗತ್ತೆ ಸರ್.
Call for T-shirts. ಬೆಳಗ್ಗೆ ಏನ್ ಪಾಸ್ವರ್ಡ್ ರೀ? ಪರ್ಮಿಷನ್ ಟು ವಿಡ್ರಾಲ್ ಐತಿ, ಪಾಸ್ವರ್ಡ್ ಅದಕ್ಕೆ. ಈಗ ಪಾಸ್ವರ್ಡ್ ಅಂತ ಹೇಳಿದ ಮೇಲೆ ನಿಮ್ಮ ಮುಖದರ್ಶನ ಆಗಲ್ಲ. ದಟ್ ಈಸ್ ದಿ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್. ಬರೋದನ್ನೇ ಇಲ್ಲ. ನಡು ಒಂದ್ ಅರ್ಧ ಗಂಟೆ ಯಾವಾಗ ಕೂತ್ ಮುಖ ತೋರಿಸ್ಕೊಂಡು ಹೋದವ್ರು ಸಾಯಂಕಾಲ ತನಕ ಪತ್ತೆ ಆಗಲ್ಲ ನೀವು. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡ್ತೀವಿ ಲಿಸ್ಟ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಾರ್ನಿಂಗ್ ನೀವೇ ಟೈಮ್ ಕೇಳಿದ್ರಲ್ಲ, ಅವ್ರು ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಕ್ರಾಬ್ ಕಂಡೋನ್ ಮಾಡಬಹುದಾ? ಸಬ್ಜೆಕ್ಟ್ ಟು ಡಿನೈಲ್ ಆಫ್ ಇಂಟ್ರೆಸ್ಟ್ ಇಫ್ ಶಿ ಸಕ್ಸೀಡ್ಸ್. MFA Crop 8 of 20. I1 of 19 is filed for condonation of delay of 670 days in filing the appeal. Third, the learning counsel for respondent, considering the grounds urged, I1 of 19 is allowed and delay of 670 days is condoned, subject to denial of interest for the said period in case cross objector succeeding in the appeal. ನೀವಿನ ವಕಾಲತ್ ಹಾಕಿಲ್ಲ ಕ್ರಾಪ್ ಒಳಗೆ. Use the matter after 2 weeks. No representation. Admit. Call for T-shirts. T-shirts ಬಂದಿದೆ. Admit ಇಷ್ಟೇ ಹೋಗುತ್ತೆ. ಫೈನಲ್ ರೀಡಿಂಗ್ ಬೀಳಿದೆ ಅಂದ್ರೆ ದಾರಿಗೆ ಬರ್ತಾರೆ.
Payments.
ಪ್ರದೀಪ್ ಒಂದ್ ನಿಮಿಷ. ಪ್ರದೀಪ್
ಅದರಲ್ಲಿ ಸ್ವಾಮಿ 8,000 rupees plus 400 rupees ಬಾಟಾ ಕೇಳಿದ್ದೆ. 8,000 rupees ಕೊಟ್ಟಿದ್ದಾರೆ. ಮಿನಿಮಮ್ ವೇಜಸ್ ನೋಟಿಫಿಕೇಶನ್ ಇದೆ. 400 rupees ಬಾಟಾ ಕೊಟ್ಟಿಲ್ಲ.
ಹೌದು, ಬರ್ತಾ ಕೊಡಕ್ ವರ್ಕ್ಮೆನ್ ಕಾಂಪನ್ಸೇಷನ್ ಆಕ್ಟ್ ಪ್ರೊವಿಷನ್ ಇಲ್ಲ. ನೋಟಿಫಿಕೇಶನ್ ಪ್ರಕಾರ 8,000 ತಗೋಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. ಇಂಟ್ರೆಸ್ಟ್ 12% ಕೊಟ್ಟಿದ್ದಾರೆ ವಿದಿನ್ ಆಫ್ಟರ್ 1 month. ಮತ್ತೆ
only point that would leave for this consideration is section 4 of the Workmen's Compensation Act. In case of the injury of the results in his death or the employer should be addition to the compensation. Okay, 4 of the minimum 5,000 rupees ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Results in the death, the employer shall in addition to the company not less than 5,000 for payment of same to eldest serving dependent employee or the funeral expenses ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಅದೊಂದು 5,000 minimum 5,000 rupees.
Not less than 5,000 ಅಂತ ಹೇಳ್ತಾರೆ. ಅವ್ರು ಕೇಳೋದು ಈಗ ಅಷ್ಟಕ್ಕೆ ರಿಸ್ಟ್ರಿಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅದಕ್ಕೆ ಅವ್ರು ಅಷ್ಟೇ ರಿಸ್ಟ್ರಿಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಬೇರೆ ನಮ್ಗೆ ಸ್ಕೋಪ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಮುಗಿಸ್ಬಿಡೋಣ. Third, though this appeal is listed for admission by consent of the parties, the matter is taken up for final disposal. We, for the sake of convenience, parties herein are referred with the original. The brief factual matters leading to the case are that deceased Mansur Ahmad was son of claimants and he was employed as a lorry driver wearing KA 25/B6568 belonging to respond number 1. That on 21/3/2014 at about 7 a.m. when deceased Mansur was driving the said lorry and proceeding towards Goa from Bankapur via Hubli Karwa route near Arbail Ghat section. Suddenly a mini truck came and in order to avoid the collision applied and the deceased applied the brake of the vehicle and as a result it went into a ditch on the right side of the road and dashed to a tree. The deceased sustained fatal injuries and head and other parts of the body and succumbed on the spot. The deceased was employee under the respond number 1 and he was paid 8,000 per month towards salary and 200 rupees per bhatta. Hence, the claimants being the parents parents of the deceased filed the claim petition before the commissioner. The commissioner, after appreciating the oral and documentary evidence, has awarded a total compensation of rupees 8,31,920 with interest at the rate of 12% per annum. Next. Being aggrieved by this judgment and award, the claimants are before this court. Heard the arguments advanced by the learned counsel for appellant and learned counsel for respondent. Here is the reports. The learned counsel for appellant would contend that the tribunal has taken the income at 8,000 as pleaded, but has not awarded bhatta at the rate of 200 per month. Further, he would contend that under section 4, section 4, subclause 4, no compensation was, no amount was awarded under the head of towards funeral expenses, which is mandatory, and hence he seeks interference by this court. The learned counsel for respondent would support the award passed by the commissioner. Having heard the arguments and perusing the records, the small issue is regarding payment of bhatta as well as funeral expenses as claimed by the claimants. However, the deceased was drawing a salary of 8,000 and the commissioner has taken the salary at 8,000. However, there is no provision under the Employees Compensation Act to award bhatta, and hence question of awarding any bhatta at the rate of 200 rupees per day does not arise at all. The other contention raised by the learned counsel for appellant is that under section 4, subclause 4, at least some minimum 5,000 ought to have been awarded towards the funeral expenses, which was not done, and hence he seeks indulgence. Section 4, subclause 4 of Employees Compensation Act mandates that the employer, in addition to the compensation, shall also pay funeral expenses not less than 5,000 to the eldest surviving dependent of the employee. Looking to these aspects, in my considered opinion, the claimant should be entitled for additional 5,000 under the head of funeral expenses, and to this extent only appeal needs to be allowed, and accordingly I proceed to pass the following order. The appeal is allowed in part. The claimant is held entitled for to additional compensation of 5,000 in addition to what has been awarded by the tribunal with interest at the rate of 12% per annum from the date of petition. Yeah, the entire amount shall be released in favor of the claimants. Hmm? Hmm.
These are the requirement. Liability will
The Lieutenant Counsel for respondent trace time. This is the matter of ಎಲ್ಲಿಂದ ಬರ್ಬೇಕು ಟೀಚರ್ಸ್ ಲೋವರ್ ಕೋರ್ಟ್ ನಿಂದನ ಇಲ್ಲಿ ಬಂದಿದ್ರಿ ಯಾವ ಕೋರ್ಟ್ ಅಂತ ಕೇಳಿದ್ದು ಬೆಂಗಳೂರು is the matter after 2 weeks.
May I interfere, my lordship? I am appellant in 20 serial number 21 ಏನಾಯ್ತು ಗೊತ್ತಾಗ್ಲಿಲ್ಲ
21 ಅಡ್ಜರ್ನ್ ಆಯ್ತು ಕಿಲ್ರು
ಓ ಸರಿ ಸಾರಿ my lord.
You are for R1 is insurance company. The learned counsel for appellant absent. Admit ಮಾಡಿ ಫೈನಲ್ ಹೇರ್ಕ ಹೋಗಿರ್ಬಿಡ ಲೋಕ ಅದಾಲತ್ ಹಾಕಿ as per request of the learned counsel for respond number 1, refer the matter to Lok Adalat. ಇನ್ನು ಡಿಲೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕವ್ರು ಅಲ್ಲ ಇನ್ನು ಹಾಕವ್ರು ಏನ್ರಿ ಸಿಸ್ಟಮ್ ಇಲ್ಲಿ ಎಂಟರ್ಟೈನ್ ಮಾಡಬಾರ್ದು ಅವಾಗ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬಿಡ್ಬೇಕು ಗಿವಿಂಗ್ an another opportunity to file a delay condonation application system So ನಾನ್ ಕಂಪ್ಲೈನ್ಸಿಗೆ ಕ್ರಾಪ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಈಗಾಗಲೇ ಅದು ಕಣ್ಣು ಮುಚ್ಚ ಹಂಗ ಹಾಕುದು ಒಟ್ಟ ರಿಕಾಲಿಂಗ್ ಡಿಲೇಗಿಲೇ ಬೇಕಾಗಿಲ್ಲ ನಮಗೆ ಏನ್ ಸ್ವಾಮಿ as per the request the appellant in MFA crop 20 of 19 these matters after 2 weeks.
My lord, I am appearing for third respondent ಮೇಲೆ insurance company claimant appeal for enhancement ಇದು
Liability is not in challenged.
ಇಲ್ಲ ನಮ್ದು ಮೇಲೆ liability ಇದೆ so now we have not challenged.
ಅಲ್ಲ ಅದೇ liability dispute ಇಲ್ಲ
liability dispute ಇಲ್ಲ enhancement ಸ್ವಲ್ಪ
dispute. What is the date of extent?
Date of 27/5/2016.
16 ಇನ್ಕಮ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ 6,500 9,500 ಆಗ್ಬೇಕು
ಹೌದು
What is the age? 60 years. Is there, what is the evidence? ಬೇಕಾದ್ರೆ ಡಿಫರೆನ್ಸ್ 60 61 ಬಂದ ಹೋಯ್ತು ಎಲ್ಲ. ಅದಕ್ಕೆ ಬಹಳ. ವಾಟ್ ಈಸ್ ದಿ ಏಜ್ ಆಫ್ ದಿ ಡಿಸೀಸ್ ವಕೀಲ್ರ?
ಸ್ವಾಮಿ 60 ವರ್ಷ. ಪೇಜ್ 7 ಮೈ ಕೈಂಡ್ಲಿ ಲುಕ್ ಇಟ್. ಏನು ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕ್ಲಿ ಅಂತ ಲರ್ನೆಡ್ ಜಡ್ಜು PM ರಿಪೋರ್ಟ್ ನೋಡ್ಬಿಟ್ಟು 60 ವರ್ಷ ಅಂತ ಬರ್ದಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಪ್ಯಾರಾ 12 ಪೇಜ್ 7 ಮೈಲ. ಹೌದು ಸ್ವಾಮಿ.
ಅಲ್ಲ ರೀ, ಏಜ್ ಪ್ರೂಫ್ಗೆ ಇದು ಇದ್ರೂ ಹಾಕಲ್ಲ ಯಾಕೆ?
ಹಾಕಲ್ಲ ಸ್ವಾಮಿ.
ಪರ್ಪಸ್ಲಿ. ಅಲ್ರಿ, ಆಧಾರ್ ಕಾರ್ಡ್ ಇಲೆಕ್ಷನ್ ID ಕಾರ್ಡ್ ಎಲ್ಲಾರ ಕಡೆ ಅದ. ಈಗ ಆಧಾರ್ ಕಾರ್ಡ್ ಇದೆ ಆದ್ರೂ ಹಾಕಲ್ಲ. ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ ಏಜ್ ಕಡಿಮೆ ತೋರಿಸಿದಾರೆ PM ರಿಪೋರ್ಟ್ ಒಳಗ, ಬೆನಿಫಿಟ್ ಸಿಗುತ್ತೆ ಅನ್ನೋದು ಒಂದು ಉದ್ದೇಶ.
ಒಂದ್ ಕಂಪಲ್ಸರಿಯಾಗಿ ಆರ್ಡರ್ ಮಾಡ್ಬಿಡಿ ಸ್ವಾಮಿ ತಾವು ದಯವಿಟ್ಟು. ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ನಮ್ಗೆ ಅಷ್ಟಾದ್ರೂ ಅನುಕೂಲ ಆಗ್ತದೆ.
Wife.
Wife, major son, married daughter, my lord. So 50% are to have been deducted. Though
Wife is.
ಒಂಥರ್ಡ್ ಹೆಂಗಾಗತ್ತೆ? ವೈಫ್ ಹೋಗ್ಬೇಕಿಲ್ಲ ಅಂದ್ರೆ
As per the Sarala Varma case,
ಈ ಸರಳ ವರ್ಮ ಹೇಳಿ ನೋಡಿ. ಸರಳ ವರ್ಮದೊಳಗ
1/3
ಡಿಪೆಂಡೆನ್ಸ್ ಯಾವಾಗ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ? ಸರಳ ವರ್ಮ
major sons is dependency.
ಕೊಡಿ. ಬಂದಿದೆ ಅಂತ ಹೇಳಿ ನಿಮ್ಮ ಹತ್ರ ಇಟ್ಕೊಳ್ಳೋದಲ್ಲ ಅದು. This is only legal representative. We're not disputing their legal representativeness. We're considering the dependency. Dependency is different. A legal representative is different. A legal representative may not be dependent, but a dependent does not become a legal representative. Though he may not be a legal representative, he may become a dependent. ನೋಡಕ್ ಓದಕ್ ಹೋಗಲ್ಲ ವಕೀಲ್ರೆ. ಹೆಡ್ ನೋಟ್ D ಒಳಗ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ದಾರೆ. ವಕೀಲ್ರೆ, ಬೀರೇಂದ್ರ ಸಿಂಗ್ ಒಳಗ 1/3 ತಗೋಬೇಕಂತ ಹೇಳಿ ಅಬ್ಸರ್ವೇಷನ್ ಇದೆ ಹೆಡ್ ನೋಟ್ D ಕೆಳಗಡೆ.
ಅಲ್ಲ, 2018 ACC 1004 ತಗೊಳ್ಳಿ ಮೈ ಲಾರ್ಡ್. ವಿನೀಶ್ ಜೈನ್ ಕೇಸಲ್ಲಿ
ಸರ್ 2020 SC 434 ನ್ಯಾಷನಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ವರ್ಸಸ್ ಬೀರೇಂದರ್. ಹೆಡ್ ನೋಟ್ D ಮೇಜರ್ ಸನ್ಸ್ 1/3 ತಗೋಬೇಕು ಅಂತ ಹೇಳಿ ಬಂದಿದೆ.
ಅಲ್ಲ, ಒಂದ್ ವೇಳೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆ ರೀತಿ ಹೇಳಿದ್ರೆ ಇನ್ನು
ಹೇಳಿದ್ರೆ ಅಲ್ಲ, ಹೇಳಿದೆ ನಿಮ್ಗೆ ಗೊತ್ತಿದೆ, ಬಟ್ ನೀವ್ ಹೇಳಿಕ್ ರೆಡಿ ಇಲ್ಲ.
ಮೈಲಾರ್ಡ್ ಬೀರೇಂದ್ರ ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ ಮೈಲಾರ್ಡ್, ತೆಗಿತೀನಿ ಇವಾಗ್ಲೇನೆ.
ಪೇಜ್ ನಂಬರ್ 434 2020 SC ಸುಪ್ರೀಂ ಇಯರ್ 2020.
ಸರಿ ಸ್ವಾಮಿ.
ವೈಫ್ ಒಂದೇ ಇದ್ರೆ ಡಿವಿಷನ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ನಮ್ದೇ ಹೈಕೋರ್ಟ್ ಇಂದ.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇದ್ದಾಗ ಡಿವಿಷನ್ ಬೆಂಚ್ ಡಿಸಿಷನ್ ಹೆಂಗ್ ಬರುತ್ತೆ?
ಅಲ್ಲ, ಓನ್ಲಿ ವೈಫ್ ಈಸ್ ಓನ್ಲಿ ಕ್ಲೇಮೆಂಟ್. ಅವಾಗ
the wife and my major children ಇರ್ತಾರ, 2/3 is to be 1/3 is to be
ಕರೆಕ್ಟ್.
ಮತ್ ಇನ್ನೇನಿದೆ ರೀ ಇದ್ರಾಗ? ಏನ್ 132 plus 16(5) plus 15 ಇಷ್ಟೇ. ಇದಕ್ಕಿಂತ ಹೆಚ್ಚು ಏನ್ ಬರುತ್ತೆ? ನಾ ಏನ್ ಹೇಳಿ 132 ಹೇಳಿದ್ದೀನಿ. ಏನ್ರಿ ಅದಕ್ಕಿಂತ ಹೆಚ್ಚಿಗೆ ಬರುತ್ತಾ ನಿಮಗೆ? 3 ಜನ ಇದಾರಲ್ರಿ. ಮತ್ 132 ಕೊಟ್ಟಿದೀನಿ, 120 ಮಾಡ್ಬೇಕಾ ಅದನ್ನ?
44
ನಾ 120 ಕೊಡ್ಬೇಕು. ಕರೆಕ್ಟಾ? 120 plus 15 plus 15 ಕೊಟ್ಬಿಡೋಣ, ಆಯ್ತಾ? ನಾಟ್ 132. ಅಗ್ರೀಡ್. ನೀವ್ ಹೇಳ್ದಂಗ
60 years.
10% ಅಷ್ಟೇ ಬರುತ್ತೆ. ಅದಕ್ಕೆ ನೀವು ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ ಸಲುವಾಗಿ ಡಾಕ್ಯುಮೆಂಟ್ ಪರ್ಟೈನಿಂಗ್ ಟು ಹಿಸ್ ಏಜ್ ಇಸ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್. ಹಂಗೆ ವಕೀಲರು ನಾವು ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೇ ಬಂದಿದ್ದೀವಿ, ಹಾಗೆ ಬರ್ಲಿಕ್ಕೆ. This appeal is filed by the claimants under section 173 subclause 1 of MA Act, seeking enhancement of compensation compensation in MFA 775 of 2016 on the file of senior civil judge and MACT Nanjangud dated 1st January 2018. There is no serious dispute regarding factual aspects. The deceased Siddegowda on 27/5/2016 at 4:45 AM was returning to his house by walk on footpath of Nanjangud Undlupet Main Road and near Madeshwara Temple at Sindhuvalli village. The respondent number being the driver of tipper lorry drove it, tipper lorry bearing registration KA 09C1686, drove it in a rash and negligent manner and dashed against the deceased. As a result, Siddegowda succumbed due to injuries at the spot. The claimants, being the wife and children of the deceased, filed a claim petition under section 166 of MA Act, claiming total compensation of rupees 43 lakhs. Next. The respondent number 1 is the owner, and while respondent number 2 is the respondent number 1 and 2 are the driver and owner, while respondent number 3 is the insurer of the offending vehicle. They have disputed the actionable negligence on the part of the driver of the offending vehicle. Next, the tribunal, after assessing the oral and as well as documentary evidence, has awarded a total compensation of rupees 5,38,000 under with interest at the rate of 6% per annum under following heads. Being aggrieved by the said judgment and being dissatisfied with the judgment and award passed by the tribunal, the claimant has filed the appeal. Claimants have filed the appeal seeking enhancement. Third, the arguments advanced by the learned counsel for appellant and learned counsel for respondent insurer company. Peruse the records. Next, the learned counsel for appellant claimant would contend that the tribunal has taken the income of the deceased at 6,500 on lower side and future prospects were not added. She would further contend that under conventional head, proper compensation was not awarded and hence she has sought for enhancement of the compensation. Per contra, the learned counsel for appellant, the respondent insurer would support the judgment and award passed by the tribunal. Next. Having heard the arguments and perusing the records, it is evident that there is no dispute regarding liability. Admittedly, the deceased Siddegowda succumbed because of the accidental injuries in the extent involving the offending lorry, which was admittedly insured with respondent number 3. The tribunal has taken the income at 6,500. As on the date of the accident, the deceased was aged about 60 years. As per Exhibit P7, the accident has occurred in the year 2016, and this court is consistently taking the notional income at 9,500 in the absence of any other material evidence. Under these circumstances, in the absence of any other evidence, the tribunal ought to have taken the notional income at 9,500, and it has taken the income on lower side. Next. Further, the learned counsel for appellant would contend that the claimants appellants 2 and 3 are the major son and married daughter, and they does not fall under the clause of dependency, and as such, half of the income is required to be deducted towards personal expenses. However, the said issue has been covered in edition reported in AR 2020 SC page 434, wherein the Honorable Apex Court has held that even in case of major sons staying along with deceased, 1/3 is required to be deducted towards personal expenses. Hence, the said arguments advanced by the learned counsel for respondent would not will not survive. Since the deceased was aged about 60 years, 60%, 10% is required to be added towards personal expenses, towards future prospects. Hence, he would have contributed 9,500 into plus 10,000, 10%. His total income would be 10,450 per month. The multiplier 9 is applicable considering his age, and hence loss of dependency would work out as 10,450 into 12 into 9 into 2/3. 7,400,000 would be entitled for total compensation of 7,52,400 as against 4,68,000 awarded by the tribunal. Further, there are 3 claimants, being the widow and widow, son and daughter of the deceased. Each of them are entitled for consortium. In view of the decision reported in 2022, each would be entitled for 44,000, and hence the claimants would be entitled for 1,32,000 under the head of loss of consortium. Further, they are entitled for 16,500 under the head of loss of estate and 15,000 under the head of funeral expenses. Hence, the total compensation would work out at as under 7,52,400 dependency, consortium 132, estate 16,500, funeral 15,000. $9,15,900. Claimant would be entitled for total compensation of 9,15,900 as against 5,38,000 awarded by the tribunal. As such, appeal needs to be allowed, and accordingly, I proceed to pass the following order. Appeal is allowed in part. The judgment and award passed in the tribunal so in so stands modified. Claimants are held entitled for total compensation of 9,15,900 as against 5,38,000 awarded by the tribunal. The announced compensation shall carry interest at the rate of 6% per annum. The claimant and the respondent insurance company is directed to deposit the entire announced compensation with accrued interest thereon within a period of 6 weeks from the date of receipt of the copy of this order. The enhanced compensation shall be released in favor of the claimants. The apportionment release cut matter. The apportionment, deposit and disbursement shall be as per the terms of the order of the tribunal.
My lord, ಒಂದೇ ಒಂದು ಸಬ್ಮಿಷನ್ ಲಾಸ್ಟ್
sir.
ಇದು ನಾನು ವಿನಿಶ್ ಜೈನ್ ಕೇಸು ನೋಡಿದೆ, ಬಟ್ ತಾವು ಹೇಳಿದ್ದು ನೆಕ್ಸ್ಟ್ ಆಮೇಲೆ 20 ಬಂದಿರೋದು. ಕನ್ವೆನ್ಷನ್ಸ್ ಅಲ್ಲಿ ಪ್ರಣಯ್ ಸೇಠಿ ಜಡ್ಜ್ಮೆಂಟ್ ಫುಲ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ ಪ್ರಕಾರ 70,000 ಕೊಡ್ಬೇಕು ಅಂತ ಇದರಲ್ಲಿ ಪ್ಯಾರಾ 8 ಅಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ. ವಿನಿಶ್ ಜೈನ್ ವರ್ಸಸ್ NIA ಪ್ಯಾರಾ 8 ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ, ಮೈಲಾಡ್, in addition to the claimant should be entitled to rupees 70,000 for loss of love and affection, funeral expenses, etc. as per the judgment of this court in Pranay Sethi versus so and so.
Correct, sir. ಅದನ್ನೇ ಕನ್ಸಿಡರ್ ಮಾಡಿ 2022 ಒಳಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ದವರು ಪ್ರಣಯ್ ಶೆಟ್ಟಿ ಒಳಗ 10% ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಮಾಡಂತ ಹೇಳಿದ್ದಕ್ಕ 10% ಆಗಿದ್ರಿಂದ 10% ಎನ್ಹಾನ್ಸ್ ಮಾಡಿ 44 ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಅದನ್ನ ಫಾಲೋ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. They have not opposed. They have distinguished as per that act decision only. 3 ವರ್ಷ ಆಯ್ತು, 10% ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು. That is awarded.
ಸಾರಿ ಇಲ್ಲ ಡಿಸ್ಟರ್ಬ್ ಮಾಡಿದ್ದಕ್ಕೆ.
Amputation of wrist. Para number?
Number 2 and hand about the stuff. Therefore, not as per the workman compensation act, 60% of the disability has to be taken.
What is the evidence of the doctor? ಹೇಳಿದ್ದಾರೆ 60% ಅಂತ ಹೇಳಿ.
Para 25.
ಲೆಫ್ಟ್ ಹ್ಯಾಂಡ್ 60% ಹೇಳಿದ್ದಾರೆ. ಹೋಲ್ ಬಾಡಿಗೆ ಎಷ್ಟು ಅಂತ ಕೇಳಿದ್ ನಾನು.
Whole body parallel. That was not, no. But here, my lord, when there is an amputation of some particular limb, my lord, there cannot be, my lord, assist, my lord, is over the whole body. But the percentage of disability has to be taken into consideration for the entire body. Also, lordship page 23. Earning capacity.
अलग ही खेल
Loss of hand or the thumb and 4 fingers of one hand, or amputation from 11.46 centimeters below tip of olecranon, 60% earning capacity. So therefore, we lot 60% has to be taken into consideration. It's not 1/3 of the whole body. ಅಲ್ಲ ಪ್ಲೀಸ್ ಆಕ್ಟ್
compensation grant ಮಾಡೋದಾದ್ರೆ other compensation ಕೊಡೋದ್ರಲ್ಲ compensation other
ultimate
cannot be taken into consideration. ಎಲ್ಲೂ ಬೆನಿಫಿಟ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ. Also says that 20% is taken.
So 20% can be taken according to you. Let us accept. Oh, a hand is not there. How he should function? What is the okay? 20% to the whole body in general. What will be the? Let us go for functional disability then. Under 166, we'll have to consider functional disability. What will be the functional disability? Common sense.
ಕೂಲಿ ಮಾಡ್ತಾನೆ ಅನ್ಕೊಳ್ಳಿ ಅವ್ರು.
I will take a judicial notice. Even he, otherwise, whatever it may be, if he is a clerk employed in some government organizations, things are different. If he continued, but if he is a coolie or otherwise agriculturist, what will be the impact of the amputation of the one hand? That will have to be considered. Lower part of the entire left hand is crushed. Photographs hakilla. ಏನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ರೀ ಫೋಟೋಗ್ರಾಫ್ಸ್ ಇಲ್ಲಲ್ಲ ಪರಿಸ್ಥಿತಿ ಏನು ಹಾಕಿಲ್ಲ ಪಾರ್ಟಿ ಪ್ರೆಸೆಂಟ್ ಬೇಡ ಒಂದು ಫೋಟೋ ಟು ಅಸರ್ಟೈನ್ ಎಕ್ಸಾಕ್ಟ್ಲಿ ವಾಟ್ ಈಸ್ ದಿ ಪೊಸಿಷನ್ ಅಂತ ಹೇಳಿ ಅಷ್ಟೇ ಎಕ್ಸಿಬಿಟ್
ಇಲ್ಲ 41 ಬಂದ್ಬಿಟ್ಟು ಇದು ಡಿಸಬಿಲಿಟಿ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡ್ತಾರೆ 50% ಡಿಸಬಿಲಿಟಿ ಬರುತ್ತೆ ಗೌರ್ಮೆಂಟ್ ಹಾಸ್ಪಿಟಲ್
Where is the doctor who has given disability? Doctor ಕೇಳಿದೆ examination. ವೃತ್ತಿ ಏನು ಇಲ್ಲ. He is a doctor. He is not a doctor. one doctor is examined. CW1. RW. Arvind. He is not a orthopedic surgeon. Ji. He is a plastic surgeon. ಈ ಕ್ರಾಸ್ ಒಳಗ ಅವನ ಅಡ್ಮಿಟ್ ಮಾಡ್ತಾರೆ ಡಾಕ್ಟರ್. ಪೇಷಂಟ್ ಕ್ಯಾಶುಯಾಲಿಟಿ ಪ್ರಥಮ ಚಿಕಿತ್ಸೆ ಮಾಡಿದ್ರೆ ಅರ್ಜಿದರಿಗೆ ಆಪರೇಷನ್ ಮತ್ತು ಸರ್ಜರಿ ಮಾಡಿದ್ದು ನಾನೇ. ನೀವು ಆರ್ಥೋಪೆಡಿಕ್ ಸರ್ಜನ್ ಅಲ್ಲ ಅಂದ್ರೆ ಸರಿ. ನೀವು ಅಲ್ರಿ ಯಾರನ್ನು ಎಕ್ಸಾಮ್ ಮಾಡ್ತೀರಿ ಇಂತ ಇದ್ರೊಳಗೂ ಇಷ್ಟು ರೆಕ್ಲೆಸ್ ಅಲ್ಲ. He has conducted operation screen grafting adu madidare, operation madidare. That's okay. But best would have been the orthopedic surgeon alva. He producer ಮಾಡ್ರಿ ಇಲ್ಲ ಇದನ್ನ ready. But he has admitted Allah, I am not a orthopedic ಅಂತ ಹೇಳಿ. Photograph of other body. As per. Use the matter on 28. 28. Then it will be date ಕೊಡಲ್ಲ ನಾನು. Then after 4 weeks ಅಂತ ಇರ್ತೀನಿ. ಈಗ ನಡು ವೆಕೇಶನ್ ಬರುತ್ತೆ. 1 to 9 ವರೆಗೆ ವೆಕೇಶನ್ ಇದೆ. It will be posted after 10. Least after 4 weeks. 27.
28.1 ನಲ್ಲಿ respondent but 2 weeks. ಅವತ್ತು ಆಮೇಲೆ ಬಂದಾಗ ನನ್ನ ಕನೆಕ್ಟ್ ಮಾಡಿ ಟ್ಯಾಗ್ ಆಗಿ
ಶಾಸ್ತ್ರಿಗಳೇ
ಮೇಲಡ್
ರಾಜಶೇಖರ್ ಅವರಿಗೆ ಕಾಪಿನೇ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ ಅವರು ಸಬ್ಮಿಷನ್
ನಾನು ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಂತ ಆಗಿರ್ಬೇಕು ಅದು ಬಹುಶಃ
ಟ್ಯಾಗ್ ಆಗಿದೆ ಅದಕ್ಕೆ ಅವ್ರ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅದಕ್ಕೆ ಅವ್ರ ಕಾಪಿ ಕೊಟ್ಬಿಡಿ
ಹ್ಯಾಂಗ್ ಕೊಡೋದೊಳಗೆ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ ಅದೇ ನನ್ಗೆ ಅಡ್ರೆಸ್ ಇದ್ರೆ ಫೋನ್ ನಂಬರ್
ನಿಮ್ಮ ಕ್ಲರ್ಕ್ ಇದ್ ನಂಬರ್ ಕೊಡಿ ನಾನು ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೋತೀನಿ ಮತ್ತೆ
ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೋತಾರ ನಿಮ್ ಕ್ಲಾರ್ಕ್ ನಂಬರ್ ಕೊಟ್ರೆ ಅವ್ರು ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೋತಾರ ನೋಡಿ
ಬರ್ಕೊಳ್ಳಿ ಸರ್ 9844 ನಾನೇ ಕ್ಲರ್ಕು 98454 ನಿಮ್ಮ ಅಡ್ರೆಸ್ ಕಳಿಸಿ ಸರ್ ನಾನು ಪೋಸ್ಟ್ ಮಾಡ್ತೇನೆ
ನಾನು ಮಾಡ್ತೀನಿ ತಗೋತೀನಿ
ಫೋನ್ ನಂಬರ್ ಕೊಡಿ ನಿಮ್ ಕಾಲ್ ಮಾಡಿ ಆಮೇಲೆ ಇಮೇಲ್ ಮೇಲೆ ಕಳಿಸ್ರಿ ಅಂತ ಅವ್ರದ್ದು ಇಮೇಲ್ ತಗೊಂಡು ಫೋನ್ ನಂಬರ್ ಕೊಡಿ ನಿಮ್ಗೆ
98454
ಹೇಳಿ ಸರ್
977
ಹೇಳಿ ಸರ್
92
97792
ಕೋಆರ್ಡಿನೇಟ್ ಮಾಡಿ
ಎಸ್ ಇದು
26-27 ಸಬ್ಜೆಕ್ಟ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಕನ್ವೀನಿಯನ್ಸ್
28 as per request 28
ಇದು ಇದ್ರಲ್ಲಿ ನಾನು ಎಲ್ಲ ಹಾಕ್ಬೇಕಾಗಿದೆ ಯಾಕಂದ್ರೆ 3 ಲಕ್ಷ ರೂಪಾಯಿ ಮೆಡಿಕಲ್ ಬಿಲ್ ಆಗಿದೆ ಅದಕ್ಕಾಗಿ ನಾನು ಪಾರ್ಟಿ ಸಿಗ್ನೇಚರ್ ಎಲ್ಲ ಬೇಕಾಗ್ತದೆ
ಅದಕ್ಕೆ 28 ಕೊಟ್ಟಿದ್ದೀನಿ ವಕೀಲ್ರೆ 28th ಆಲ್ಮೋಸ್ಟ್ ಮೋರ್ ದನ್ 15 days
ಅಡ್ಡಿಲ್ಲ
ಅಷ್ಟೊತ್ತಿಗೆ ಆಗ್ಲಿಲ್ಲ ಆಗುದಿಲ್ಲ ಅಂದ್ರೆ ಇನ್ನ ಟೈಮ್ ಕೊಡೋರು ಕೊಡ್ತೀನಿ ನಂದೇನಿಲ್ಲ ಸರಿ
$29 million I pay for the appellant KSRTC. This appeal is filed by the KSRTC for enhancement of compensation. Well, it is like this, Malad, towards the loss of revenue during
ಒಂದ್ ನಿಮಿಷ ಹಾ ಶ್ರೀರಾಮ್ ಚಿಟ್ಸ್ ಏನಾಯ್ತು? ವಕೀಲ್ರ ಅವ್ರು ರೆಡಿ ಆದ್ಮೇಲೆ ಹೇಳ್ತಿರಲ್ಲ, ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಬೇಕು. ಇನಿಷಿಯಲಿ ಹೇಳಕ್ ಆಗಲ್ವಾ ನಿಮಗೆ? ಸರ್ ನನಗೆ ಟೈಮ್ ಬೇಕು, ಒಂದ್ ಟೈಮ್ ಕೊಡಿ ಅಂತಂದ್ರೆ ಕೊಡ್ತೀವಿ. ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ ಮೇಲೆ ಹೇಳಲೇಬೇಡ ಅಂತ ತಿಳಿಸೋ ವಿಷಯ ಏನ್ರಿ ಅಂತ ಕೇಳಿದ್ಮೇಲೆ ನಾನು ಅಪೀಲ್ ಮೆಮೊ ಇಲ್ಲ, ಒಂದ್ ಟೈಮ್ ಕೊಡ್ರಿ ಅಂತ ಹೇಳಿದ್ರಿ. ಹೇಗ್ರಿ? ನೀವು ಟೈಮ್ ಬೇಕಾಗಿತ್ತ ಕೇಳಿ, ಒಂದ್ ಅಕಾಮಿಡೇಷನ್ ಕೊಡಿ ಸರ್, ನೋಡ್ಕೊಂಡು ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿ, ಫೈನ್, ನೋ ಪ್ರಾಬ್ಲಮ್. ಯು ಶುಡ್ ಬಿ ಫೇರ್. ನಾನು ನೋಡಿಲ್ಲ, ಪ್ರಿಪೇರ್ ಆಗಿಲ್ಲ, ಒಂದ್ ಡೇಟ್ ಕೊಡಿ ಸಾಕು. ವಕೀಲರು ಒಂದ್ ಡೇಟ್ ಕೇಳ್ತಾ ಇದಾರೆ ಅವರು.
Very soon. Matter may require reconsideration by the tribunal. ಅದಕ್ಕೇನೆ ನಾನು ಅವಸರ ಮಾಡಿದೆ ಸುಮ್ಮನೆ.
23rd.
Please, Malad.
List on 23/9. Rajaram Suryambail, Sandesh Shetty, Ravi Shankar, there is no representation on behalf of appellant and respondents. List after 2 weeks. ಶಾಸ್ತ್ರಿಗಳೇ ನಿಮ್ಗೆ
ಆಮೇಲೆ ಕೇಸ್ ಆಫ್ ಡೆತ್ ಅಷ್ಟೇ. ಲಯಬಿಲಿಟಿ ಅಂಡ್ ಇನ್ವಾಲ್ವ್ಮೆಂಟ್, ಲಯಬಿಲಿಟಿ ನಾಟ್ ಇನ್ ಡಿಸ್ಪ್ಯೂಟ್. ಏನಿಲ್ಲ, 2018 ಆಕ್ಸಿಡೆಂಟ್ 2018 ಚಾರ್ಟ್ ಅಂತೆ ಕೊಟ್ರಾಯ್ತು. ಬ್ಯಾಚುಲರ್ ಡೆತ್ 50% ಡಿಡಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ಸರಿ ಇದೆ. 50% ಡಿಡಕ್ಟ್ ಮಾಡಬೇಕು, 40% ಆಡ್ ಮಾಡಬೇಕು, ಅದು ಮಾಡಿಲ್ಲ. ಮತ್ತೆ ಕನ್ವೆನ್ಷನ್ ಅಲ್ಲಿ ಇಷ್ಟೇ. ಮೇ ಐ ಸಬ್ಮಿಟ್ ಮೇಲೆ ಎಲಾಬರೇಟ್.
ಅಲ್ಲ ಆಯ್ತು, ಇದು ಇನ್ಕಮ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
5,000 ತಗೊಂಡಿದ್ದಾರೆ 2018 ಆಕ್ಸಿಡೆಂಟ್.
ಸೊ 12,500 ತಗೋಬೇಕು ಅಕಾರ್ಡಿಂಗ್.
ಹೌದು. ಅದಕ್ಕೆ 40% ಆಡ್ ಮಾಡಿದ್ರೆ 5,000 ಆಡ್ ಮಾಡಬೇಕು.
ಸರಿ,
17,500 50% ಹೋಗುತ್ತೆ, 8,750 ಆಗುತ್ತೆ. ಇಂಟು 12 ಇಂಟು 18 ಇಷ್ಟೇ ಸ್ವಾಮಿ. ಆಮೇಲೆ ಕನ್ವೆನ್ಷನ್ ಲೆಟರ್ ಪೇರೆಂಟ್ಸಿಗೆ.
ಸರಿ, ಇಲ್ಲಿವರೆಗೆ ಇದ್ರೆ ಅವ್ರು ಇರಲಿಲ್ಲ, ಅವ್ರು ಬಂದ ತಕ್ಷಣ ಡಿಸ್ಪೋಸ್. ನಿಮ್ದು ಇಷ್ಟೇ ಅಲ್ಲ?
ಇಷ್ಟೇ ಸ್ವಾಮಿ, ಇಷ್ಟೇ. ಇಟ್ ಮೇ ಬಿ ಡಿಸ್ಪೋಸ್. ಇಂಟ್ರೆಸ್ಟ್ 8% ಕೊಟ್ಟದಿದ್ರೆ 6% ತರಬೇಕು ಸ್ವಾಮಿ. ಅದು ನೋಡಿಲ್ಲ ನಾನು.
ಸರಿ,
ಹಾ 8% ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಮಾಡಿದೆ.
ಸರಿ, ನೋಡೋಣ. ಅವ್ರು ಬಂದ್ ಕೂಡಲೇ ಅವ್ರನ್ನ ಕೇಳಿ, ಕ್ವಾಂಟಮ್ ಬಗ್ಗೆ ಅವ್ರನ್ನ ಕೇಳ್ಕೊಂಡು ವಿಲ್ ಡಿಸ್ಪೋಸ್.
ಅಷ್ಟೇ. ಮೈ ಪ್ರೆಸೆನ್ಸ್ ಮೇ ಬಿ ಡಿಸ್ಪೆನ್ಸ್ಡ್ ವಿತ್.
ಎಸ್, ನಿಮ್ನ ಹೇರ್ ಮಾಡಿದ್ದೀನಿ. ಓಕೆ,
ಸರಿ.
Two aspects I have to point out to you.
ಹೇಳಿ. ಹೇಳಿ ಫೈಲ್ ಬಂದಿದೆ.
Point out your lordship. The accident is taken place on 24/2011 their condition. Now, as per the records what I transfer your lordship. Yes, got retired in the year 2013. That is on 2013 he has got retired, your lordship. That is on 5/2/2013. Because his date of birth was 6/2/1953.
He cannot retire on 5/2/2013. He can retire only on 28/2/2013. He is not a constitutional authority.
Of course, your lordship. Of course, your lordship, that is whichever is they ಬರುತ್ತೆ ಅದರಲ್ಲಿ ತಗೊಂಡಿದ್ದಾರೆ 6/2 on the date of birth ಆದ್ರು
So 2013 ರಿಟೈರ್ ಆಗಿದ್ದಾನೆ ಅಷ್ಟೇ.
2013 retired. Now, your lordship, he during the period of service, in his service, your lordship, he has availed all the benefits of Raja Manjurati and earned leave. Raja Manjurati ಎಲ್ಲ ಮಾಡಿಕೊಂಡು yes, still he worked in his retirement by substituting lighter jobs, but without loss of wages. Without loss of wages. After retirement, your lordship, he files the petition under section 22(1) of the Employees Compensation Act, which before the Commissioner Compensation on 29/7/2013. This is after his retirement. He availed all the benefits, no loss of pay or wages, and he was given with the lighter works in terms of the corporation regulations and surplus like again payment ಅಲ್ಲಿ ಎಲ್ಲೂ ಕಮ್ಮಿ ಆಗಿಲ್ಲ. 2013 ಅಲ್ಲಿ after retirement he passes, which the interview your lordship referred to the because of the government notification that referred to the small class MSc transfer act. There your lordship now, as far as my submission your lordship was on the last day pointed out section 4 right there. Now section 4 your lordship. Section 4 in which clause 1 A, C, such as last one. In the case of injury not specified in schedule 1, such a percentage of compensation paid in the case of permanent total disablement as is proportional to the loss of earning capacity. So your lordship here, my submission, I'll pose the earning capacity, your lordship is not at all diminished because he has paid full salary in his retirement. Full salary with his retirement, till his retirement. Then your lordship, I will just for the sake of your lordship, how the earning capacity or disability has to be examined, kindly refer to section 11 numbers. Section 11. Really, medical examination. ಅವರೇ ಹೋಗ್ಬಿಟ್ಟು ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಕ್ ಆಗಲ್ಲ, ಅವರೇ ಹೋಗ್ಬಿಟ್ಟು ನಾನು ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡ್ಕೊಂಡು ಎಂಪ್ಲಾಯ್ have given notice of an accident. The employer before the expiry of 3 days at the time of each service of the notice has been effected. Offer to have him examined with charges by a qualified medical practice or submit himself for such examination, and any employee who is in the set of a half monthly payment under this shall, if so required, submit himself for such examination for time to time. So that means, Your Lordship, he has to submit before the authority corporation that please examine my disability in the presence of your corporation officers and examine my disability, which he has not done. Without any loss of pay, wages, then after retirement, he goes and fights. Now, Your Lordship, rule, Your Lordship. Rule, Your Lordship, Workmen's Compensation Rules 1924, medical examination of that. Okay, examination of when workmen and medical practitioner both on premises. 13 over 3. A workman who is required by subsection 1 of section 11 to submit himself to medical examination shall be bound to do so in accordance with the rules contained in this part and not otherwise. The examination when workmen and medical practitioner both on premises, if such workman is present at the employer's premises and the employer offers to have been examined free of charges by qualified medical practitioner, if so present, the workman shall submit himself for the examination for paid. So what he did, Your Lordship, he has not made an offer to examine himself. What is it?
What prevented you? Because you have reimbursed the charges. Very interestingly, you paid all the charges. Keli. On kadinda matta you are eligible for 8,000 and order balance matta you have deducted it from his salary.
Adu, as per understanding, deduct money now. Because cost of 1,08,000.
No, sir, 25,000 odd, expenses agittu. Yeah, 25. See, he was your employee. The accident has occurred during the course of employment. And last time you have submitted, you will ascertain from your employee. Other ಬಗ್ಗೆ ಏನು ಮಾತಾಡೋದು, you are directly arguing on merits. But you have not submitted anything on this point. Straight away you started arguing on merits without any defense. Very serious.
This is what the information which I have obtained.
See, say fair I helbekagiತ್ತು first ನೀವು. Sir, they are not ready for settlement. We'll go with the merits of the case ಅಂತ ಹೇಳಿಲ್ಲ ನೀವು. You directly started arguing on merits only. ಅಲ್ಲ ಬರೋದು ಬೇಡ ನನಗೆ. See, why accommodation was given to you? ಅಲ್ಲ why? ನೀವು ಹೇಳ್ಬೋದಾಗಿತ್ತು ಕಾಂಪ್ರಮೈಸ್ ಸಾಧ್ಯ ಇಲ್ಲ. Now we are not ready for any settlement. The reasons are ಅಂತ ಹೇಳಿದ್ರೆ court would have appreciated your stand. You started arguing on merits. Sorry, ಹಂಗ ಹೇಳಕ್ ಬರಲ್ಲ ನಿಮ್ಗೆ. ಆಯ್ತು ಹೇಳಿ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. Everything is without a defense.
ಸೆಟಲ್ಮೆಂಟ್ ಬರಕ್ ಡಿಫೆನ್ಸ್ ಹೇಳ್ತಾ ಇರೋದ್ರಿಂದ ಸೆಟಲ್ಮೆಂಟ್ ಬರಕ್ ಆಗೋದಿಲ್ಲ ಅಂತ ಹೇಳೋಣ ತಿಂತೀರಾ?
ಅದಕ್ಕೆ ಹೇಳೋದು ನಿಮ್ಮ ಲಾರ್ಡ್ ಆಫೀಸರ್ಸ್. I need not say anything. ಸರಿ ಹೇಳಿ ಏನ್ ಮೆರಿಟ್ಸ್ ಬಗ್ಗೆ ನೋಡೋಣ. Let us see.
This is how Your Lordship is done. No doubt, Your Lordship, we have not taken any defense by taking the process and find out the statement or cross examination. No methods has been produced. That is why, Your Lordship, since these are the laws which has enumerated, Your Lordship, I simply request Your Lordship to remand the matter, Your Lordship.
ಒಂದು 15,000 ರೂಪಾಯಿ ಕಾಸ್ಟ್ ಆಗ್ತದೆ. ನೋಡಿ ಸೀರಿಯಸ್ನೆಸ್ ವಿಚಾರ ಮಾಡಿ. ದಟ್ ಈಸ್ ನಾಟ್ ಈಸಿ. The corporation heavy cost hike ಅಂದ್ರೆ what is the status of the corporation? How it affects the reputation of the institution? Think of it. No, Martinillo, I am not assuring you. That is your contention. I am not saying that it will be done. No. It is an alternative submission in case your your contention is accepted because of your latches. You will have to face the consequences. One thing. That is serious latches. Serious latches. Not a casual latches. ಯಾರು ನಾನು ಇಗ್ನೋರ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಬಟ್ ನೀವು ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ಒಳಗೆ ಇಗ್ನೋರ್ ಮಾಡೋದು ಸೆಕೆಂಡ್ರಿ. ಯು ಆರ್ ನಾಟ್ ಚಾಲೆಂಜಿಂಗ್ ಎನಿ ಆಫ್ ದೀಸ್ ಆಸ್ಪೆಕ್ಟ್ಸ್. ಡಿಸಬಿಲಿಟಿ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ಲಿಲ್ಲ ಇಲ್ಲಿ ಬಂದು ಅದು ಹಾಗಾಗತ್ತೆ ಇದಾಗತ್ತೆ ಅಂದ್ರೆ ಸೆಕ್ಷನ್ 4 ಕೆಳಗೆ ಹೋಗ್ಬೇಕು, 11 ಕೆಳಗೆ ಹೋಗ್ಬೇಕು. ದಟ್ ವಿಲ್ ಅರೈಸ್ ಓನ್ಲಿ ಇಫ್ ಯು ಡಿಸ್ಪ್ಯೂಟ್. ಯು ನೆವರ್ ಡಿಸ್ಪ್ಯೂಟೆಡ್. ದಟ್ ಈಸ್ ದಿ ಇಶ್ಯೂ ದೇರ್. ಇಷ್ಟ ಅಲ್ಲ ನಿಮ್ದು. Heard the learned counsel for appellant further to hear respondent, counsel for respondent, claimant, Monday to hear other side. Agar ಅವ್ರಿಗೆ ಹೇರ್ ಮಾಡ್ಬೇಕು ನಾನು. Agar you are now raised new grounds.
ನಾನು ನಮ್ಗೆ ಗಮನ ತರಬೇಕಾಯ್ತು. ಈ ಗ್ರೌಂಡ್ ಇರೋದ್ರಿಂದ ಬೇಡ ಸ್ವಾಮಿ ಅಂತ ಹೇಳಿದ್ರು. ಅವ್ರು ಯಾವ್ದು ಅಪೀಲ್ ಹಾಕಿಲ್ಲ.
ಅವ್ರು ನೀವು ದುಡ್ಡು ಕೊಟ್ರೆ ಸಾಕು ಅವ್ರಿಗೆ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು. ನೀವು ಅಪೀಲ್ ನಾವು ಅಗ್ರೀವ್ಡ್ ಇಲ್ಲ, ಕೊಡು ದುಡ್ಡು ನಮಗೆ ಆರ್ಡರ್ ಪ್ರಕಾರ ಕೊಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅಷ್ಟೇ. Have you deposited the entire amount before the commissioner? ನೋಡಿ, otherwise you appeal maintain ಆಗಲ್ಲ. ಈಗ ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ರಿ ಎಷ್ಟ್ರಿ? ಕೊಡಿ ಇಲ್ಲಿ ಅವಾರ್ಡ್ ಕೊಡಿ. ಅವಾರ್ಡ್ ಎಷ್ಟಾಗೈತಿ ನೋಡಿ. then you are deposited. You are not deposited the entire amount. Awarded amount is 2,43,456 with interest at the rate of 12%. No, law doesn't say entire amount shall be deposited and ಹೇಳ್ತದೆ. Without depositing the entire amount with accrued interest, you cannot maintain an appeal. ವೆರಿಫೈ ಮಾಡ್ಕೊಂಡು ಹೇಳಿ. ಏನೇಯೋ ಅಲ್ಲ, ಅಸರ್ಟೈನ್ ಮಾಡ್ಕೊಡ್ರಿ. ನಿಮ್ಮ ಆಫೀಸಲ್ಲಿ ಗೊತ್ತಾಗುತ್ತೆ, ಅವ್ರ ಕಡೆ ರೆಕಾರ್ಡ್ಸ್ ಇರುತ್ತೆ. ಅಲ್ಲ, ನೀವು 242 ಅಂತ ಹೇಳ್ತಿದ್ರಿ. ಅವಾರ್ಡೆಡ್ ಅಮೌಂಟ್ 243 ಇದೆ, ಪ್ಲಸ್ 12% ಇಂಟ್ರೆಸ್ಟ್ 1 month ಆಫ್ಟರ್ ದಿ ಆಕ್ಸಿಡೆಂಟ್. ಎಲ್ಲ ಇಶ್ಯೂಸ್ ಬರ್ತವೆ, ಚೆಕ್ ಮಾಡ್ಕೊಡ್ರಿ. ಈಗ ಅದು ಏನೆಲ್ಲ ಆ ಇಂಟ್ರೆಸ್ಟ್ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ್ರೆ ಇಟ್ ವಿಲ್ ಬಿ ಮೋರ್ ದನ್ 5 lakhs. Monday ಇಟ್ಟಿದ್ದೀನಿ. anyhow by that time you can ascertain it. Next.
Ramaya, Mahesh.
ಓ ಅದು ಇದನ್ನ ಸಿಡಿ ನೋಡೋದು ನೋಡ್ಕೊಳಕ್ಕಲ್ಲ ಸಿಡಿ.
Read the zone that no violation of permit. You are already covered in planning case. Not real ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಓ ಮಹೇಶ್ ವಕೀಲ್ರೆ, ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ. ಪರ್ಮಿಟ್ ಇಲ್ಲ, DL ಇಲ್ಲ, FC ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಗ್ರೌಂಡ್ ಅವ್ರದ್ದು. ಅಂಡ್ ಇನ್ಕಮ್ ವಾಸ್ ಟೇಕನ್ ಅಟ್ 15,000 ಪರ್ ಮಂತ್. ಅದನ್ನ 9,000 ರೆಡ್ಯೂಸ್ ಮಾಡ್ರಿ ಅಂತ ಹೇಳಿ ಒಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಅವ್ರದ್ದು.
10%
ಅಲ್ಲ ಅದನ್ನ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಏನದೆ ಕೊಡ್ಬೋದು, ಬಟ್ ಇನ್ಕಮ್ 15,000 ಟೇಕನ್ ಆನ್ ಹೈಯರ್ ಸೈಡ್, ಅದು 9,000 ಬರುತ್ತೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಎಕ್ಸ್ಟೆಂಟ್ ಆಫ್ ದಿ ಇಯರ್ 2015 ಅಲ್ವಾ, 9,000 ಬರುತ್ತೆ. ಅಲ್ಲ ಕನ್ವೆನ್ಷನಾಲಿಟಿ ಆಟೋಮೆಟಿಕ್ಲಿ ಆಸ್ ಪರ್ ಲಾ ಬಂದೇ ಬರುತ್ತೆ. ಇನ್ನೊಂದಿಗೆ ಎರಡು ಇಂಜುರಿ ಕೇಸು. 522/8 ಈಸ್ ಆಫ್ ಡೆತ್ ಕೇಸ್. ಡೆತ್ ಕೇಸ್ ಒಳಗೆ ಏಜ್ ಆಫ್ ಇಂಜುರಿ ಎಷ್ಟ್ರಿ? ಏಜ್ ಆಫ್ ಡಿಸೀಸ್ಡ್ 60 years. Hello, what is the document to show that deceased is aged about 60?
PM report.
ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು. PM ರಿಪೋರ್ಟ್ ಬಿಟ್ಟು ಏನು ಕೋರ್ಟ್ ಹಾಕ್ತೀರಾ, ಆಧಾರ್ ಕಾರ್ಡ್ ಹೊಡೆದಾಡ್ ತಗೊಳ್ತೀರಾ, ಅವ್ನು ಯಾವನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಲ್ಲ. PM ರಿಪೋರ್ಟ್ ಒಳಗೆ ಕಡಿಮೆ ತೋರಿಸಿದಾರ, ಇರ್ಲಿ ನನ್ಗೆ ಅನುಕೂಲ ಆಗತ್ತ ಅಂತ ಹೇಳಿ ಇಟ್ಕೊಂಡು ಕೊಡ್ತೀರಾ. ಉಳಿಕಿದವ್ರದ್ದು ಎಲ್ಲ ಕ್ಲೇಮೆಂಟ್ಸ್ ಆಧಾರ್ ಕಾರ್ಡ್ ಬರುತ್ತೆ ಎಕ್ಸೆಪ್ಟ್ ಡಿಸೀಸ್ಡ್. ಅವ್ರ ಮುಖ ನೋಡ್ತೀರಿ, ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ. ಏನ್ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿ?
By taking the national income as per the chart of the local adalats and by taking future prospects of 10%.
What is the relationship of deceased with this Danamma?
She is the wife minor.
Wife of the deceased.
Because reasonable compensation is awarded. But by taking income and lawyer paid by 8,000.
What is the nature of injury? Left femur fracture. Where is the evidence that DL permit ಇದೆ ಅಂತ ಹೇಳಿದ್ರಿ?
DL permit ಇಲ್ಲ ಅಂತ evidence ಇದೆ. How permit ಆದ್ರೂ as per
ಅದು ಮುಂದಿಂದು ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರಿ ಅವೆಲ್ಲ ಬರೋಲ್ಲ DL ಇದೆ ಅಂತ ಹೇಳಿದ್ರಿ. ಹಾ DL ಇಲ್ಲ ಅಡ್ಮಿಟ್ ಮಾಡ್ತೀರಾ DL ಇಲ್ಲ ಅಂತ ಹೇಳಿ.
Not placed before the court below my lordship. Not documented that not permit.
No DL, no permit, no FC.
Contention of insurance company, there is no DL, there is no permit.
ಇಲ್ಲಿವರೆಗೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ಲ. ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅದನ್ನ ಸಿಕ್ಕಾಪಟ್ಟೆ ಹಾರ್ಪ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಇಷ್ಟು ವರ್ಷ ಆದ್ರೂ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ತಾ ಇಲ್ಲ ನೋಡಿ ಸರ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಎಷ್ಟು ಮಟ್ಟಿಗೆ ಸುಳ್ಳು ಇರ್ಬೇಕು ಈ ಕೇಸ್ ಅಂತಾರ ಅವರು. ಅವ್ರ ಪ್ರಕಾರ ಅಲ್ಲ ವಾಟ್ ಎವರ್ ಇಟ್ ಬಿ, ಬಟ್ ಒನ್ ಥಿಂಗ್ ಈಸ್ justified that the charge sheet is still not submitted.
Maybe at the time of filing the using the evidence, charge sheet may not be filed against the driver of the offending vehicle.
ಈ ಫೈಲ್ ಮಾಡಿದಾರ ಅಂತೀರಾ?
ಗೊತ್ತಿಲ್ಲ ಸರ್.
ಮತ್ತೆ ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ರು, ಇವತ್ತಿನಿಗೂ ಫೈಲ್ ಮಾಡಿಲ್ಲ ಅಂತೀರಾ ಅವ್ರ ಕಂಟೆನ್ಷನ್.
There is very clear there is a ration negligence part of the offending vehicle and death is due to the negligence of the driver of the offending vehicle. Insurance policy was in force at the time of accident. These are all the issues are not included by the insurance. The third party. While in a auto rickshaw.
Two claimants, huh? One is death, the other is injury.
One is death, another is three claimants is death case, my lord.
No, claimants necessarily two cases.
Yes. The 130 by 2006.
One is Bharat is the claimant.
And after two daughters.
ರಾತ್ರಿ 8 ಗಂಟೆಗೆ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದೆ. What is the status of claimants 2 and 3 daughters, sir?
minor. I also filed an appeal. And appeal carried.
ಎಲ್ಲಾ ಮುಗಿದ್ಮ್ಯಾಗ ಹೇಳ್ತಿರಲ್ರಿ. ಇಲ್ಲಿವರೆಗೆ ಹೇಳಿಲ್ಲಲ್ರಿ, 2 ಟ್ಯಾಗ್ ಆಗಿದಾವೆ. ಯಾವ್ದು ನಿಮ್ಮ ಅಪೀಲ್ ನಂಬರ್? 2328/21. I am not concerned. ನಾನು ತೊಗೊಳಕ್ಕಾಗಲ್ಲ. This court doesn't have any jurisdiction regarding 21 matters. Roster ನನಗಿಲ್ಲ. I have got roster 17 to 19 only. I cannot direct also. You will have to move to the concerned court. ನಾನು ಏನನ್ಸಾಗ ಆಗೋದು ನೋಡೋಣ ಅದ್ರಾಗ. ಕರೆಕ್ಟ್, ನೀವು ಅಪೀಲ್ ಮಾಡ್ಲಿಲ್ಲಲ್ಲ. ಕರೆಕ್ಟ್, ನೀವು ಅಪೀಲ್ ಮಾಡಿದಿರಿ. ಈಗ ಅಪೀಲ್ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ ಡಿಲೇ ಇದೆ, ಡಿನೈಲ್ ಆಫ್ ಇಂಟ್ರೆಸ್ಟ್ ಎಲ್ಲ ಬರುತ್ತೆ. ಅದಕ್ಕೆ ನಾಟ್ ಪ್ರೆಸ್ ಮಾಡ್ತೀನಿ, ಇದ್ರೊಳಗೆ ಎನೌನ್ಸ್ ಮಾಡ್ಬೇಕಂತ ಹೇಳಿದ್ರಿ. ಸಿ ನಾವು ಹುಕ್ಕಿಲ್ರಿ, ಇವೆಲ್ಲ ನಮಗೂ ಟ್ರಿಕ್ಸ್ ಎಲ್ಲ ಅಷ್ಟು ಅರ್ಥ ಆಗಲ್ಲ. ಬಟ್ ದಿ ಥಿಂಗ್ ಇಸ್, ಯು ಶುಡ್ ಹ್ಯಾವ್ ಸಬ್ಮಿಟೆಡ್. ಯು ಕುಡ್ ಹ್ಯಾವ್ moved before that court, because I cannot direct. That court should pass an order having a roster. That bench should pass an order having a roster to place it before the CJ for appropriate orders. It is not in my hands. You ಮಾಡಿಸ್ಕೊತಿದ್ರೆ ನಂದು I don't have any objection. Move ಮಾಡಿ ಮಾಡಿಸ್ಕೊತಿದ್ರೆ ಮಾಡಿಸ್ಕೊಡ್ರಿ. ನಾನು ಇಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ ಅಲ್ಲಿ ಅಪೀಲ್ ಮಾಡಿದ ನಾಲೆಜ್ ಇದ್ದಾಗ ನಾನು ಇದನ್ನ ಸ್ಟೇಟ್ ಆಫ್ ಡಿಸ್ಪೋಸ್ ಮಾಡೋದು ತಪ್ಪಾಗುತ್ತೆ. ಅದನ್ನ ನಾಟ್ ಪ್ರೆಸ್ ಮಾಡ್ರಿ, ಇಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತೀನಿ. ಬಟ್ ಆ ಪೀರಿಯಡ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಡೀಟೇಲ್ಸ್ ಮಾಡಿ, even if you are entitled for announcement, then it will have to be considered. Here announcement ಆಗುತ್ತಾ ಅನ್ನೋದು ನನಗೆ ಡೌಟ್. ಒಂದೇದು 15,000 ತಗೊಂಡಿದ್ದು ಮತ್ ನಿಮ್ದೇನಿದೆ ಇನ್ 10%. ಆದ್ರೆ ನಿಮ್ಗೆ ಸ್ಯಾಲರಿನ 1/3 ಇಳಿತದೆ ಇಲ್ಲಿ 10%, ಮ್ಯಾಕ್ಸಿಮಮ್ 10% ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್. ಬಿಕಾಸ್ ಏಜ್ ಇಸ್ 60. ಆಕ್ಚುಲಿ ಅದು ಬರಲ್ಲ, ಆಕ್ಚುಲಿ ಏಜ್ ಇಸ್ ಮೋರ್. ನೀವು ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಯಾಕಂದ್ರೆ ನಾವು 60 ಕ್ರಾಸ್ ಆಯ್ತು, ಫಿನಿಶ್, ಈಸ್ ಔಟ್ ಆಫ್ ದಿ ಕೋರ್ಟ್. ರಿಗಾರ್ಡಿಂಗ್ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ ಬರಲ್ಲ. ಎನೌನ್ಸ್ಮೆಂಟ್ ಆಗುದಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ನೀವ್ಯಾಕೆ ಅಪೀಲ್ ಹಾಕಿದಿರಿ? ಅಲ್ಲ, ಎದಕ್ಕೆ ಅಪೀಲ್ ಹಾಕಿದ್ರಿ? ಎನೌನ್ಸ್ಮೆಂಟ್ ಆಗುದಿಲ್ಲ ಅಂತ ಗೊತ್ತಿದ್ರು. ಇದ್ರ ಕ್ರಾಸ್ ಅಪೀಲ್ ಹಾಕಲ್ದಾದ್ರು ಎನೌನ್ಸ್ಮೆಂಟ್ ಯಾಕೆ ಹಾಕಿದ್ರಿ? ಮುಂದೆ ಆ ಸೈಟೇಷನ್ ಆಗಿ ತಗೊಂಡು ಬಂದ್ರಿ, ಎನೌನ್ಸ್ಮೆಂಟ್ ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿ. ದಟ್ ಸಿ ರೀಕ್ಯಾಲ್ಕುಲೇಷನ್ ಒಳಗೆ ನಾವು ಎಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕು. ದರ್ ಇಸ್ ಅಬ್ಸಲ್ಯೂಟ್ಲಿ ನೋ ಇಶ್ಯೂ. ದಟ್ ವಿಲ್ ಹ್ಯಾವ್ ಟು ರೀಕ್ಯಾಲ್ಕುಲೇಟ್ ಆಗ್ಬೇಕು. ಆದ್ರೆ ಎನೌನ್ಸ್ಮೆಂಟ್ ಆಗತ್ತಾ? ಆಗಲ್ಲ. ವಾಟ್ ಈಸ್ ದಿ ಇನ್ಕಮ್? 9,000 9,900 into 12 into 9 ಎಷ್ಟಾಯ್ತ್ರಿ? ಸಾರಿ, into 1/3. Actually 1/3 doubtful, because they are married daughter, they are not residing with him. 50% deduction ಆಗುತ್ತೆ ನಿಮಗೆ. They are married daughter. The latest decision ಹೇಳ್ತಾರೆ, if they are residing together, then a dependency ಅವನ್ ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕು. They are residing with their in the respective husband's house. In that event ಇನ್ನೂ ಕಡಿಮೆ ಆಗುತ್ತೆ. ಬಟ್ 10% ಫೋರ್ಗೋ ಮಾಡಿ. ಇನ್ನೂ ಕಡಿಮೆ ಆಗುತ್ತೆ. ಅಲ್ಲ, 1/3 ಮಾಡೋದಾದ್ರೆ 10% ಫೋರ್ಗೋ ಮಾಡ್ರಿ. ಎಲ್ಲಾ ಬೆನಿಫಿಟ್ ಬೇಕನ್ನಂಗಿಲ್ಲ. ದಿ ಪಬ್ಲಿಕ್ ಮನಿ, ಅದು ವಿ ಆರ್ ಸಪೋಸ್ ಟು ಕನ್ಸಿಡರ್ ಇಟ್. ಇಗ್ನೋರ್ ಮಾಡಕ್ ಬರಲ್ಲ. ಇದೆಷ್ಟು ನೋಡ್ರಿ, 9,000 into 12 into Sir, 9,900 into 12 into 9 into 2/3 ಎಷ್ಟಾಗತ್ತೆ ನೋಡಿ?
Before the 15, it was granted 10 lakh. The convention net, German was.
712,800, 132, 1,32,000, 16,500 plus 15,000. ಅದನ್ನ 50% ಮಾಡಿದ್ರೆ
ಈ ಕೇಸಲ್ಲಿ ನನ್ನೇನು ನೋಟ್ ಇಲ್ಲ, ಕಡಿಮೆ ತಗೊಂಡಿದ್ದೆ ನಾನೇ. ಐ ಆಮ್ ನಾಟ್ ಪ್ರಿಪೇರ್ಡ್. 2,000 ತಗೊಂಡಿದ್ದಾರೆ. I'm taking 9,000.
These appeals filed by the insurance company challenging the judgment and award passed in motion number 130 of 2016 and 131 of 2016 on the file of second additional senior civil judge and university chief review dated 26th January 2018. Yagridu 26th January, how here the judgment is pronounced? 26th January, how judgment is pronounced? It being a holiday. 26th February 2018. January ಅಂತ ಹೇಳಿ ಇದ್ರೊಳಗೆ ಬರ್ದಿದ್ದಾರೆ ಅವರು. The factual matrix leading to the case are as under. That on 11/2/2015 at 8 p.m. deceased was proceeding in auto bearing registration KA 465727 as a passenger along with others from Kalsapura to Belawadi. The respondent was driving the auto and he drove the auto in a rash and negligent manner with excess speed. As a result, the vehicle capsized into Belawadi tank. The deceased sustained fatal injuries and succumbed on the spot. The other claimant, Bharat, sustained injuries and the extent is because of actionable negligence on the part of the driver of the offending vehicle. Hence, the legal heirs of deceased Ningegowda and the injured claimant Bharat filed claim petitions seek under section 166 of the MA Act claiming compensation. The respondents contested the matter and disputed actionable negligence on the part of the driver of the offending vehicle. The respondent number 3 the learned counsel for respondent number 3. The respondent number 3 has raised objection contending that the driver, the person driving the vehicle has no relation in force as on the date of the accident to drive the vehicle, and he was not possessing valid defective driving license. It is also asserted that there is breach of policy conditions and breach of permit also, as excess passengers have been transported in the vehicle. Would also contend driver of the auto rickshaw was a necessary party, and in his absence, the matter cannot be effectively disputed. Hence, the respondent number 3 has also taken other statutory defenses and sought for dismissal of the claim petition. After hearing the arguments and perusing the after assessing the oral and documentary evidence and perusing the records, the tribunal has awarded compensation of rupees 1,35,000 with interest at the rate of 8% to the claimants in emission number 130 of 2016 and 2,81,420 in respect of claimant in emission number 131 of 2016. The tribunal has further fastened the liability on respondents 1 to 3 jointly and severally. For the arguments being agreed by this judgment in award, the insurance company has filed these appeals challenging the liability as well as quantum. Third, the arguments advanced by the learned counsel for appellant and learned counsel for respondents perused the records. The main contention of the learned counsel for appellant is that there is no permit, no DL and no FC to the vehicle, and driver was not made as a party. But the said contention cannot be not made as a party. He would further contend that the income taken at 15,000 per month is on higher side in case of deceased, and interest awarded is also on higher side. He would also contend that till today charge sheet has been, is not at all submitted, and it appears to be a false claim. Hence, he would seek for allowing the appeal. In case of injury, next one. In case of injury, it is contended that the injured was alleged to be aged about 17 years and the disability taken at 8.6% is on higher side. Hence, he would seek for reduction of the compensation in this case also, in case the insurance company is held liable. The learned counsel for respondent claimants would support the judgment and award passed by the tribunal. However, he fairly concedes that income is taken on higher side and a notional income at 9,000 may be taken and future prospects of 10% may be added considering the age, and hence he would seek for dismissal of MFA five double 228. He would further contend that as regards in case of injury, the compensation awarded is reasonable one, and there is no issue of enhancement also, and as such, he would seek for dismissal of both the matters. Having heard the arguments and after perusing the records, it is evident that the insurance company is half-heartedly disputing the extent. It is argued that the involvement of the vehicle itself is doubtful, and it is asserted that it appears to be a false claim. But the records disclose that the extent has occurred on 11/2/2015 at about 8 p.m. and the complaint was lodged at night at 10:30 p.m. on the same day. Further, this defense is not taken specifically in the objection statement. Even RW1 was examined on behalf of insurance company has not stated so in his evidence. Hence, the said contention cannot be accepted. The other contention regarding false claim is charge sheet is being not yet submitted, but mere non-submission of charge sheet does not amount that it is a false claim. Further, submission of the charge sheet is not within the hands of the claimants, and the issue is only involvement of the vehicle in the extent, and the prima facie all the material documents clearly establish that the offending vehicle was involved in the extent. Hence, the said arguments also does not survive for consideration. Next, the other argument is regarding non-possessing of BL permit and FC, but the insurance company has not made any attempt to prove this aspect, except taking a bald assertion in this regard. No material is placed on record by the insurance company. On the contrary, RW1, an officer of the insurance company, in his cross-examination, has clearly admitted that at the time of the accident, the respondent number 1 was possessing valid and effective driving license. When further, the RW1 admitted that they have got investigated the matter from one Sumati but the said investigation report is not placed on record. There is no explanation as to why the said investigation report is withheld if at all the vehicle was not possessing valid FC or permit. There is no dispute regarding coverage of the policy, and if at all there is no FC, the insurance company is required to answer why they have issued a policy in respect of the vehicle which is not having a fitness certificate. The fact that the policy has been issued presupposes that the insurance, because of the fitness certificate only, policy has been issued. Hence, the said arguments advanced by the learned counsel for appellant holds no water at all. Next. Now coming to the quantum in MFA 5228 arising out of MEC 130 of 2016. Admittedly, the deceased was aged about 60 years as on the date of accident, which is not under serious dispute. Further, he succumbed on the spot. The claimant is the widow and two married daughters. The accident has occurred in 2015, merely only on the basis of oral statement. A PW1, the tribunal has taken the income of the deceased at 15,000 per month. There is no material evidence, and merely because he is possessing agricultural lands, it does not mean that he was earning rupees 15,000 per month. Further, the agricultural lands continue to be owned by the legal heirs, and hence the tribunal has erred in taking the income at 15,000 on higher side. Since the accident has occurred in 2015, this court is consistently taking the notional income at 9,000 per month in the absence of any material evidence. Hence, income is required to be taken at 9,000 as against 15,000 taken by the tribunal. Since the deceased was aged about 60 years, 10% of future prospects are required to be added. If the income is taken at 9,000 and 10% future prospects are added, then the monthly income would be 9,900. Considering the age of the deceased, multiplier 9 is applicable. Since there are 3 dependents, 1/3 is to be deducted towards personal expenses. Hence, he would have contributed 2/3 towards the family. Considering these aspects, loss of dependency would work out as 9,900 into 12 into 9 into 2/3, 7,12,800. There are 3 claimants, that is the widow and 2 daughters. Each of them are entitled for sum of rupees 44,000 under the head of consortium. Hence, claimants as per decision report and source. As such, the claimant should be entitled for rupees 1,32,000 under the head of consortium, loss of consortium. Further, they are entitled for 1,16,500 under the head of loss of estate and 15,000 under the head of funeral expenses. As such, claimant should be entitled for total compensation of 8,76,300 as against 11 lakhs. Correct entry? 8,76,300 as against 11,35,000 awarded by the tribunal. The tribunal has also awarded interest at the rate of 8%, which is on higher side. And this court is consistently awarding interest at the rate of 8%, 6%, considering the prevailing FD rates. Hence, interest is required to be reduced from 8 to 6%. Next. ನೀವು ಹೋಗ್ರಿ, ನೀವು ಹೇಳಿದ್ರಲ್ಲ ಹೋಗ್ಬಿಡಿ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. As regards MFA, 52229 regarding injured claimant appellant Bharat, the tribunal has awarded total compensation of rupees 2,81,420 under following heads. The judgment page number 32, 33 ಒಳಗಿದೆ ನೋಡಿ. 987. Admittedly, the claimant was aged about 17 years. Also future ಇನ್ಕಮ್ ಎಷ್ಟು ತಗೊಂಡಿದಾರ ವಕೀಲರಲ್ಲಿ ಎಲ್ಲಿದೆ, ಯಾವ ಪ್ಯಾರ ಒಳಗೆ ಹೇಳ್ತಾರೆ? ಪ್ಯಾರ 53 ನಾ? The tribunal, after assessing evidence of the medical officer, has taken the disability. What is the nature of injury? ಡಿಸಬಿಲಿಟಿ ಕೇಳಿಲ್ರಿ, ನೇಚರ್ ಆಫ್ ಇಂಜುರಿ ಏನು ಅಂತ ಕೇಳಿದೆ ನಾನು. ಎಲ್ಲಿಯೂ ಬರಲಿಲ್ಲ. The claimant has suffered fracture of right femur and PW3 has assessed a disability to the limb to the extent of 25.8%. The tribunal, considering this aspect, disability was taken at 8.6% to the whole body. Considering the fracture to the femur, the disability taken by the tribunal cannot be said to be on higher side. Next. Apart from that, the tribunal has taken the income of the claimant as 8,000 considering his age. The learned counsel for claimant would submit that he is not disputing this aspect. Hence, the tribunal has awarded 1,48,608 under the head of loss of future earning on account of permanent disability, which it does not call for any interference. Further, towards hospital charges, tribunal has awarded 9,875 as per records, and under the head of nourishment, diet, food, etc., it has awarded rupees 30,000. Towards loss of earning period during treatment, it has awarded 2,937, and towards pain and suffering 30,000, and towards conveyance 30,000 was awarded. Further, additional compensation of 30,000 was awarded towards amenity, loss of amenities, and 30,000 is awarded towards future medical expenses. There is no material evidence to award compensation under the head of nourishment and diet 30,000 and conveyance charges again 30,000 in the absence of any material evidence. Hence, under the head of conveyance charges, claimant would be entitled for only 10,000, and in the absence of any material evidence under the future medical expenses, claimant would be entitled for only 15,000. Hence, the claimant would be entitled for total compensation of rupees as under 98 medical, 9,875 nourishment and diet, 30,000 loss of earning during period 2,937, pain and suffering 30,000, conveyance charges 10,000, loss of earning 148,608, amenities 30,000, future medical expenses 15,000. Since claimant would be entitled for total compensation of rupees so and so as against 2,81,000 awarded by the tribunal. The interest awarded by the tribunal is 8%, which calls for interference, as this court is consistently awarding interest at the rate of 6%. Hence, both the appeals need to be allowed in part, and accordingly, I proceed to pass the following. The appeals filed by the claim insurance company are allowed in part so far as they relate to quantum only. Net. The claimant respondent in MFA, first case, MFA. $5,229, the claimant would be entitled for total compensation of 8,76,300 as against 11 lakhs so and so awarded by the tribunal, with interest at the rate of 6% on the entire compensation of rupees 8,76,300. The MFA, in MFA so and so, the injured claimant appellant is held entitled for so and so as against so and so awarded by the tribunal, with interest at the rate of 6% on the entire compensation awarded. The insurance company is directed to deposit the entire compensation with accrued interest thereon within a period of 6 weeks from the date of receipt of the deposit disbursement and the apportionment, deposit and disbursement shall be as per the terms of the order of the tribunal. The statutory deposit made by the tribunal shall be transmitted to the ಅಲ್ಲ ನೀವೇ ನಿನ್ ಹೇಳಿದಿ ಸಿಡಿ ನೋಡ್ತೀನಿ ಅಂತ ನಿಮಗೂ ಅಪಾರ್ಚುನಿಟಿ ಕೊಟ್ರಿ ಸಿಡಿ ನೋಡ್ರಿ ಇಟ್ ಮೇ ಗೋ ಅಗೇನ್ಸ್ಟ್ ಯು ಅಂತ ಹೇಳಿ. ಅಲ್ಲ ಇಟ್ ಮೇ ನಾನೇನ್ ಐ ನಾಟ್ ಯೆಟ್ ಓಪನ್ ಏನ್ ಅನಿಸ್ತದೆ ನೋಡಿದೀನಿ ಇಟ್ ಹ್ಯಾಲ್ ಟು ಬಿ ವೆರಿಫೈಡ್ ಕ್ಲಿಯರ್ಲಿ. ಅದಕ್ಕೆ ಐ ವಾಂಟೆಡ್ ಟು ಹಿಯರ್ ಯು. ಸರಿ ಮಂಡಿ ಆಯ್ತಾಯ್ತು ಆಯ್ತು. ಎರಡೂವರೆ. The MFA 4913 of 2017 filed by the insurance company is allowed in part insofar as it relates to interest by reducing the rate of interest from 7.5 to 6% per annum. MFA 8204 of 2017 is allowed in part judgment and award dated 23/2017 passed by MACT Chitradurga and emission 95 of 2015 is modified. The claimant appellant is held entitled for total compensation of rupees 9,49,100 as against 7,28,600 awarded by the tribunal. The entire compensation of 9,49,100 rupees shall carry interest at the rate of 6% per annum from the date of petition till its realization. The appellant in MFA 4913 is directed to pay the entire enhanced compensation with accrued interest thereon within 6 weeks from today. The entire enhanced compensation with accrued interest shall be released in favor of the claimant. The amount in deposit shall be transmitted to the tribunal.
And in the 42, the answer the respondent number 1 will have been directed to pay the appellant has not a copy of the same amount. 2017 matter.
ಅಲ್ಲಿ ಬಂದಾಗ ನೋಡ್ತೀನಿ actually.
Dr. Pratap Singh.
Connect ಆಗಿದೆ. ವಿಶಾಲ್ ಪ್ರತಾಪ್ ಸಿಂಗ್ ನೋಡೋಣ ಬರ್ತಾರೆ ನೋಡೋಣ ಕೆಲವರು ಕನೆಕ್ಟ್ ಆಗಿಲ್ಲ ಅವರು ಕಲಬುರ್ಗಿ ಅವರು.
Second clear?
Already the first matter. Also, get there in the second matter. First matter is category insurance. Proceeding liability. Second matter, that is loss of petition is filed for enhancement.
Yes.
And so far as enhancement is concerned, the facts that are read in the case Melody. 13/1/2018 Melody is the date of the accident. The deceased is one Srinivasa, was working as a tractor loader and unloader. There was an accident and therefore he passed away. He was aged 26 years, the time of his death. The mother has filed the claim. The amount that is awarded is at page number 10, internal page number 10 of the award.
Yes.
His monthly income is taken as 8,000. It is on the lower side.
Yes.
Idol prakara 12,000.
Yes.
Then 50% is deducted towards personal expenses. And thereafter
Is
40%.
there any illegality? 50% deduction in case of bachelor. Yes. Your only ground is regarding income.
Conventional heads is ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಕೊಡಬೇಕು.
ನೀನ್ ಜಾಸ್ತಿ ಏನಕ್ಕೆ ಒಂದು 15-20,000 ರೂಪಾಯಿ ಎಕ್ಸ್ಟ್ರಾ ಆಗುತ್ತೆ. 29,000 ರೂಪಾಯಿ ಎಕ್ಸ್ಟ್ರಾ ಆಗುತ್ತೆ. ಅವೇನೇ ಹೆಚ್ಚಿಗೆ ಆಗಲ್ಲ. ಲವ್ ಅಂಡ್ ಅಫೆಕ್ಷನ್ 15,000 ಇದ್ದಲ್ಲೇ ಕನ್ಸೋರ್ಟಿಯಂ ಕೆಳಗೆ 44 ಬರುತ್ತೆ ಅಷ್ಟೇ. ಬೇರೆ ಏನು ಚೇಂಜ್ ಆಗಲ್ಲ ಅದರಲ್ಲಿ. Now liability.
Liability, what they would say is, someone working as a tractor was traveling.
Question is whether he was working in a tractor and loader. That is a different thing. The allegation is that he was sitting in the tractor, traveling in the tractor. He is harping that point and he is placing reliance on a full court bench edition of this court.
ನೋಡ್ತೀನಿ, but ಅದರಲ್ಲಿ ಇರೋದು he was a gratuitous passenger.
No, he was traveling on a mudguard. And there is a specific observation in the said case that tractor is meant for one traveler, only one person, that is driver. Except driver, any third person cannot travel. Even gratuitous passenger or paid passenger doesn't arise. Tractor is meant for only one person. That is the driver of the tractor. That was the observation of the full court. ಬಿಡಿದಿರಿ ನೀವು 3 ದಿನ ಆಯ್ತು ಇಲ್ಲೇ ಇಟ್ಕ ಟೈಮ್ ತಗೊಂಡು ಹೋಗ್ತಾ ಇದ್ದೀರಿ, ಬರ್ತಾ ಇಲ್ಲ, ಪಾಸ್ವರ್ಡ್ ಮಾಡಿಸ್ತೀರಿ, ಬರಲ್ಲ. ನಮ್ಮಲ್ಲಿ ರೀಚ್ ಆಗಿದೆ ವಕೀಲ್ರೆ, ನಮ್ಮಲ್ಲಿ ರೀಚ್ ಆಗಿಲ್ಲ ಅಂತ ಯಾವ್ದು ರೀಚ್ ಆಗಿದೆ. That is not the ground. ನೀವು ಪಾಸ್ವರ್ಡ್ ಮಾಡಿಸ್ಕೊಂಡ್ಮೇಲೆ is it not your duty to attend? ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ಕೊಂಡು third time I am adjourning it.
Traveling in Madgaon is not.
ಅಲ್ಲ ಮಡ್ಗಾಡ್ ಅಂತ ಇಲ್ಲ, ಟ್ರಾವೆಲ್ ಮಾಡಕ್ ಅವಕಾಶ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಫುಲ್ ಬೆಂಚ್ ಎಡಿಷನ್. Tractor is meant for only one person to travel, that is the driver. Except driver, no third person can travel. That was the full bench edition. No pay and recovery ಬರೋಲ್ಲ, ಅದ್ರ ಪ್ರಕಾರ ಆ ಡಿಸಿಷನ್ ಪ್ರಕಾರ ಪೇ ಅಂಡ್ ರಿಕವರಿ ಇಲ್ಲ. ಟೆಕ್ನಿಕಲ್ ಕಂಟೆನ್ಷನ್ ಅಲ್ಲ ಇದು. ದಿಸ್ ಇಸ್ ನಾಟ್ ಎ ಡಿಎಲ್ ಇಲ್ಲ ಅಂತಿಲ್ಲ, ಪಾಲಿಸಿ ಕಂಡೀಷನ್ಸ್ ವೈಲೇಷನ್ ಅಲ್ಲ. Therefore, the apex court has held, ನಮ್ ಕೋರ್ಟ್ ಫುಲ್ ಬೆಂಚ್ ಹೇಳಿದೆ, it is not a case of pay and recovery. It is clear violation of the conditions by the tractor owner. He has to face the consequences.
Insurance company can recover from the tractor.
Why should be saddled with liability on insurance company ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು. ನೀವು ಓನರ್, ನೀವು ಡ್ರೈವರ್, ನೀವು ಹತ್ತವನು ತಪ್ಪು ಮಾಡ್ತಾನೆ, he is no right to travel in a tractor. Not a ground Allah.
It is not a ground, but since it is social legislation.
But if that is the ಎಲ್ಲಾದ್ರೂ ಪೇಮೆಂಟ್ ರಿಕವರಿ ಮಾಡ್ಕೊತ ಹೋದ್ರೆ, there is no control over the breach of the policy conditions. Anybody can breach it, pay it, then will come to see it. ಅಷ್ಟೇ ಆಗುತ್ತೆ. ಹೌದಾ? Everybody will start doing the same thing. ಯಾಕಂದ್ರೆ ಈಗ certain decisions are now for that purpose only refer to a larger bench.
Looking at the practical difficulties that submissions are made.
ಏನು ಟ್ರ್ಯಾಕ್ಟರ್ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಮಾಡಿಕೊಡ್ಬಿಟ್ರಿ, ಬಂದ್ ರಜೆ ಇರ್ತಾನ. ಟ್ರ್ಯಾಕ್ಟರ್ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಅದನ್ನ ನೀವ್ ಯಾಕೆ ತಲೆ ಕೆಡ್ಸ್ಕೊತೀರಿ? ನಾವು ತಲೆ ಕೆಡ್ಸ್ಕೋಬೇಕಾಗಿದ್ದು. ಒಂದ್ ಟ್ರ್ಯಾಕ್ಟರ್ ಅದ ಅಂದ್ರೆ ಒಂದ್ ಜಮೀನ್ ಇದೆ, ಜಮೀನ್ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಮಾಡಿಸ್ರಿ, ಒಂದ್ ಕೇಸ್ ಒಳಗೆ ಮಾಡಿಸ್ರಿ, ಒಂದ್ ಕೇಸ್ ಒಳಗೆ ಮಾಡಿಸ್ರಿ ಸಾಕು. ಬ್ರೀಚ್ ಮಾಡೋರು ಸ್ವಲ್ಪ ಅಲರ್ಟ್ ಆಗ್ತಾರೆ. ಇಲ್ಲೇನಾಗತ್ತ, ರಿಕವರಿ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿ ಬಂದಾಗ ನೋಡೋಣ, ಅಷ್ಟೊತ್ತಿಗೆ ಏನೇನೋ ಗದ್ದಲ ಹಾಕ್ತಾರೆ. ಮತ್ತೆ ಮ್ಯಾನೇಜ್ ದಿ ಥಿಂಗ್ಸ್. We are dealing with breach of policy condition in a casual way. The person who breaches should feel the heat. He should feel the heat. When he is purchasing a vehicle, he is responsible to take all precautions. Alva.
For the victim,
in submission, there is no issue. Enhancement agate, absolutely no issue. But liability, his appeal needs to be allowed. He is least interested about enhancement. Except liability is least interested in any other matters. ನೀವು ಬೇಕಾದಷ್ಟು ಕೊಟ್ಕೊಡ್ರಿ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು. And I think owner has not represented. ಮತ್ತೆ ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
ಓನರ್ ಒಂದ್ಸತಿ ಸರ್ವಿಸ್ ಹೇಗಿದೆ ನೋಡ್ಬಿಟ್ರೆ
ಸರ್ವಿಸ್ ಆಗಿದ್ದದೆ.
ಸುಮಾರು ನಮ್ಗೆ ಈ ತೊಂದರೆ ಏನು ಅಂದ್ರೆ ನಮ್ಗೆ ಇಲ್ಲಿ ಸಾವು ಆಗಿ ಕಾಂಪನ್ಸೇಷನ್ ಬರ್ದೇ ಹೋದ್ರೆ ಅಂತ ನಮ್ಗೆ ಕನ್ಸರ್ನ್ ಅನ್ಸುತ್ತೆ.
He is represented by the council, R. Vijay Kumar. He is represented by the council. He has appeared. Even then, he is so casual. ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ಈಗ ನಾವು ಬಂದು ಭೇಟಿನ ಆಗೋದಿಲ್ಲ. ವಕೀಲರಿಗೆ ಕೊಟ್ಟಿವಿ, ಎಲ್ಲ ವಕೀಲರದೇ ಹೋಲ್ಸೇಲ್
Including compensation.
ಎಲ್ಲ ಬೇಕಾದ್ರೆ ನೀವೇ ಕೊಟ್ಕೊಳ್ರಿ ನಮ್ಗೆ ಸಂಬಂಧ ಇಲ್ಲ ಅಂತ. ದಿಸ್ ಮೆಂಟಾಲಿಟಿ ಇಸ್ ಡೆವಲಪ್ಡ್ 100%. ಎಸ್ಪೆಷಲಿ ನಿಮ್ಮ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಒಳಗೆ ಒಮ್ಮೆ ವಕೀಲರಿಗೆ ಕೊಟ್ಬಿಟ್ರೆ ಮುಗಿದೋಯ್ತು. ಎಲ್ಲ ಹೋಲ್ಸೇಲ್ ವಕೀಲರಿಗೆ ಬರಲ್ಲ. ಏನು ಉಪಕಾರ ಮಾಡಕ್ ಕೇಸ್ ಕೊಟ್ಬಿಟ್ರೆ ಉಪಕಾರ ಆಯ್ತದ ಅವ್ರಿಗೆ. ನಿಮ್ ಕೊಟ್ಟಿದ್ದೀವಿ ನೀವೇ ಮಾಡ್ಬೇಕ್ರಿ ಅಂತ ಸಾಕ್ಷಿನೂ ನೀವೇ ಹೇಳ್ರಿ. ಆ ಸ್ಟೇಜ್ ಬಂದಿದ್ದೀವಿ. What is the difficulty of the advocate? How can he prosecute unless without there being a proper assistance, instructions ಬೇಕು, relevant documents ಕೊಟ್ಟು ಅಸಿಸ್ಟ್ ಮಾಡಬೇಕು, so that he can take a proper defense. ಏನಿಲ್ಲ, ಕೊಟ್ಬಿಟ್ಟು ಮುಗಿದೋಯ್ತು. ಎಲ್ಲ ನಿಮ್ದೇ ಹೋಲ್ಸೇಲ್. ದುಡ್ಡು ಬಂದ್ರೆ ನಮಗೆ, ಇಲ್ದೇ ಇದ್ರೆ ಎಲ್ಲ ನಿಮ್ದು. ಆ ಮೆಂಟಾಲಿಟಿ. These two appeals are filed. These appeal and cross MFA CROB are filed against the judgment and decree, judgment and award passed in Innovation number 453 of 2018 on the file of 6th Additional Session Judge Tumkur, dated 5th July 2019. The MFA 8261 of 2019 is filed by the insurance company challenging the liability, while MFA Cross 35 of 21 is filed by the claimants seeking enhancement. For the sake of convenience, parties herein are referred with the original ranks occupied by them before the tribunal. The brief factual matrix leading to the case are that on 13/1/2018 at 6 AM, deceased Srinivas and one Lokesh were proceeding for work, that is to load the tractor and unload. And driver of the said tractor and trailer bearing AA 52T 1439 and 1440 drove it in a same as load the same in a rash and negligent manner. As a result, the deceased fell down from the tractor and sustained severe injuries and died on the spot. After conducting in this regard, the claimant, being the mother of the deceased, filed claim petition under section 166 of MU Act, claiming compensation of rupees 35 lakhs. The insurance the respondents 1 and 2 have appeared and contested the matter and denied the allegations and assertions made thereunder. The respondent number 2, insurance company, has specifically denied, has specifically contended that as per the claim, the claimant, the deceased as well as injured Lokesh were traveling in the tractor and fell from the tractor, sustaining fatal as well as other type of injuries. He would also contend that in the own certificate there is a reference of self-fall, and hence he would contend that there is a breach of policy conditions. And in this regard, he contend that when the claimant, the deceased, is traveling in the tractor, the liability is not covered, and hence he would seek for allowing his appeal by exonerating the liability to pay the compensation. Per contra, the learned counsel or respondent, that is appellant in MFA Crop 35/21, contended that The deceased was aged about 26 years and income was taken at 8,000, which is on lower side, and it ought to have been taken at 12,500. He would also contend that under the conventional head, proper compensation is also not awarded. He would further assert that though the deceased was alleged to be traveling in the tractor, at least the order regarding pay and recovery may be passed, considering the difficulty in recovering the amount from the owner. Next. Having heard the argument, perishing the reports, it is evident that the deceased, while traveling in the tractor, fell from the tractor and suffered previous injuries, fatal injuries, and succumbed because of the injuries. The complaint is marked at Exhibit P3, and there is a specific assertion that the deceased and one Lokesh were traveling in the tractor. The tractor is meant for only a driver, and there is no scope for any other passenger to travel in a tractor. It is alleged that the driver of the tractor suddenly taken a turn. As a result, the deceased as well as Lokesh fell from the tractor and suffered injuries.
Not there in the written statement. The appeal and actual.
Nothing. Nothing. But that is a legal issue, alva?
What goes against me?
Legal issue.
What goes against me? Factor one day seat adana deny madakagalla. Fact is, if they have not denied it specifically on that ground.
Deny madabekagilla. What is the legal position?
The legal position will follow if they have taken that contention.
So do you mean to say that even if a law is not pleaded and if law does not permit, since it is not pleaded, it is to be ignored?
On this ground, I am not liable annadaru beku anta helodu.
Not acceptable, sir.
Adu evidence lead madlilla anno prashne bere. Nanu ಹೇಳ್ತಾ ಇರೋದು on this ground, liability is.
I'll answer you.
ಅವ್ರು ಹೇಳೋದು ಏನು ಅಂದ್ರೆ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಇರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ, ಅದಕ್ಕೆ ಕೆಳಗಿನ ಕೋರ್ಟ್ ನಾವು ಮೀಟ್ ಮಾಡಿ ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ. For the first time that is being taken up. The written statement.
Only then. Top 35 on the injury
statement as further contended, maybe in certificate another injured Lokesh sustained injury due to self-harm. Government made its complaint clearly established and missing one. It is a tractor. And this is the point, they have taken convention. GD capacity, only one. The segment they discussed it in diagram number 5. As per the increased rate in the wood certificate, another injured, local shall sustain injuries due to self-harm. The government's made in the complaint clearly established that the ECD was sitting in the tractor and the seating capacity is only one. Accordingly, claim within itself is not maintainable. In what way we have taken this line? PMD put up injury certificate of the other claimant. Sorry, correct. Then put. First time during cross-examination of RW1, he have taken a contention that he was sitting in tractor and trailer. Till then, all along, it is the contention that he was sitting in the tractor only. It is alleged the driver of the tractor suddenly taken a turn as a result the deceased as well as the fell from the tractor and suffered injuries. It alleged that the driver of the tractor suddenly taken a turn. As a result, the deceased as well as Lokesh fell from the tractor and suffered injuries.
Suffered injury while the deceased succumbed and Lokesh suffered injuries. The main contention raised by the learned counsel for appellant insurance company is that tractor is meant for carrying only one person and the all the records clearly disclose that deceased was traveling along with Lokesh in the tractor, which is not permissible, and hence there is clear breach of policy conditions, and as such, the liability is disputed. On the contrary, the learned counsel for appellant submit that no such defense is taken in the appeal memo, but however, the written statement filed by respondent number 2 insurer in para number 3 clearly disclose that such a defense is raised before the trial court, and trial court has also discussed this aspect. Next, in this regard, the learned counsel for appellant insurance company has placed reliance on a full bench edition of this court. Reported in 2021 ACJ 2588. Wherein the Honorable Apex Court on the full bench had an occasion to discuss, to deal with the matter regarding person traveling in a tractor, and held that by virtue of Regulation 28 of Motor Vehicles Act and rules of Road Regulation 1989, the driver of the tractor is not permitted to carry or allow any person to be carried on the tractor, including the mudguard. It is further held that if a person traveling in the tractor can be construed as an authorized passenger and his risk cannot be considered as an authorized passenger and his risk is not covered by the policy as contemplated under section 147 subclause 1 of any act. It is, he said, aspect came to be was discussed in para number 21, 22, 23 and 33 of the judgment. Under these circumstances, in the instant case, there is no serious dispute of the fact that deceased was traveling in the tractor. All the police records, including the evidence, clearly disclose that the deceased was traveling in the tractor. Apart from that, along with deceased and a driver, one more person is traveling. One more person by name Lokesh was also traveling in the tractor. which is clear breach of policy conditions and regulation 28, and as such, in view of the decision cited supra, the insurance company is not liable to indemnify the claim of the claimant on behalf of the owner of the tractor. Hence, the tribunal has erred in fastening the liability on the respondent insurer. However, the liability is required to be fastened on the respondent number one owner alone, and he is required to pay the entire compensation to the claimant on account of death of the deceased. As regards quantum is concerned, the tribunal has taken the income of the deceased at 8,000. Admittedly, the accident has occurred in the year 2018. This court is consistently taking the income at 12,500 in respect of accidents occurred in the year 2018. Hence, tribunal has erred in taking the income on lower side. Since the deceased was aged about 26 years and bachelor, 50% is required to be deducted towards personal expenses. Hence, he would have contributed 6,250 towards his family. Considering the age of the deceased as 26 years, 40% of the future prospects are required to be added. If 40% of future prospect is added, his monthly notional income would be 6,250, 40% is to the 6,250 40% ಎಷ್ಟಾಗುತ್ತೆ ಇಲ್ಲ 12,500 40% ಮಾಡಿ ಮತ್ತೆ 6 ಎರಡು ಒಂದೇ ಅಷ್ಟೇ 2,500 income would be 8,750 per month. Considering the age of the deceased, multiplier 17 is applicable, and loss of the hence compensation under the loss of dependency would work out at 8,750 into 12 into 17. Lakhs 85,000. Further, claimant is the mother and she is entitled for consortium to the tune of rupees 44,000 as per the decision reported in 2022. Further, she is also entitled for 16,500 under the head of loss of estate and 15,000 under the head of individual expenses. As such, claimant would be entitled for total compensation under various heads as an as such, claimant would be entitled for total compensation of rupees 1 so as against 11,87,400 awarded by the tribunal. However, as observed above, the respondent number one owner is required to pay the entire compensation, and the appellant insurance company is exonerated from paying any compensation. As such, both the appeal filed by the insurance company as well as cross objections required to be allowed in part, and accordingly, I proceed to pass the MFA CROB MFA 8261 of 2019 is allowed. The liability fastened on insurance company, that is appellant respondent number 2, is set aside and the entire liability is fastened on respondent number 1, owner of the vehicle. MFA crop so and so is allowed in part. The claimant is held entitled for total compensation of rupees so and so as against 11 lakhs so and so awarded by the tribunal. The enhanced compensation of rupees so and so shall carry interest at the rate of 6% per annum from the date of petition till the realization. The entire compensation, including the enhanced compensation, shall be paid by respondent number 1 alone. The respondent number 1 owner is directed to deposit the entire compensation with accrued interest within a period of 6 weeks from the date of receipt of the certified copy of the order. The statutory deposit made by the statutory deposit as well as the amount deposited by the insurance company in MFA 8261 of 2019 shall be refunded to the company. The other side. Serial number 31. ಶಾಸ್ತ್ರಿಗಳು ಏನಿಲ್ಲ ಅದ್ರಾಗ ಬ್ಯಾಚುಲರ್ ಅದಾನೆ 5,000 ತಗೊಂಡಿದ್ದಾರೆ 12,500 ತಗೊಂಡು 40% ಆಡ್ ಮಾಡಿ ಕೊಟ್ಬಿಡಿ ಸಾಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ. Liability is not disputed. Insurance company has not challenged it. Liability is undisputed. The income 5,000 ತಗೊಂಡಿದ್ದಾರೆ. It should be 12,500 as the accident has occurred in the year 2018. ಅಷ್ಟೇ ಅಲ್ಲ, ನಿಮ್ದೇನು ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ? ನೀವು ಇರ್ಲಿಲ್ಲ ಅದಕ್ಕೆ ಅವ್ರು ಅಂದ್ರು ಇಷ್ಟೇ ಸರ್ ನಂದು ಆರ್ಗ್ಯುಮೆಂಟ್, ಹೆಚ್ಚಿಗೆ ಏನಿಲ್ಲ ಅಂತ ಹೇಳಿ ಹೋದ್ರು ಅವರು. ಬಟ್ ನಿಮ್ನ ಒಂದ್ ಮಾತು ಕೇಳಿ ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ ಅಂತ ಹೇಳಿ ನಾನು ಜಸ್ಟ್ plus 40%. 1/3 is to be deducted. 17 multiplier. What is the age? ಅದನ್ನೆಲ್ಲ ಸರಿ ತಗೊಂಡಿದ್ದಾರೆ if I'm correct. ಮಲ್ಟಿಪ್ಲೈಯರ್ ಸರಿ ತಗೊಂಡಿದ್ದಾರೆ ಅವರು if I'm correct. ಏನಿದೆ ಲಾಸ್ ಆಫ್ ಡ್ಯಾಮೇಜ್ ಟು ವೆಹಿಕಲ್ ಆಡ್ ಮಾಡಿದ್ರೆ ಏನೇನು ಅರ್ಥ? ಹಾ, ಡ್ಯಾಮೇಜ್ಗೂ ವೆಹಿಕಲ್ ಡ್ಯಾಮೇಜ್ ಆಗಿದೆ. ಅಲ್ಲ ಅದನ್ನ ರಿಟರ್ನ್ ಮಾಡೋದು ದೇರ್ ಇಸ್ ನೋ ಇಶ್ಯೂ. ಇದೆ ಅವ್ರೇನು ಅದನ್ನ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿಲ್ಲ. ಬಟ್ ದಟ್ ವಾಸ್ ನಾಟ್, ಅದು ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡಿದ್ರು. $5,078 under the head of damage to the vehicle ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಆದ್ರೆ ಟ್ರಾನ್ಸ್ಪೋರ್ಟೇಶನ್ ಏನ್ ಪ್ರಾಪರ್ ಹೆಡ್ ಕೆಳಗೆ ಕೊಟ್ಟೇ ಇಲ್ಲ. ಲಾಸ್ ಆಫ್ ಡಿಪೆಂಡೆನ್ಸಿ 510, ಟ್ರಾನ್ಸ್ಪೋರ್ಟೇಶನ್ ಫ್ಯೂನರಲ್ obscene ceremonies 25,000 plus 5,078 vehicle repairs close. This is a death case. Brother party early, he may not be he may be dependent, but dependency doesn't change. 2/3 and change agudilla, 1/3 adu agutte. Other same ulitada. Second thing is consortium on shigalla. Consortium on gen shigalla. ಎನಾನ್ಸ್ ಕಾಂಪೆನ್ಸೇಷನ್ 6% ಕೊಡ್ತೀವಿ ಅಷ್ಟೇ. ನಿಮ್ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ, 9% ಕೊಟ್ಟಿದ್ದಾರೆ ಟ್ರಿಬ್ಯುನಲ್ ದಲ್ಲಿ.
Because that amount
ವೆರಿ ಮೀಗರ್.
should unnecessarily take a risk about it.
This appeal is filed by the claimants challenging the judgment and award in admission number 753 of 2018. Dated
Not money. That. The respondent jagged in today, the second respondent is paid 6%. With the application below. Page number 18 of the.
Correct. That was your this contention, it appears.
The respondent are jointly and thoroughly liable to pay compensation. Second respondent directed to pay interest at 6% per annum. The rate of the year is paid to the sub income. That is cannot be restricted.
Correct. 2 ತಿಂಗಳು ಕೊಡ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಹೈಯರ್ ರೇಟ್ ಆಫ್ ಇಂಟ್ರೆಸ್ಟ್. We are not concerned. But now I am concerned with anyhow ನೀವೇನು ಹೇಳಿಲ್ಲ, but we are concerned with interest on enhanced compensation. Challenging the judgment and award passed. Admission number 753 of 18 dated 18th February 2019 on the file of senior civil judge and MACT Arkalpur. For the sake of convenience, parties herein are referred to the original grants certified by them before the tribunal. The brief factual matrix leading to the case that this is Jagadish is the son of claimants appellants 1 and 2 and brother of claimant number 3. That on 11/3/2018, he and his mother, that is second claimant, came to Arkalgud in connection with the work and were returning to Kabbaligere village in a two-wheeler bearing registration KA13EB 5855. That the second claimant was the pillion rider and deceased wearing helmet and was riding the bike on the left side of the road following rules and regulations. At about 6 p.m. near the land of Chennaiya of Ramenhalli village on Arkalgud Konanur road, the driver of Mini Ashoka Leland bearing registration KA13C 2392 drove it in a rash and negligent manner and dashed against the bike of the deceased, resulting in the accident. Deceased suffered fatal injuries and he was shifted to government hospital Arkalgud, and after providing first aid, he was shifted to Jnanapriya Hospital Hassan, but he did not respond and succumbed to the injuries in the hospital on the same day at 7:30 p.m. The claimants claiming to be the dependents filed claim petition under section 166 of NU Act, claiming compensation of rupees 22,15,000 with interest at the rate of 9%. The respondents contested the matter by resisting the petition by filing objection statement and disputed actionable negligence on the part of the driver of the offending lorry. The respondent number 2 insurer has also taken all the statutory defenses raised and sought for dismissal of the claim petition. The tribunal, after appreciating the oral as well as documentary evidence, has awarded a total compensation of rupees 5,40,078 rupees under following heads on head circuit. Being dissatisfied with the award of the compensation, the claimant is before this court. The claimants are before this court seeking enhancement. Heard the learned counsel for appellant and learned counsel for respondent insurer. There is the records. the learned counsel for appellant would contend that the tribunal has taken the income of the deceased on lower side. He would contend that the extent has occurred in the year 2018 and the tribunal has taken the income at 5,000 and it ought to have taken the income at 12,500. He would further contend that the tribunal is 40% of future prospects are required to be added and hence he would seek for enhancement. Per contra, the learned counsel for insurer would support the judgment and award passed by the tribunal. Having heard the arguments and after perusing the records, it is evident that the deceased succumbed because of the injuries sustained in the road traffic accident dated 11/3/2018. The tribunal has held that the accident in question is because of actionable negligence on the part of the driver of the offending lorry, and this finding is not at all challenged. Further, there is no dispute regarding the coverage of the insurance policy. The tribunal has taken the income of the deceased at 5,000 per month. But admittedly, the extent has occurred in the year 2018. What is the age of the deceased? 27 years. The deceased was aged about 27 years as on the date of the accident. This court is consistently taking the notional income at 12,500 in respect of the accidents occurred in the year 2018. Hence, without there being any basis, the tribunal has taken the income at 5,000 on low, which is on lower side. Considering the age of the deceased, 40% of future prospects are required to be added towards his income, and if his income is taken as 12,500 and 40% of the future prospects are added, his monthly income would work out at next 20,100, 17,100, 500, 17,500. Okay. Since the deceased was a bachelor, 50% is required to be deducted towards personal expenses. Hence, considering his age as 27 years, multiplier 17 is applicable. Hence, under the head of loss of dependency, the claimant should be entitled for 17,500 into 12 into 17 into half. $17,85,000 as against 5,10,000 awarded by the tribunal. Next. Further, the claimants 1 and 2, being the parents, are entitled for consortium at the rate of 44,000 each, and hence they are entitled for 88,000. Under the head of loss of estate, the claimants would be entitled for 16,500, and under funeral expenses, they are entitled for 15,000. The tribunal has also considered the bike repair charges to the extent of 5,078, and the same is, and the claimants are entitled for the same. Hence, claimants would be entitled for total compensation under various sets as under 17 lakhs. plus dependency, consortium 88, loss of estate 16,500, funeral expenses 15,000, bike repair charges 5,078.
Mm-hmm.
19 lakhs 572, 78. Hence claimant should be entitled for total 19 lakhs 9,578 as against 5 lakhs 40,078 awarded by the tribunal. Under these circumstances, appeal needs to be allowed in part and accordingly proceed to pass the following. The appeal is allowed in part. The claimant is held entitled for so and so. The judgment and award passed by the tribunal so and so stands modified. The claimants are held entitled to so and so compensation as against so and so awarded by them. The enhanced compensation of so and so shall carry interest at the rate of 6% per annum from the date of petition till the date of realization. The 2018. I don't think extended 2018. Possibility is very hard, that is not considered. And in one last sentence. The entire enhanced compensation with accrued interest shall be deposited by the respondent insurance company within 6 weeks from the date of receipt of the certificate copy of this judgment. Next, out of the compensation, the claimant and the appellant number 1, mother appellant number 2 is entitled for 75% and appellant number 1 is entitled for remaining 25%. The apportionment, deposit and disbursement shall be as per the terms of the order of the tribunal.
ಇವರಿಗೆ ಬಹಳ ನಂಬಿಕೆ ಇಟ್ಟಿದೆ. Indian jurisprudence would have any license. They have passed in what is duly license. What is effective living license?
I didn't follow.
This is the latest decision of the Supreme Court rendered 1.5 years back. The judgment forensic case to refer ಮಾಡಿ. They give a different version. The claim petition is filed by workman. ಬೇರೆ ತರ interpretation. Opposite side will have to be taken up on Monday.
ಅಲ್ಲ ನನಗೇನು ತೊಂದರೆ ಇಲ್ಲ. If you are enlightening the court on question of law, that is appreciable. Question of law idag we will have to consider it. When that Supreme Court has laid down a new law by the larger bench, it will have to be considered. How whether it is applicable, whether facts and circumstances are similar or not, we will consider it. But first that citation is to be placed on record. As per the request of the learned counsel for appellant, this is the matter on Monday. Yes. ಅದನ್ನ ನೋಡಿದ್ರಾ ನೀವು? ನಿನ್ನೆ ಹೇಳಿದ್ದೆ ಅಲ್ಲ. Ram Khiladi. Yes, Ram Khiladi.
Be a trader or a rider. Undisputedly, they hold that.
ಅಲ್ಲ ಅದಕ್ಕೆ ಹೇಳಿದ್ದೆ ರಾಮ್ ಖಿಲಾಡಿ 160, it is reference to 163A who was rider. It is in case of a rider. But the other side of submission at the bar is that is been distinguished in case of rider 163A. Ram Killard is not a good law. 163A petition is maintainable and bandide ant helidru. I do not know because I have not gone through that citation. No, Devon, go through it. Because we will also update ourselves. Huh?
Your Lordship, serial number 37 appear for the appellant, Your Lordship.
One ನಿಮಿಷ. ಏನು ಹೇಳಿದ್ರಿ?
Kindly, what is anyone to occur filed by Counsel G. Shankar? Kindly, name may be shown in Counsel
G. Shankar name ಇದೆ, ಶಂಕರ್. ಆಯ್ತು ಬಿಡಿ, NOC ಹಾಕ್ಲಿ, ಏನೇ ಹಾಕ್ಲಿ. ಶ್ವೇತಾ ಆನಂದ್ ಅಂಡ್ G. ಶಂಕರ್ ಗೌಡ ಅದ.
ನಾವು anyone to occur Shankar Gowda.
ಸರ್, ನೀವ್ ಯಾರು ಮೊದಲು ಹೇಳಿ? ಯು ಆರ್ ರಿಪ್ರೆಸೆಂಟಿಂಗ್ ಶಂಕರ್ ಗೌಡ. ಶಂಕರ್ ಗೌಡ ನಿಮ್ ಹೆಸರು ಇದೆ. ಈಗ ವೆದರ್ ಶ್ವೇತಾ ಆನಂದ್ is jointly filed or earlier advocate, so her name is to be deleted. Simple ಇಷ್ಟೇ ಹೇಳ್ರಿ. ಇಷ್ಟು ಕನ್ಫ್ಯೂಷನ್ ಯಾದಕ್ಕೆ ಮಾಡ್ಕೋತೀರಾ? The learned counsel for respondent submit that Sri G. Shankar Gowda has submitted NOC power and hence the name of for respondent and hence name of Shweta Anand requires to be deleted from the causate office to delete the name of Shweta Anand in view of the NOC Wakalat filed by the learned counsel Sri Shankar Gowda after verification. Aita, satisfied? Heli madam.
Your Lordship, I pay for the appellant. Appellant
Yes.
was working with the respondent, Your Lordship, and he suffered an employment injury during the course of the employment, Your Lordship. And his right eye vision was completely blocked, Your Lordship. And he took the treatment, and the person, doctor who has treated him, has given the certificate that he has got he is now a one-eyed person and 30% visibility in the other eye because of the tension on the left eye. And he approached the commissioner, Your Lordship, and the commissioner rejected the entire claim on the ground that the medical treatment and the expenses towards medical is borne by the respondent employer. Against that, I have filed the appeal, Your Lordship.
Hello, when the respondent employer has borne the entire medical expenses.
Yes, Your Lordship.
How you again entitled for the said medical expenses?
I'm not asking for the medical expenses. My
Okay.
claim
Now
is-
next question.
Yes, it is a
ಇವತ್ತು ಇನ್ನೊಂದು ಇಂಥದ issue ಬಂದಿದೆ.
schedule injury.
See, ಒಂದ್ ನಿಮಿಷ ಕೇಳ್ತೀನಿ. What was your age?
My age was 49 at the time of the injury, accident.
Yeah, at the time of the injury, you are aged about 49. What was your status in the?
I was a technical assistant with the respondent.
You are working as a technical assistant under respondent.
Yes, Your Lordship.
Have you removed from the service?
No, Your Lordship.
You continue. One ನಿಮಿಷ.
Yes, I am continued. Now
continue. One ನಿಮಿಷ. Have patience. You continued it to be in service because of this disability. Whether any benefits have been denied to you, such as increments, promotions.
No, Your Lordship, see, what has happened is I am not on that question.
I'm not concerned. One ನಿಮಿಷ ನಾನು ಕೇಳಿದ್ದು because the disability gain ಕೊಡೋದು, that is a different aspect.
Yes. I have continued and I have continued in a different post.
Different post. There is no reduction in the salary.
No reduction in the salary.
No loss of income.
No loss of income. Yes.
Only now issue is assessing the disability, which affects your earning capacity.
I'm not on that point, Your Lordship. My contention is it is a schedule injury and any expenses under section 4 of the Workman Compensation Act, Your Lordship, if any expenses or payment is made towards the medical expenses, that does not absolve the employer from the liability.
ಅಲ್ಲ liability absurd ನಾನು ಅದನ್ನೇ we are coming to
Yes.
our payment ಮಾಡಿದ್ದಾರೆ medical bills, that is absolutely
Yes,
correct.
yes,
They are
yes.
bound to reimbursement, they are not making any favor.
So,
I do endorse it. The
ಅಲ್ಲ
issue
ಈಗ
is only,
Yes.
can you claim compensation?
Yes.
If so, what
Yes.
would be the extent? That is the
Correct.
only issue, because
Exactly.
you continue to be in service.
Yes.
There is no denial of service, and however, the fact remains that you will have to carry that disability throughout your life, even after
Exactly. I'm much obliged, Your Lordship. That is correct, Your Lordship. Yes. Now, Schedule 1, Part 2, Your Lordship. Schedule 1, Part 2, serial number 25.
Yes. Whether
Yes,
you fall under section clause 25 or clause 26,
I fall under 25.
is there any disfigurement of the eyelids?
Loss of one eye. I have lost one eye.
See, go through
medical-
it.
Yes.
Loss of one eye without complication, the other being normal, 40%. Okay. But
Yes.
you cannot ignore 26. Loss of vision of one eye,
Yes.
loss of vision of one eye
Yes.
without complication, or disfigurement of eyeball, the other being normal.
Yes. My kindly say, Lordship, exhibit.
Whether it
R-
is a loss
R3.
of eye or a loss of vision of the eye,
One
there is
minute,
lot
one
of
minute.
difference.
Yes, Your Lordship, I understand. This doctor certificate is produced, annexure R3, Your Lordship. Yes. What he says, Your Lordship, Your Lordship, annexure R3, medical certificate, considering him as one
Annexure
eye.
R3 is the Karnataka ವೈದ್ಯಕೀಯ ಮೆಚ್ಚುಗಳ ನಮೂನೆ ಅರ್ಜಿ ಅಂತ ಹೇಳುತ್ತೆ.
ಅಲ್ಲ ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ 15/3/2016.
ನನಗ್ ಗೊತ್ತಿಲ್ಲ, ಎಕ್ಸಿಬಿಟ್ ಸರಿಯಾಗಿ ಹೇಳ್ರಿ. ಎಕ್ಸಿಬಿಟ್ R1 R2
P3.
ನೀವು R3 ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಿ ಮೇಡಮ್.
Sorry, Your Lordship, P3. I'm
ನೀವು
sorry.
R3 ಅಂತ ಹೇಳಿದ್ರೆ ನಾವು R3
ಅಲ್ಲ R3 ಇದು ಅಲ್ಲ P3. I'm sorry, Your Lordship. P3 is the disability certificate.
This certificate doesn't give a true exact whether it is loss of vision or loss of eye. I am asking you whether you fall under 25 or 26.
Your Lordship, may I read the PW2 doctor's evidence in cross-examination, Your Lordship?
PW2 na?
PW2, Your Lordship. Dr. Veerabhadra Ravanta, PW2.
Yes.
And second page ನಲ್ಲಿ ಇದೆ ಪಾಟಿ ಸವಾಲು. ನಾನು ಕಣ್ಣಿನ ತಜ್ಞರಾಗಿ 16ರಿಂದ 17 ವರ್ಷದಿಂದ ಈ ವೃತ್ತಿ ಮಾಡುತ್ತಿದ್ದೇನೆ. ನಾನು ಹಿಂದಿನ SS ಹೈಟೆಕ್ ಆಸ್ಪತ್ರೆ ದಾವಣಗೆರೆ ಮತ್ತು ಮಣಿಪಾಲ್ ಕಸ್ತೂರ್ಬಾ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ನೋಡಿರುತ್ತೇನೆ. 7/11/12 ಅರ್ಜಿದಾರ ನನ್ನ ಹತ್ತಿರ ಬಂದಾಗ ಹಿಂದಿನ ಆಸ್ಪತ್ರೆಗಳಲ್ಲಿ ನಡೆದ ಚಿಕಿತ್ಸೆ ಫಲಕಾರಿಯಾಗದೆ ಇದ್ದಿದ್ದರಿಂದ ನಾನು ಮುಂದಿನ ಚಿಕಿತ್ಸೆಯನ್ನು ಮಾಡಿರುತ್ತೇನೆ. ಅರ್ಜಿದಾರರು ಮುಂದುವರೆದ ಚಿಕಿತ್ಸೆಯನ್ನು ಸರಿಯಾಗಿ ಪಡೆದಿದ್ದರಿಂದ ಈ ನ್ಯೂನತೆ ಆಗಿದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಪುನಃ ಇವರಿಗೆ ಬಲಗಣ್ಣಿಗೆ ಯಾವುದೇ ಶಸ್ತ್ರಚಿಕಿತ್ಸೆಯಿಂದ ದೃಷ್ಟಿ ಬರುವ ಸಾಧ್ಯತೆ ಇದೆಯಾ ಎಂದರೆ ಯಾವುದೇ ರೀತಿಯಿಂದಲೂ ಅರ್ಜಿದಾರರಿಗೆ ಬಲಗಣ್ಣಿನ ದೃಷ್ಟಿ ಬರುವ ಸಾಧ್ಯತೆ ಇರುವುದಿಲ್ಲ. ಅರ್ಜಿದಾರರು ಇದೇ ವೃತ್ತಿಯಲ್ಲಿ ಮುಂದುವರಿಯಬಹುದಾದರೆ ಮುಂದೆ ಖಂಡಿತ ಇಂತಹ ಅಪಘಾತ ಮರುಕಳಿಸಬಹುದು. ಆದ್ದರಿಂದ ಎಡಗಣ್ಣು ನ್ಯೂನತೆ ಇರುವ ಸಾಧ್ಯತೆ ಇರುತ್ತದೆ. 30% ನ್ಯೂನಪತ್ರ ನೀಡುತ್ತೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ.
So one thing is certain, it is not loss of eye, it is loss of vision. If loss of vision, you fall under 26.
Please, your lordship, that would be considered. Yes, sir.
Yes. Any other thing? So you want that 30% disability,
yes,
and multiplied by the relevant factor. You want to multiply with relevant factor.
Yes.
Looking to his age.
Yes.
And that compensation should be awarded irrespective of the fact of
Yes,
he
sir.
continuing in the office.
Yes, sir.
Yes, madam. Very interesting. ಈಗಾಗಲೇ ಒಂದು issue ಇದೆ ನನ್ನ ಮುಂದೆ. This is the second case of the same time. Suffering injury in a KSRTC or BMTC, continuing in service, but filing claim petition. ನೀವೇನ್ ಹೇಳ್ತೀರಾ? ಅವರೇ ಹೇಳಿದಾರಲ್ರಿ, ಕೆಲಸ ಕಂಟಿನ್ಯೂ ಆಗಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ. ಅವ್ರದ್ದಾದ್ಮೇಲೆ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿಲ್ಲ. ಬಟ್ ಕೆಲಸದ ಟೈಮ್ದಾಗ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದೆ, ಅವನ್ ಕಣ್ಣು ಹೋಗಿದೆ, ಅವ್ರು ರಿಟೈರ್ ಆದ ಕೂಡಲೇ ಕಣ್ಣು ತಿರುಗಿ ಬರುತ್ತಾ? ನಿಮ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಅವ್ರು ರಿಟೈರ್ ಆದ ತಕ್ಷಣ ಕಣ್ಣು ವಾಪಸ್ ಬರುತ್ತಾ? He has to suffer that disability throughout his life, alva. Throughout his life, he has to suffer this disability. The income is no way concerned, madam. I'm asking you, he has lost an eye. Vision of the one eye has gone because of the accident occurred during workplace. Correct? ಒಂದು ಕಣ್ಣು ಹೋಯ್ತು, ಅವ್ನ್ ಬೇರೆ ಕೆಲಸ ಕೊಟ್ರಿ, ಕೆಲಸ ಮಾಡ್ಕೊಂಡು ಹೋದ, ಆಯ್ತು. ಅವ್ನ್ ಸಂಬಳ ಕೊಡ್ಕೋತ ಹೋದ್ರಿ, ಅವ್ನ್ ಕಣ್ಣು ತಿರುಗಿ ಕೊಡಕ್ ಆಗತ್ತಾ? ಅವ್ನು ರಿಟೈರ್ ಆಗೋ ಟೈಮ್ ಅವ್ನ್ ಕಣ್ಣು ತಿರುಗಿ ಕೊಟ್ಟು ಕಳಿಸ್ತೀರಾ? Whether he will get back his eye at the time of retirement. ಅರ್ಥ ಆಯ್ತಾ ಮೇಡಮ್? ನಾನು ಕೇಳಿದ ಪ್ರಶ್ನೆಗಳ ಅರ್ಥ ಆಗ್ತಾ ಇದೆ ಅಲ್ರಿ? ಅದು ಇನ್ನೊಂದು ಮಂಡೇ ಇಟ್ಟಿವಲ್ಲ, ಇನ್ನೊಂದು ಇದೆ ಕೇಸ್ ಅಡ್ಸಿದ್ದು, ಮಂಡೇ ಇಟ್ಟಿದ್ದೀವಲ್ಲ. ಮೇಡಮ್ ಮಂಡೇ ಇಟ್ಟಿರ್ತೀನಿ, because one more matter in the same line is there. I can dispose of this in along with the both the matters.
Much obliged.
Monday next week agalva? Monday ee week agatta? Monday will be next week.
Much obliged.
It is only a question of law, that is a common law is required to be applied. Common law.
I appear for the appellant, serial number 39, my lord.
Yes, sir.
I request for short accommodation.
At the request of the learned counsel for appellant.
My lord, appearing for R4, serial number 39.
Learned counsel for R4 present at the request of the learned. You are not filed power, sir. The request of learned counsel for appellant, least after 2 weeks.
Obliged.
Obliged.
Satish Kumar. Forty. 39 or 10 time ತಗೊಂಡಿದ್ದಾರೆ 2 weeks.
From last hearing, but the direction you need petitioner to produce season hazard as well as this.
To correction, my lord. That direction, my lord kindly go to the other thing, that is dispensation.
ಅಲ್ಲ ಡಿಸ್ಪೆನ್ಸ್ ಹೆಂಗ್ ಮಾಡಕ್ ಆಗತ್ರಿ?
Subject to correction ಅಂತ ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು.
ಅಲ್ಲ ನಿಮ್ ಮೆಮೊ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿದ್ದಾರೆ. But the question is, you have asserted that it is lost in the file.
Certified copy
ಸೀಸರ್ ಮಾಜರ್ ಮಾಡಿಲ್ಲ ಅಲ್ಲ, ಇದು ಸೀನ್ ಆಫ್ ಅಫೆನ್ಸ್ ಮಾಜರ್ ಇದ್ದೇ ಇರುತ್ತೆ.
Vehicle was not seized, IMU was not done.
Vehicle was not seized. ಅಲ್ಲ ವೆಹಿಕಲ್ ಸ್ಪಾಟ್ ಮಾಜರ್ ಇದ್ದೇ ಇರ್ತದಲ್ಲ.
Seizure matter, delaying complaint 3 days delayed.
ಸೀಸರ್ ಮಹಜರ್
ಅಂತ ಇವರು
ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಆಗಿದೆ.
ಬಟ್ 24/1/20 ಅವ್ರು ಮೆಮೊ ಹಾಕಿದಾರೆ. ಮೆಮೊ ಇಸ್ ಅಕ್ಸೆಪ್ಟೆಡ್. ಕರೆಕ್ಟ್. ಅವ್ರು ಇರ್ಲೇ ಅಲ್ಲಿ ಹಿಂದೆ ಇದ್ದ ಇವ್ರವ್ರು ಎಲ್ಲಿಂದ ತರ ಅವರು
ಇಟ್ ಇಸ್ ನಾಟ್ ಪ್ರಿಪೇರ್ಡ್.
ಅಲ್ಲ ಕರೆಕ್ಟ್. he cannot produce, Allah, he cannot produce what is not there. If it is there and if it is not produced, things are different. Allah address ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಅವನ್ ಮೆರಿಟ್ಸ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅವರು. ಅಲ್ಲಲ್ಲ, he is submitting that he would address the arguments on merits.
Case of the petitioner,
the insurance appeal idu
19/8/2011 about 12:15 he was proceeding in his motorcycle in order to go to his workplace. That point of time, not because his case, Maruti car A02 HL 3837 moved its driver in a rational manner, dashed against it. Because of that reason, he has sustained some injury. Therefore, he has failed in kind of but yes, the complainant, injured person has not the complaint on 22/8/2023. 11. After lapse of 3 days after the accident, and he has given some reasoning why the delay was. He said that he was admitted in the hospital. Therefore, I am not allowed to come. But the cross-examination of the one. Peculiar case. He said that after the accident, he lost the conscience. He does not know the number of in the cross-examination. You will also find the TW1 cross-examination dated 5/3/2013.
Yes.
Another DL, the mother DL in there, other person is Manila. I am not studied. Studied India only DL it's not forthcoming. Because he was driving the vehicle at that point. That after the accident, I lost the conscious. I was not observed whether the car was stopped at the base or not. Soon after the accident, I felt unconscious. And I am not aware of what happened thereafter and which vehicle caused the accident. Subsequently, ಆಮೇಲೆ ಅದನ್ನ ಅವರು ಕರೆಕ್ಷನ್ ಮಾಡ್ತಾರೆ. Now,
ನೀವು ಒಂದು ಸಜೆಷನ್ ಮಾಡಿದ್ರಿ ಮುಂದೆ ಒಂದು ಸಜೆಷನ್ ಮಾಡಿದ್ರಿ ಅಲ್ಲ ನೀವೇ ಸಜೆಷನ್ ಮಾಡಿದ್ರಿ ನಿಮ್ಗೆ ಯಾಕೆ ಬೇಕಾಗಿತ್ತು
ಅದು ಇಮಿಡಿಯೇಟ್ಲಿ ನಮ್ಮ ಕ್ವಶನ್ ಆನ್ಸರ್ ಮಾಡಾದ್ಮೇಲೆ ವಾಲಂಟ್ರಿ ಈ ಸೇ ಸಮಥಿಂಗ್ ದಟ್ ಇಸ್ ದ ರೀಸನ್ ದಟ್ ಕ್ವಶನ್ ವಾಸ್
ಅಲ್ಲ ಪ್ರೈಸ್ ಮಾಡ್ಲಿ ಇಟ್ ಇಸ್ ಟ್ರೂ ದಟ್ ದಿ ಆಫ್ಟರ್ ಆಕ್ಸಿಡೆಂಟ್ ಸ್ವಿಫ್ಟ್ ಕಾರ್ ವೆಂಟ್ ಅವೇ ವಿದೌಟ್ ಸ್ಟಾಪಿಂಗ್ ದಿ ವೆಹಿಕಲ್ ಅಟ್ ದಿ ಸ್ಪಾಟ್
accident to hingaಯ್ತು ಹೀಗಾಗಿ there are two questions. He says that he is an unconscious at that point of time. He himself does not be complained. He says that I don't know which vehicle or the vehicle number of that car. Still after the discharge, he has not become. What is the basis? No police document was placed before the court. ಈಗ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಏನಾದರೂ ಇದೆಯಾ ಅಂತ ವೆರಿಫೈಡ್ ದಟ್ ಅದರಲ್ಲಿ ಅನ್ಕಾನ್ಸಿಯಸ್ ಬಗ್ಗೆ ಏನು ರೆಫರೆನ್ಸ್ ಇಲ್ಲ. ಇವಾಗಿರೋ ಇಂಜುರಿಗಳು ಸಿಂಪಲ್ ಇಂಜುರೀಸ್, ನಾಟ್ ದಿ ಫ್ರಾಕ್ಚರ್, ಮೆಟಕಾಲ್ ಫ್ರಾಕ್ಚರ್ ಬೇರೆ ಇದೆ. ಅದರ್ವೈಸ್ ಲೈಕ್ ಡಿಸ್ಚಾರ್ಜ್ ಆಗೋದು 20ನೇ ತಾರೀಕು ಡಿಸ್ಚಾರ್ಜ್ ಆಗ್ತಾರೆ. 20ನೇ ತಾರೀಕು 3:15 he has not been complained with the police. Discharge ಅವತ್ತೆ discharge time ಇದೆ. Complaint was on 22/8/2011 3:30 hour. And ಪಂಚನಾಮನ ಗುರುವರೆಗೆ ಅವ್ರು ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಾರೆ, 4:00 ಆ ಪಂಚನಾಮ ನಮ್ಮ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎಷ್ಟು ಫಾಸ್ಟ್ ಇದ್ದೀವಿ. Your lordship kindly see. No explanation was given or after payment. Who has given the number? How this was traced? Anytime yes examine any alleged right witness. You know our head illa. Apart from this, my lord, ನಂದು ವೆಹಿಕಲ್ ಏನು ಇನ್ಶೂರ್ ಆಗಿರೋ ವೆಹಿಕಲ್ ಜಾಸ್ತಿ ಯಾರು ಐಡೆಂಟಿಫೈ ಮಾಡಿ ಸೀಸ್ ಮಾಡಿದ್ರು ವೆದರ್ ಇಟ್ ಇಸ್ ಸಬ್ಜೆಕ್ಟೆಡ್ ಟು IFP or not. These documents were not placed either in the document. Now, why it was not done, they have not examined the investigating officer. Scenario. But your lordship kindly see the IMA report on the injured person.
Exhibit ಹೇಳಿ.
Right side headlight. Right side plus dot. Now the last NBC sketch. One cannot imagine in these two documents whether such a status where the accident was to be taken. It is history of the complaint. I was going in a motorcycle. Some car was hit behind. That is the sketch also indicated. Damage ಮಾತ್ರ ಅವರು ಗಾಡಿ ಮುಂದ್ಗಡೆಯಿಂದ ಹಿಂದ್ಗಡೆಯಿಂದ ಹೊಡೆದ ಮುಂದ್ಗಡೆಗೂ ಆಗುತ್ತೆ. Under these circumstances, my respectful submission. It is a half of that. In order to get the compensation, our insurance vehicle accident.
ಆಕ್ಸಿಡೆಂಟ್ ಡೌಟ್ಫುಲ್ ಅಂತ ಹೇಳಲ್ಲ ಅವರು. ನೀವು ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿರಬಹುದು, ಯಾವ್ದೋ ಗಾಡಿ ಹೊಡೆದೋಗಿದೆ ನಿಮಗೆ, ಈ ಗಾಡಿ ಪ್ಲಾಂಟ್ ಮಾಡಿದೀನಿ ಅಂತ ಹೇಳಿ ಅಷ್ಟೇ ಕಂಟಿನ್ಯೂ. PW3 is an eyewitness. He is not cited as a chassis witness.
But I noted the first, second, third, fourth, fifth, sixth line. I noted down the register number of the said car. The said car was slowed down and thereafter led from the spot. I took the petitioner to nearby clinic. Petitioner is also plumber. I informed the Banaswadi police station to call by correcting the station number from Rangnath. This Rangnath is a charged witness. This Rangnath, we could not secure the presence of Rangnath. Admittedly, he kindly looked into the Questioning of the deposition of.
I am simply asking you, Ranganath were least interested. He has given a number of police station that is irrelevant. Who is an eyewitness becomes relevant.
Yes, my lord. I know the petitioner from 15 years. My lord, this is how the petitioner and another person was proceeding in one more. This witness along with Ranganath, who is a charge sheeted witness, for proceeding in another one. At that point of time, in order to attend the plumbing work in Niyarpuram, the accident occurred. This is the facts of the case. After treatment, when he came to the police station, police instructed him to go to the hospital. And later on, we will only come there and take the complaint. They did not come to the hospital. So, petitioner, after discharge from the hospital, he went to the hospital and lodged from police station and lodged the complaint. What is wrong in it? What is wrong in it? In support of my contention, my lord is well aware of the Supreme Court landmark judgment. AIR 2011 Supreme Court 2022. Ravi versus Proceedings. In that case, 3 months delay is unknown. And delay in lodging, even though there was a delay in lodging complaint for 3 months, after 3 months, the tribunal dismissed the case. But Supreme Court wrote that in that judgment, I want to draw the attention of the Honorable Court to file number 27. ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ ಏನು ಅಂದ್ರೆ ಯಾವುದೇ ಅಪಘಾತ ಆದಾಗ ಇದು ಫಸ್ಟ್ ಆಸ್ಪತ್ರೆಗೆ ಹೋದಷ್ಟು ಆಕ್ಸಿಡೆಂಟ್ ಆದ್ಮೇಲೆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಹೋಗಕ್ ಆಗಲ್ಲ ನಿಯರ್ delay in FIR is not at all a ground to dismiss the plaintiff petition. In support of my contention, I draw the attention of the Honorable Court to page number 6 of the judgment rendered by the tribunal. In that it has clearly stated that it should be noted that during cross-examination of PW1, it has been suggested as it is true that ships are dashed from the backside of my vehicle. And it is true that after the accident, went away without stopping the vehicle at all. But by putting these suggestions, the respondents have admitted the occurrence of the accident and involvement of Maruti Swift car. From the evidence of PW1 and PW3 appointment exhibit E4, it is clear that the accident was due to negligence of the driver of the Swift car. Therefore, the testimony of RW1 is not worthy of credence. My lord may kindly look into the para number 14. It is true that petitioner has not lodged the complaint and it is written by somebody and there is 3 days delay. But this delay has no impact on the state of the petitioner because immediately after the accident he was taken to the hospital due to the reason. That reason he may not have been in position to lodge the complaint immediately. It is B7 in the rule certificate. It shows that he suffered both simple and grievous injuries. PW2, the doctor has given evidence stating that he treated the petitioner and issued the wound certificate. This evidence also remained unshaken. The charge sheet is filed against the driver of the car. That itself is the prima facie evidence to believe the negligence is on the part of him. The driver of the car is not examined, nor the charge sheet is challenged. Considering all these aspects, I am of the opinion that the petitioner has proved that he has sustained injuries in the accident also due to the negligence act of the driver of the car. Hence, I want to one of the day. So, completely agree the judgment and award passed by the tribunal.
You are bound to agree. Otherwise, you are out of the court. Question, you cannot dispute it. Now one question. He has raised one issue. The Maruti Swift knocked your vehicle from backside. Damages were on the front side of the vehicle. No damages on the motorcycle on the rear end were noticed. How it is being explained?
That means they fell down from the motorcycle.
If they fell down, if a moving vehicle is hit by another moving vehicle, from rear end. There should be damage to the rear end. That was not noticed. Except that they fell, damage is caused. If they fell along with vehicle, scratch marks ought to have been there on the vehicle. Because it is a road, vehicle will fail, it will not hage bidalla, it will be dragged to some extent, and by rubbing with the ರಬ್ ಆಗಿರ್ತದೆ, ಘರ್ಷಣೆ ಆಗಿರ್ತದೆ. ಆ ಘರ್ಷಣೆಗೆ ಅದಕ್ಕೆ ಬಾಡಿಗೂ ಡ್ಯಾಮೇಜ್ ಆಗುತ್ತೆ, ಅದು ಮಲಗೆ ಹೋಗುತ್ತೆ, ಹಿಂಗ ಸ್ಟ್ರೇಟ್ ಹೋಗಲ್ಲ. ಅಲ್ಲ, ಅವನ್ ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಲ್ ಅಲಾಂಗ್ ಯು ಆರ್ ಅಸರ್ಟಿಂಗ್ ದಟ್ ಯು ಆರ್ ಅನ್ಕಾನ್ಶಿಯಸ್. When you are unconscious, your evidence regarding who has caused accident has no relevancy. What has immediately happened, you are unaware. Only then evidence remains is that of PW3.
He took the petitioner to the hospital. None of the attendants were easy. When his wife came to the hospital, he went to the work. See, my lord, because of lethargic approach of police authorities and RTO authorities, innocent victim of road accident. What prevent, my point is, as rightly pointed out by Honorable Judge of Tribunal, that why the charge sheet is not done.
Say law now settled. The insurance company need not challenge the charge sheet. That argument is not over.
Point number 1 appears before the tribunal and finding the detailed statement reading all the government petition.
But she did not. See, there lies the issue. There lies the issue. Filed objection, but did not contest the matter. What?
I request the honorable court to only don't have more work to argue about. Honorable court kindly confirm the judgment that exaggerated compensation is not awarded. Only 90,000 is awarded. It appears to be just and reasonable. I request the honorable court to dismiss the appeal. No reasonable ground made out to allow the
Second, the major only issue is he has suffered fifth metatarsal bone of right side. ಕಾಲಿಂದ ಒಂದು 5ನೇ ಬೆರಳಿಗೆ ಫ್ರಾಕ್ಚರ್ ಆಗಿದೆ. ಅವನು ಅನ್ಕಾನ್ಶಿಯಸ್ ಇದ್ದ. ಅಲ್ಲ, ಇದೆ ಮೈಕ್ ಕಂಟ್ಯೂಷನ್ಸ್ ಇದ್ರೆ ದೇ ವಿಲ್ ಬಿ ರೆಕಾರ್ಡೆಡ್ ಹಿಯರ್. ಕಂಟ್ಯೂಷನ್ಸ್, ಅಬ್ರೇಷನ್ಸ್ ಅವೆಲ್ಲ ಬರುತ್ತೆ, ಇಲ್ಲ ಅಂತ ಹೇಳಲ್ಲ ನಾನು. ಬಿಕಾಸ್ ಲ್ಯಾಸರೇಷನ್ ಆನ್ ದಿ ಬ್ಯಾಕ್ ಆಫ್ ದಿ ರೈಟ್ ಆಂಕಲ್ ಇದೆ, ಇಲ್ಲ ಅಂತ ಹೇಳಲ್ಲ. ಬ್ಯಾಕ್ ಆಂಕಲ್, ರೈಟ್ ಆಂಕಲ್ ಲ್ಯಾಸರೇಷನ್ ಇದೆ. ಕಂಟ್ಯೂಷನ್ ಆನ್ ರೈಟ್ ಫುಟ್ ಇದೆ, ಬಾಡಿ ಇಲ್ಲ. ತಲೆಗೇನೋ ಕ್ರೈ ಆಗಿಲ್ಲ. ಅನ್ಕಾನ್ಶಿಯಸ್ ಹೆಂಗ್ ಆಗ್ತೀರಾ?
ಬಿಕಾಸ್ ಆಫ್ ಪೈನ್, ಸಿವಿಯರ್ ಪೈನ್ ಇದ್ದಾಗ ಪೈನ್ ಆಗಲ್ಲ. ನಮಗೆ ಒಂದು
ಏನಾಗುತ್ತೆ ಅನ್ಕಾನ್ಶಿಯಸ್ ಆಗೋದು ನಾನು ಹೊಸದಾಗಿ ಕೇಳಿದ್ದೆ. 80-90 ಒಳಗ ನಿಮ್ನ ಹೊಡೆದಿದ್ರೆ ನೀವು ಜೀವಂತ ಉಳಿಬಾರ್ದು. You will be thrown somewhere else. See, practically we should think of.
ಇಲ್ಲ, ಒಂದು 50 ಬರ್ತೀನಿ, ಇಲ್ಲ ಒಂದು 40-50 ಬರ್ತಿದ್ರು ಪೈನ್ ಬಹಳ ಕಾಂಪ್ಲಿಕೇಟೆಡ್ ಆಗಿರುತ್ತೆ. ಹಿಂದಿನ ಕಾಲದಲ್ಲಿ ಆದ್ರೆ ಒಳ್ಳೆ ಶಕ್ತಿ, ಒಳ್ಳೆ ಊಟ ಮಾಡೋದು, ಒಳ್ಳೆ 90-100 ನಾಟ್. ಈಗಿನ ಕಾಲದ ಫುಡ್, ಈಗಿನ ಕಾಲದ
ನಮ್ಮ ಒಂದು ಕಂಟೆನ್ಷನ್ ಏನು ಅಂದ್ರೆ ಲೋಯರ್ ಕೋರ್ಟ್ ಮಾಡಿರೋದು ಕರೆಕ್ಟ್ ಆಗಿದೆ. ಕೈಂಡ್ಲಿ ಕನ್ಫರ್ಮ್ ದ ಜಡ್ಜ್ಮೆಂಟ್ ಪಾಸ್ ಬೈ ದ ಟ್ರಿಬ್ಯುನಲ್ ಅಷ್ಟೇ. ಫಸ್ಟ್ ರೌಂಡ್ ಅಲ್ಲಿ
35,000 ರೂಪಾಯಿ ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಒಂದು ಕಿರುಬಳೆ ಫ್ರಾಕ್ಚರ್ಗೆ
ಬಿಲ್ಸ್ ಇದೆ ಎಲ್ಲ
ಬಿಲ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ನಿಮ್ಗೆ ಬಿಲ್ಸ್ ಬಗ್ಗೆ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ ನಾನು. 2 days ಅದಕ್ಕೆ ಕೇಳ್ತಿದ್ದೀನಿ. ಕಿರುಬಳ ಕ್ರಶ್ ಇಂಜುರಿ ಅಲ್ಲ, ಮೆಟಟಾರ್ಸಲ್ ಫ್ರಾಕ್ಚರ್ ಇದೆ. ಕ್ರಶ್ ಇಂಜುರಿ ಇಸ್ ಡಿಫರೆಂಟ್, ಫ್ರಾಕ್ಚರ್ ಇಸ್ ಡಿಫರೆಂಟ್. ಅದಕ್ಕೆ 35,000 ರೂಪಾಯಿ ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗು, 25,000 ರೂಪಾಯಿ ಅಮ್ಯುನಿಟೀಸು, 60,000 ಒಂದು ಫ್ರಾಕ್ಚರ್ಗೆ. ಅದ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಿಸ್ 20,000 38 ಇದೆ, ಆನ್ ರೆಕಾರ್ಡ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ದಟ್ ಇಸ್ ರೈಟ್, ದೇರ್ ಇಸ್ ನೋ ಇಶ್ಯೂ ಅಬೌಟ್ ಇಟ್. ಬಟ್ ಡೋಂಟ್ ಯು ಥಿಂಕ್
ಕರೆಕ್ಟ್ ಆಗಿದೆ. ಇದನ್ನ ಯೂಸ್ ಮಾಡೋ ಒಂದು ಸಂದರ್ಭ ಏನು 90,000 ಏನು ಸಿಂಪಲ್ ಕೆಲವು ಇಂಜುರೀಸ್
ಸರ್ ಇದು ದಿಸ್ ಎಕ್ಸ್ಟೆಂಟ್ ಹ್ಯಾಸ್ ಅಕರ್ಡ್ ಇನ್ ದಿ ಇಯರ್. ಮತ್ತೆ ಅವಾಗಿಂದ ಮನಿ ವ್ಯಾಲ್ಯೂ ನೋಡ್ಬೇಕಾಗತ್ತೆ. ಅಲ್ಲ ಅವ್ರು ಏನ್ ಮಾಡ್ಲಿ, 35,000 ರೂಪಾಯಿ ಅವಾಗ. ದಟ್ ಈಸ್ ವೆರಿ ವೆರಿ ಹೈ.
ನೋಡ್ಕೊಂಡು ಹಾಕಿದ್ದಾರೆ. ಯಾಕೆ 2011 ಫೈಲ್ ಮಾಡಿದ್ವಿ, ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. ಯಾಕೆಂದ್ರೆ 2 days ಡಿಲೇ ಇತ್ತು ಅಂತ ಡಿಸ್ಮಿಸ್ ಮಾಡಬೇಕು ಕಂಪ್ಲೇಂಟ್. ಆಗ ಈ ಕೋರ್ಟ್ ನಾವು ಅಪೀಲ್ ಹಾಕೋದಕ್ಕೆ
ಏನೇ ಇರ್ಲಿ, ನಾ ಅದ್ರ ಬಗ್ಗೆ ಹೇಳಲ್ಲ. ನಿಮ್ದು ಟ್ರಯಲ್ ಯಾವಾಗ ಆಗುತ್ತೆ ಅವಾಗಿಂದ ವ್ಯಾಲ್ಯೂ ತಗೊಳಕ್ ಬರಲ್ಲ. ದಿ ವ್ಯಾಲ್ಯೂ ಶುಡ್ ಬಿ ಟೇಕನ್ ಆಸ್ ಆನ್ ದಿ ಡೇಟ್ ಆಫ್ ದಿ ಇನ್ಸಿಡೆಂಟ್ ಆರ್ ಆಕ್ಸಿಡೆಂಟ್. ಈಗ ಮನಿ ವ್ಯಾಲ್ಯೂ ಇನ್ಕಮ್ 10,000 ಇದೆ ಅಂತ ಹೇಳಿದ್ರೆ ತೊಗೊಳಕ್ ಆಗತ್ತೆ. ನಿಮ್ ಪ್ರಕಾರ ಈಗೆಲ್ಲ 2000 ನಾವು 22 ಒಳಗೆ ಹೇರ್ ಮಾಡ್ತಾ ಇದೀವಿ. ನ್ಯಾಷನಲ್ ಇನ್ಕಮ್ 2022 ತೊಗೊಳಕ್ ಆಗತ್ತಾ? Why we are taking the income as on the date of the accident? ಮತ್ತೆ ಇದನ್ನ ಹೆಂಗ ನೀವು? That is not botheration of the courts. ಅದನ್ನೆಲ್ಲ ಕೋರ್ಟ್ಗೆ ಹೇಳಕ್ ಹೋಗ್ಬೇಡಿ. ನೀವು ಅಪೀಲ್ ನಿಮ್ ವಿರುದ್ಧ ಆಯ್ತಾ, ನೀವು ಅಪೀಲ್ ಮಾಡಕ್ ಅಧಿಕಾರ ಇದೆ, ನಿಮ್ಗೆ ಮಾಡ್ಕೊಡ್ರಿ. ನಿಮ್ಮ ಪರವಾಗಿ ಆದ್ರೆ ಖುಷಿ ಪಡ್ರಿ, ಅದ್ರ ಬಗ್ಗೆ ನಾವೇನು ಹೇಳಲ್ಲ. ಆಯ್ತು, ನಿಮ್ ಇದ್ರ ಪ್ರಕಾರ ಅದಕ್ಕೆ ವಿಚಾರ ಮಾಡಿದೆ ನಾನು. ಆದ್ರೆ 35,000 ರೂಪಾಯಿ, 25,000, 60,000 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದು ಒಂದು ಕಿರುಬಳ್ಳ ಫ್ರಾಕ್ಚರ್ಗೆ 2011ರಲ್ಲಿ ಯಾವ ಡಾಕ್ಟರ್ ಕಿರುಬಳ್ಳ ಎವಿಡೆನ್ಸ್ಗೆ ಏನ್ ಡಿಸಬಿಲಿಟಿ ಕೊಡಕ್ ಸಾಧ್ಯ? ಫ್ರಾಕ್ಚರ್ ಆದವ್ರಿಗೆ ಎಲ್ಲರಿಗೂ ಓಡೋರ್ಲಿಕ್ಕೆ ಕಷ್ಟ ಆಗತ್ತ.
ರಿಕವರಿ ಆಗತ್ತಂತ ಸಮಸ್ಯೆ ಇಲ್ಲ. ನಾನು ಹೆಂಗ್ ಕನ್ವಿನ್ಸ್ ಮಾಡ್ಬೇಕು ಅಂತ ನಮ್ಗೆ ಗೊತ್ತಾಗ್ತದೆ.
ನಾನ್ ಹೇಳಕ್ ಆಗಲ್ಲ. ನಾ ಹೆಂಗ್ ಹೇಳಕ್ ಆಗತ್ತ? There are two aspects. One is under certain head excess ಕೊಟ್ಟಿದ್ದಾರೆ, and he has raised other issues. ಎರಡು ಕೋಆರ್ಡಿನೇಟ್ ಮಾಡಕ್ ಸಾಧ್ಯ ಇದೆನಾ ನೋಡ್ತಾ ಇದ್ದೀನಿ. ಅದಕ್ಕೆ ನಿಮಗೆ ಈ ಪ್ರಶ್ನೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು.
ಕನ್ಫರ್ಮ್ ದ ಜಡ್ಜ್ಮೆಂಟ್. ಇಂಟ್ರೆಸ್ಟ್ ಸ್ವಲ್ಪ 9% ಕೊಟ್ಟಿದ್ದಾರೆ, 6%.
ಅದಂತೂ ನೀವು ಕೇಳದೇ ಇದ್ರು 6% ಬಂದೇ ಬರುತ್ತೆ. ಅವ್ರ ಅಪೀಲ್ ಇದೆ, ಅವ್ರ ಅಪೀಲ್ ಇದೆ, 6% ಬಂದೇ ಬರುತ್ತೆ. You are, I should not use that word, to be frankly. Allah, it is directly you are attacking on his integrity. It amounts to attacking the integrity.
ಮಾತಾಡ್ತಾ ಇದ್ರೆ
Third. Monday dictating orders ಇಟ್ಕೊಂಡ್ಬಿಡಿ. ಅಲ್ಲ he should not feel offended. You both of you are directly it amounts to attacking his integrity. ತಪ್ಪಾಗುತ್ತೆ ಅಷ್ಟೇ. ನಂದೇನೆ ಪರ್ಸನಲ್ ಏನಿರಲ್ಲ, ಬಟ್ ಅವರು they are representing the company means that it cannot be taken in such a way. ಅಷ್ಟೇ. ಅದನ್ನು ಫೈಲ್ ಹೋಮ್ ಆಫೀಸ್ ಹಾಕ್ತೀನಿ. Sir, other side ಅವರು you are for appellant claimant. ಅವರು ಕಾಪಿನ ನಮಗೆ ಸರ್ವ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಅಲಿಗೇಷನ್ ಅವ್ರದ್ದು. ಅವರು ಬೆಳಿಗ್ಗೆ ಈಗ ಮಧ್ಯಾಹ್ನದಾಗ 1-2 ಫಸ್ಟ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದ ಅದೇ 42 ಒಳಗೆ ನಮ್ಗೆ 200 ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಸರ್ ಅಂತ ನೋಡ್ರಿ. The learned counsel for respondent submit that copy is not yet served on him. ಅವ್ರು ವಕಾಲತ್ ಹಾಕಿಲ್ಲ. ಕಾಪಿ ಬಂದ ಮೇಲೆ they will have to send it to the office and then they will receive the ವಕಾಲತ್. ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರ್ತೀನಿ. The learned counsel is directed to serve the copy of the appeal memo and other relevant documents on the learned counsel for respondent number 2. And you have not taken notice to R2 na? ಕೇಳಿದ ಮ್ಯಾಗ ಹೇಳ್ತೀರಾ I will file ಅಂತ ಹೇಳಿ. ಏನ್ರಿ steps taken, not taken, no order is passed for R2 ಅಂತ ಹೇಳಿ ಅದ್ ನೋಡಿದ್ಮೇಲೆ ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ I'll take ಅಂತ ಹೇಳ್ತೀರಿ. I'll file ನೀವು ಒಂದೇ ಮಾಡ್ಬೇಕು. The final hearing without completion of the process itself is wrong. How can it be posted for final hearing? Notice ಆಗಿಲ್ಲ, service is not completed, notice not ordered to R2, ಇವ್ರು dispensation ಹಾಕಿಲ್ಲ. ಈ ಕೋರ್ಟ್ನವ್ರು ಅದನ್ನ ಕೇಳಿದ್ರೆ ಇಲ್ಲ ನಾನು seek dispensation. ಏನ್ರಿ ನೋಡಿ ಅದನ್ನ ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ. Is the matter after 2 weeks. No representation on behalf of appellant, list after 2 weeks. ಯಾವ್ದು ಸೈಟೇಷನ್ ರೀ? ಆ ಕೇಸಿಗೆ ಅದೇ ಕೇಸ್ ಸಂಬಂಧಪಟ್ಟಿದ ಇದು? List next week as per request of the appellant.
But in this case, there is a delay of 9 days.
ಖಂಡನ ಆಗಿಲ್ಲ ಖಂಡನ ಆಗಿ ಇದು ಕಂಪ್ಲೇಂಟ್ ಡಿಲೇನಾ She has argued. She has argued.
By addressing the aspect, you see that because of
Illiteracy. He could not disclose the name of his father because of the shock and other things. That was the argument.
But the way in which the evidence was tendered by the witness. Does indicate a different fact. But they say that physical or यहाँ पे शक्ति वाला ये करेंगे क्या? अरे नन डाक्टर आते हैं तो नन इंता डाक्टर है ना अपने से लगा तब तो कि ना whether educated or uneducated आपका हम देला for your own knowledge education is required only for your ability not to identify the father and mother. Here is the case, my lord. He further admitted that another person and the Montiro approval indirect. Assuming the sake of argument, my lord, if it is accepted, the argument of then this petition has to be dismissed on that ground also. He does not know anything about it. The rate ಇರೋದೆಲ್ಲ ಸುಳ್ಳೆ ಆಗೋದು petition ಸುಳ್ಳೆ ಆಗಿದೆ. Therefore, my lord, considering the statement which was given, in support of that, my lord, the doctor has been examined. It was written without the evidence. Where we have stated that the person was injured person was conscious. He has given the statement. Otherwise, two-wheeler, four-wheeler, two-wheeler, ವ್ಯತ್ಯಾಸ ಇರಲ್ಲ. Two-wheeler only complaint and not four-wheeler. Whom certificate, the father name considering the whom certificate on the medical record as well as in the petition itself indicate that these are all the created story by the petitioner followed with the others in order to grab the public money. Therefore, they have lodged the complaint after some time. Will be compensation. Therefore, madam, considering that aspect, evidence on record, admitted fact by the petitioner, the court has come to conclusion, madam, that they have created the story, they are not two ways. Therefore, my respect submission, they will.
They are replying. There is submission made by the advocate for the respondent insurance company is that there is 9 days period. Here also the owner has been served and his representatives. They are not come before this court to oppose. But whereas in the trial court, they opposed my petition to convey saying that the vehicle was not. It is the case. The insurance company is own duty is based on the contract of indemnity. They indemnify after taking the amount, that is policy amount from the person who is the owner of the vehicle. And my learned friend is saying that it is public money. No public money is involved. It is the policy amount based on that policy.
Are you sure? Are you supported by your arguments that it is not a public money? It is a taxpayer's money.
I will make.
Policy holders are taxpayers.
I will make myself. Whether the submissions which I make.
See, that doesn't mean that I can accept all the submissions, I can allow it. No. If they are reasonable, if they are supported, we consider.
Taxpayers are income taxpayers to the Department of Income based on their income. Here, the public money is not involved. It is the money of the person who owns the vehicle, who have paid the money to the insurance company to indemnify them if there is an accident. If there is an accident, because it is based on the law of indemnity. It is not all the public whose money is involved. It is only the policy amount that involved. There are so many policies which will be given by the insurance company, and that amount they will utilize in giving it an accident and that is all. And I'm not very much interested in arguing about it because he said that it is public money. I wanted to. He was not in a position to identify the father and mother. This is what it is. At the time of accident, when he was taken to the hospital, he was not in a position to remember his father's name properly. He says at any time, the father's name will be told by any ordinary person properly. But who has informed him and who has, it is he who was accompanied by another friend by name Ramesh. It is accompanied by Ramesh. Usually, the person who accompanied the injured or the person who is wounded will give the details of those things. Except the injuries are where the pain is, will be told by the injured person. And even for the operation, they take the signature of the family member, not the injured person or the person who is undergoing the operation. Even in that, as your lordship can make out, that even in that, it is written as Kalegowda son of Kalegowda. Who has put the signature? His wife has put the agreement. It does not mean that the daughter-in-law did not know the name of her father-in-law. The daughter-in-law did not know the name of the father-in-law. Even there, it is named as Kalegowda son of Kalegowda. That itself shows that they have not explained all the relationship with the name mentioning a wrong name, Kalegowda son of Kalegowda, will not come. And with regard to 9 days delay in reporting the matter to the police, he was an inpatient in the hospital. They come to the hospital and take the report on the 9th day. He was hospitalized. Nobody can expect a person who is an inpatient to go and report to the police. The delay is not detrimental in this case as he was asked. And with regard to the involvement of the vehicle, the owner himself came on record and he has stated that my vehicle was not owned. My learned friend, being the insurer of that person, had to argue on that, but when he is represented by an advocate, even before your lordship, they remained absent so far.
You are making a wrong submission, not on records. He was here. He is not present at this juncture. He was there waiting since morning.
If that is the case, he has not.
Therefore, it is not open for you to argue in such a way. Because if that, one thing I'll tell you, if that is the case, if the case is called out, if you are not present, and if the other side is present, whether court can draw a presumption.
Not once, this is the second time it has
See,
come. Whatever-
that should not be the presumption, because courts are here not to draw a presumption on the basis of representation by the non-representation of the advocates. Simple.
That the only crux is that the owner has not denied the involvement in the appellate stage.
I didn't follow the very rules of appellate court when you argue in such a way. Do you mean to say that in the appellate court also, the owner should come and file an objection denying the involvement of the vehicle?
I never said
No,
so. I never said
then why you are arguing such a
They
way?
should come and at least
Dil-
say how, when I have made allegations, when there are scratch marks, then there is a dent, when an IMD report is there, when Mahas.
ನಿಮ್ದೊಂದೇ ಹೇಳಿ ಓನರ್ ಏನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು ನಿಮ್ದಲ್ಲ. ಅವನು ಇಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಲಿಲ್ಲ, ಅದಕ್ಕೆ ನಮ್ ಪರವಾಗಿ ಮಾಡ್ಬೇಕು ಅನ್ನೋದು, that is a wrong submission. I'm sorry to say that such a submission cannot be entertained, because court is not here to only because the other side doesn't appear on record.
ಏನು ಅಂದ್ರೆ ನಾನು ಹೇಳ್ತೀನಿ, ಒಂದ್ ಸಾರಿ ಒಂದ್ ಆಕ್ಸಿಡೆಂಟ್ ಆದಾಗ
Next, you can argue.
ಅದರಲ್ಲಿ
Next appoint ಬಿಟ್ಬಿಡಿ, next argument. ಅವ್ರು ಏನ್ ಮಾಡಿದಾರೆ ಬಿಟ್ಬಿಡಿ, ನಿಮ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬಿಡಿ, ನಿಮ್ದೆ ಅಷ್ಟೇ.
there is a dent, there is a scratch mark, and even at the time of seizure, and even at the time of the Mahajat, I am very good. Everything says that the vehicle was involved in an accident. When that is the case, it is the duty of the owner to discharge that it was not involved in an accident. So when that has not been brought up properly before the tribunal also, it has to be concluded that it was that vehicle which was involved in the accident, because it is not a old vehicle, it was a new vehicle without a number. If it were to be a old vehicle, then we could have said that it would have been happened sometime before, but it's a new vehicle. That's why I feel that the matter may kindly be allowed and it may kindly be remanded so that even the other witnesses required can be for assessment of the compensation, it may kindly be remanded to the tribunal.
Hold reserved. Yogesh Ajike. There is no representation on behalf of appellant, least after 2 weeks. ಅವ್ರು ಬರ್ಲಿಲ್ಲ, ನಾನೇನ್ ಮಾಡ್ಲಿ? ಅವ್ರು ಬರ್ಬೇಕು, ಅವ್ರು ಬರ್ದೇ ಇದ್ರೆ ನಾನು ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? Based on 26. ಈಗ ಅವ್ರು ಬಂದ್ರೆ ನಾನು ಏನ್ರ ಮಾಡ್ಬೋದು. On merits, in the absence of appellant, I cannot do it. That's all. That is the difficulty. Kalburgi kar. Vishal Pratap Singh from Kalburgi. There is no representation on behalf of the petitioner. Even at 2:30, there was no representation, and at 2:30, 4:45, 4:35 also, there was no representation. Hence, this is the matter next week. ಎಂಟು ಸಾವಿರ. You have accepted your fair submission that 8,000 ತಗೊಳ್ರಿ. Sorry sir, 8,000 ತಗೊಂಡಿದ್ದಾರೆ, ನಾನು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ ಹೇಳಿದಕ್ಕೆ ನಾನು ಅದನ್ನ ಮಾಡಿದ್ದೀನಿ. ಇಲ್ಲಂದ್ರೆ ಇನ್ನೂ ರೆಡ್ಯೂಸ್ ಆಗ್ಬೇಕಾಗಿತ್ತು. ಅದು ನೇಚರ್ ಆಫ್ ಇಂಜುರೀಸ್ ನೋಡಿದ್ರೆ ಬೇಡ ಇಲ್ಲ, ನಿಮ್ಗೆ ಯಾಕಂದ್ರೆ ಎಕ್ಸೆಸ್ ಆಗಿದೆ, ಅದಕ್ಕೆ ನಾನು ಕೆಲವೊಂದಷ್ಟೇ ಮಾಡಿದ್ದೀನಿ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್, ಬೇರೆ ಏನು ಮಾಡಕ್ ಹೋಗಿಲ್ಲ.